Hi guys! So I had a productive morning. I figure we can start on time anyway. So court just kicked off. It's about 2 minutes in. Make my screen bigger. And we'll get into it. This is going to be day 157 of the YSL trial with 2 defendants remaining. So hope everybody is doing well today. Let's see. I saw love, guys. I saw love is in the courtroom. So let's see if we get any mess. Let's see.
Good morning, everybody. Be seated.
Got a squeak?
Don't know if we have all the jurors or not. I haven't checked yet, but anything we need to put on the record before we get the jury out?
Your Honor, good morning.
Good morning.
My understanding is that Mr. Sumlin is on the state's agenda this morning at some point.
He's not coming today, Your Honor.
Okay.
Oh,
Is he coming at all?
Yes, he's coming with
Next week?
So, in preparation of him coming today, I reviewed his statement that he gave to Investigator Viverito and other law enforcement investigator J.P. Miller. And my understanding is the state is going to ask him questions based on things that he has personal knowledge of, and I understand that that's out there for potential impeachment. My concern, and I'm just making sure that we're all on the same page. Investigator Viverito asked him to speculate about a lot of things, why certain things would have happened. He makes it clear that he was locked up during the Donovan Thomas murder. He knows nothing about it. He also makes it clear that he does not know about the Shymel Drinks murder, and he's just, kind of speculating about why this would happen. There's a lot of talk. How much would Jeffrey have paid them? Why, the hypotheticals. Why would Shannon have done this? And the reality is, Mr. Sumlin has no firsthand knowledge of who did what. He's just kind of going off the cuff in this interview. I just want to make sure that we're all on the same page, that none of that is, nothing that he is speculating or just kind of hypothesizing about that he does not have firsthand knowledge of will be inquired about.
Good morning, Your Honor.
Morning.
We will be making inquiries into, we will be laying proper foundations, and we will be making inquiries into areas that we believe he has knowledge of. If we will not improperly ask a question that we've not laid a foundation for him having knowledge of. That's what we can say. I don't think it's proper for counsel for the defense to attempt to curtail our direct examination based on what he believes a witness has knowledge of.
Okay, well, I don't mean to curtail anything, but if the state brings out things that he does not have firsthand knowledge of and it's improper, I'm going to be moving for a mistrial with prejudice, and we all know that now.
Yeah, okay. So I would think that y'all, I don't know if I've got a copy of the interview or not, but y'all could get together and see if you all can agree on what's clearly not within his knowledge and what might be, and then we could potentially litigate that beforehand on Friday.
We could do that. We could,
You do have a copy of it, Your Honor. It's in that third witness.
Okay.
In his folder.
and Your Honor, we could definitely get together and talk about things that we believe or one party believes he does or does not have direct knowledge of. But again, given the way that the interviews have gone and the examinations have gone, I don't, again, think it's proper to prematurely try and curtail certain things. I believe
It
that
is absolutely proper to try to make an evidentiary determination beforehand on things that would be objectionable.
I don't disagree with what the court is saying. I'm saying that unless,
you do.
if we seek to, or we establish a foundation for his knowledge of certain things that the defense does not believe he has knowledge of, I believe that curtailing our ability to make that foundation would not.
I don't think that's what he's asking.
Well, if that's not what he's asking. Okay.
So those folders, they were in like buckets of 30. Which one am I supposed to be looking at? I thought we had litigated everything there was to litigate about
We did.
someone.
We keep going back to that day that we ran out of time, and I was litigating a lot that day, but there was a couple things left on the table, and we were going to get back to it, and then
Okay. Well, I guess
everything sped up, and
I guess that'll be Friday then. All right. Anything else?
none of this time.
Do you know whether we have all the jurors? Not, Not yet? Okay.
I didn't want to hold court up for the day, so I was going to bring it up at the end of the day, but if we're waiting on the jurors, I'll just raise it now. They're continuing to wake my client up at 5 a.m. in the morning. He's exhausted. He has trouble participating in his defense in that state. I would just, once again, I know you said something once, the election thankfully was over yesterday. So maybe if
I'm not
that,
sure what the election has to do.
well, I thought that was the
Traffic.
reason that the jail was short-staffed. But anyway,
Oh, okay, I got you.
if that's the reason they're waking up at 5 a.m., that's over. So if they could get back to what they were doing prior to
Look at
the
Schardt.
brief recess we had last
What
week.
time does he get to go to bed? I mean, he can go to bed early.
I don't know.
I'm not saying I want him to keep having to be woken up at 5, but I would suggest that maybe he try to get his sleep in as soon as he gets back after he has his evening meal.
I understand, but for some reason, since the pleading out of the other defendants, there's been some kind of shift. And if that shift isn't wholly necessary, it would be good if he could get the same amount of rest he was getting prior to that.
Okay, so who would be in charge of what time they are awakened in the mornings?
The lieutenant gets all the transfer. I'll speak with him again. I spoke with him on yesterday, but I'll speak with him again.
All right, I appreciate it. Thank you.
Thank you, Your Honor.
Sure.
All right, so if you just joined us in the last 30 seconds, love is already causing chaos.
Can I ask the state a
Oh,
question?
man.
Is, when we get around to the jury charges, I know, well, I don't know, but I think that early on in this case, John Floyd was involved. Is he still going to be available? Because certainly he's
I'd
got
rather
some
have him in
knowledge of
love.
RICO that might be helpful to the court in crafting the charges. Okay,
And Judge, we've actually been working with him.
okay,
So
great.
We'll make him available.
Thank you. So Ms. Pursfield was just looking at wherever someone's evidence is and does not, oh, no. That would be. Is the statement a video? Maybe that's what it is. Okay, so I think we were looking for a transcript. Is there a transcript available?
We can make one really quickly. We'll have to get it to the court this afternoon.
That'll be fine. Thanks. Yeah.
I believe there is justice.
Okay, well, if we have one or can create one quickly, that might be helpful.
Yeah, if you guys didn't catch that, Whitaker was throwing shade saying she didn't want Love to be in charge of writing jury instructions.
All right, so
she
since we're
wanted John
waiting on the
Floyd to
jury
help.
anyway, what else did we need to be covering on Friday? Everybody here? All right, well, y'all get back to me sometime before Friday morning on that question. All right, y'all have your witness ready, whomever your first witness is going to be? We can go ahead and get them out. Okay.
I know they mentioned Detective Starks, so we're gonna get some detective today. I want Viverito on the stand. And you got a hint, if you didn't see her
Who's your
transcripts,
first witness going to be? Okay.
Schardt was saying, like, they used Viverito to have these conversations and get these guys to speculate. Then these guys took
Yeah,
plea
you
deals.
can come on in up to the stand. The jury's on their way out.
front table, you guys. Wherever love moves, the chat is like, why is she at the back? Why is she at the front?
Testing.
Thank you. If you'll swear our witness, please.
You raise your right hand. You swear affirm testimony to give the truth, the whole truth, and nothing but the truth.
I do.
State your spelling first and last name to the one.
Okay. My first name is Sarah, S-A-R-A-H. My last name is Van Holm, that's 2 words, V-A-N-H-O-L-M.
And where are you employed?
I am currently employed with the Georgia Bureau of Investigation in the Division of Forensic Science.
And if you can tell the jury, what are your current job duties and responsibilities?
So I'm a firearms examiner. We primarily determine if a bullet or a cartridge case was fired from a particular firearm. We also perform services in serial number restoration and muzzle to target distance determinations.
And if you can tell the jury about your education and training in ballistics and firearm analysis.
So I have a bachelor's degree in biology from the University of North Georgia. Prior to being employed with the GBI, I was an operations manager for a small firearms manufacturing company. I was a certified firearms instructor, and I was also a professional competitive shooter. Upon being employed with the GBI, I completed a 14-month training program to become a firearms examiner, and that was followed by 7 months of supervised casework. I have been certified as an armorer for multiple firearms manufacturers, including Glock. I have attended multiple conventions and conferences that are firearms related, and I am also a member of the Association of Firearm and Toolmark Examiners.
And over the course of your time, well, and I don't think I asked, how long have you been with the GBI?
How long? Since July of 2017.
How many cases have you analyzed while you've been at the Georgia Bureau of Investigations?
Almost 400 cases.
And how many cases have you worked where you had to compare both projectiles and handguns?
The majority of those cases dealt with comparisons.
You're on this time, the state would like to tender Ms. Sarah Van Holm as an expert in ballistics and firearms analysis.
All right, she is step qualified and may testify as an expert in those fields.
If you can tell the jury, what is the difference between a semi-automatic handgun and an automatic weapon?
Yes, so a semi-automatic handgun is a handgun that fires 1 cartridge per single pull of the trigger. An automatic handgun is a type of handgun that fires multiple cartridges per single pull of the trigger.
And are there mechanisms that can be used to change a semi-automatic handgun to an automatic handgun?
Yes, there are.
And what are those mechanisms?
So there are different ways to turn a semi-automatic handgun into a fully automatic handgun. The most common one that we see in casework is going to be something called a Glock switch. It is usually a slide backplate aftermarket part that replaces that back slide plate, and it renders a Glock firearm fully automatic.
Mm-hmm. And I want to draw your attention to DOFS case number 2022-101-9842, where you requested to do any testing on a Glock 9mm pistol.
Yes, I was.
And what agency submitted the evidence to the GBI?
It was Fulton County District Attorney's Office.
And what were you requested to do?
I was requested to perform what we call a check function on the firearm and determine if it can fire fully automatic.
And how would you do a check function test on a semi-automatic gun?
So semi-automatic, when we perform a check function, we are going to test fire that firearm. We're going to look at that firearm to determine if the safeties are operational and functional. We're going to determine if there's any alterations done to the firearm, if there's any damage to the firearm, and if that firearm is operating as it should.
Okay. And is that the same process you would go through to determine if it's an automatic weapon?
Yes, so if it's an automatic weapon, we perform a few extra test fires to determine that it will fire a certain amount of cartridges to render it full auto.
And how many cartridges are you looking for to determine if it's full auto?
6 or more.
And why are you determining if it's 6 or more?
So that's according to the Code of Georgia standards for what is defined as a fully automatic weapon.
And what was the serial number of the weapon that you were asked to test?
So if I may refer to my notes. So the serial number on the slide and frame was BPHW105, and the serial number on the barrel, which was different, was KUT516.
And what was the type of firearm?
The type of firearm, according to the frame, was a Model 45 Glock 9mm pistol.
And were you able to test to determine if that Glock 9mm pistol was operating as an automatic weapon?
Yes, the plate on the back, the full auto sear on the back, did render the firearm full auto.
And you said the sear on the back?
Yes, so that would be the aftermarket slide plate auto sear, or the Glock switch, as it's commonly called.
And after conducting this test, did you write a report?
Yes, I did.
And are your findings contained in that report?
Yes, they are.
And after your report was published, did that conclude your involvement in that DOFS case number?
Yes, it did.
You talked about the fact that there was a different serial number, BPHW105, on the barrel of the gun, and then KUT516 on a different portion of the gun. Is that unusual?
Yes, generally that means that the barrel was replaced from the original barrel.
Court's indulgence for a moment. Is that significant for you as a firearms examiner?
It can be, because during comparisons, we look at the markings that the barrels impart on the projectiles. So that is something that we would look at if we were doing comparisons.
All right. Court's indulgence for a moment. If there's a difference of the serial numbers, does that have any impact on being able to trace that firearm?
So typically the firearm is traced using the serial number on the frame, because that's technically what the firearm is, that is the frame of the firearm. So that is how you typically would trace a firearm.
Permission to approach? I'm going to show you what's been admitted as State's Exhibit 51XXA. Tell me if you recognize State's Exhibit 51XXA.
I think this is the one that
For
was on the
court,
floor with the
this
extended
firearm
mag
is cleared.
in Williams'
There is
house.
a lock through the chamber. Yes, I do recognize it.
And how do you recognize 51XXA?
I recognize it by the serial number and my initials on the trigger guard.
And is that the same weapon that we've just been discussing a few moments ago?
Yes, it is.
All right. And you talked about the Glock switch. If you can pull the weapon out again for us, if you can just kind of show the jury, point to where is the converter or the switch on the weapon.
Yes, so typically Glocks will have a back slide plate that is flush to the slide on the back. So that was removed, and this Glock switch was then replaced and put on the firearm.
And when you talk about the two different serial numbers, if you can just point or show the jurors where the two different serial numbers are.
Yes, so there's a serial number here on the frame. There's a serial number on the slide. And so that's the slide and frame serial numbers, which is going to be BPHW105. And then the serial number on the barrel is actually going to be right here on the chamber of the barrel. And that is KUT516.
Are you familiar with the NIBIN system?
Yes, ma'am.
When there are two different serial numbers on the NIBIN system, two different serial numbers on the weapon, does the different serial numbers on the barrel and the other parts have any impact on the ability to get proper NIBIN results or ballistic comparisons?
Okay, so for comparisons, it may impact it because if a barrel is switched out, obviously we're looking at the markings on the actual projectiles themselves. For NIBIN is the National Integrated Ballistics Information Network. That has to do with cartridge cases only. So we're not looking at projectiles for that. So switching out a barrel isn't as pertinent as it would be maybe a slide.
Thank you so much. I have no further questions.
Doug?
Good morning, ma'am.
Good morning.
Good morning. My name is Max Schardt. I represent Shannon Stillwell. I just have a couple questions. It seems that you're telling us that there's components from two different firearms on this gun.
Yes.
Okay. Ultimately, at the end of the day, what caliber bullets or projectiles does this gun, as is, fire?
9mm.
Okay, fires 9mm. All right. Do you have any evidence that this gun has been used in any crimes on record?
I do not.
Okay. Do you have any evidence that this firearm has ever been fired by Shannon Stillwell?
I do not.
Do you have any evidence at all that Shannon Stillwell has ever been in possession of this firearm that you tested?
I do not.
Okay, thank you.
Go, Doug.
Good morning. I'm Doug Weinstein. I represent Diamante Kendrick.
Good morning.
I have some similar questions to Mr. Schardt. Do you have any evidence that Mr. Kendrick ever fired this firearm?
I do not.
Do you have any evidence that Mr. Kendrick was ever in possession of this firearm?
I do not.
Do you know who modified this firearm to put the switch on the firearm?
I do not.
And do you know who may have modified the firearm so that it has a barrel that is inconsistent with the frame?
I do not know.
Okay, no further questions. Thank you.
Redirect.
The questions that were just asked of you, would you have any way to know any of those answers, given your work at the GBI?
I would not.
No further questions.
Who can give us those answers?
I do not know.
All right, I look forward to hearing from you.
All right, you are excused. State, call your next witness.
Your Honor, the state calls Brian Shea to the stand.
And I think the state was really unclear what firearm they're even trying to say that was attached to. We just found a firearm, and there's a file number associated with it. Because I think it's the one that was in Jeffrey Williams' house, but they didn't really make that clear.
You ready for that, sir? Swear affirm testimony by this court, true and false, nothing but you tell.
I do.
You have to see, you state your first and last name, spell them both, please.
First name Brian, last name Shea. It's Bryanshea.
And where are you currently employed?
I am currently employed with the Gwinnett County School Police
And how long have you been with the Gwinnett County School Police?
since August 19th of this year.
And prior to working at the Gwinnett County, for the Gwinnett County School Police, where did you work?
I was a senior investigator for Fulton County District Attorney's Office, but I was task forced out to the Bureau of Alcohol, Tobacco, and Firearms.
How long did you work at the Fulton County District Attorney's Office?
I started in August of 2021.
Now, you said you also served as a task force officer with the Bureau of Alcohol, Tobacco, and Firearms. What did you do as a task force officer?
I was attached to an enforcement group. Our main function was illegal firearms, narcotics, and gang issues.
And while you were a task force officer, did you have the occasion to handle cases involving machine gun conversion devices?
I did.
And is that commonly called a switch?
It is.
What type of cases did you handle regarding machine gun conversion devices?
One specifically is I testified a piece of evidence involved in the YSL case, the RICO trial. It was a Glock model 45 9mm that had a MCD, a machine gun conversion device affixed to the back of it.
And if you can briefly tell the jury, what was your education, background, and training experience to qualify you to serve as a task force officer?
I started law enforcement in 2003 with the Atlanta Police Department. I served there for almost 10 years. Left in 2010, went to the City of Johns Creek Police Department, where I started as uniform patrol, worked my way to detective, then made my way to narcotics detective, worked undercover narcotics for a task force. Left there in 2021, came here, was immediately assigned to the ATF, where I studied under numerous special agents there in weapons firearm recognition and how firearms work, specifically illegal ones.
So I want to take you to May 25th, 2023, where you asked to test a Glock Model 45 pistol.
I was.
And were you familiar with that type of firearm?
I was. It was actually the duty issued weapon that I was given by the Fulton County District Attorney's Office.
And there is an exhibit in front of you, 51XXA. Please look and tell me if you recognize State's Exhibit 51XXA.
Familiar, I recognize this weapon.
How do you recognize it?
This was the weapon that I test fired that day.
And when you say that day, you're talking about May 25th, 2023?
Correct.
All right. And how many, in your time either as a task force officer or as in your other roles, how many guns with switches have you handled during the course of your law enforcement career?
Oh, numerous.
And what were you asked to do regarding that weapon?
I was asked to just do a demo video to show its functionality, that it does in fact fire as a fully automatic machine gun.
He seems
I'm
happy
going
to
to
think
show
about
you
it.
what's been marked as 51XXC. Tell me if you recognize State's Exhibit 51XXC.
I do.
How do you recognize 51XXC?
By the case number and my initials and the date and time on it.
Okay. And what is contained on 51XXC?
It is the video of myself at the Fulton County Training Center range, test firing a normal function semi-automatic Glock 45 9mm and then test firing the State's Exhibit.
And did that video fairly accurately depict your test firing of both those two weapons?
It does.
Your Honor, this time the state would like to tender in the mid 51 XXC.
Your Honor, may I approach?
Yes.
Oh, so they're approaching at the bench, not just to see the exhibit. So guys, this is a little bit odd to me because I'm still stuck on, you know, if this is the gun with the extended mag and the switch that they found that is in the indictment as being in the possession of Diamante Kendrick, Martinez Arnold, who's Duke, Ashley Merchant's client, and Jeffrey Williams. Jeffrey Williams just pled to this. If this is the same firearm, it's weird because it seems like the agency that recovered the firearm from the scene isn't the one that handled the testing that the state is bringing these witnesses in this morning to attest to. So to me, it's just signaling that the state had more than one, or this gun was tested by more than one agency, which signals that maybe the DA didn't like the result or lack of results from the first round of testing. So they tested again, right? So I'm a little bit confused, and Hylton's not being all that specific, but she did say the Sarah, the witness, Sarah Van Holm, said that she received that firearm from the district attorney's office. So it just seems like to me the state is trying desperately to test and retest until they can find something that they can tell the jury that wink, wink, maybe there's something here.
Go ahead.
Thank you. Now you said before you tested it a normal functioning handgun and then I guess a not normal. What's the distinction between the normal way that it should operate and the abnormal way?
So the normal way, a semi-automatic pistol is one trigger pull, expels one round from the magazine out of the barrel of the firearm. And when I test fired the state's exhibit, it was one trigger pull and it expelled 6 rounds out of the magazine, out of the weapon.
Sure, son. And before we play it, just where are you when you do the test fire?
The Fulton County Training Center on their range.
And which gun do you test fire first?
So it starts off with my actual duty weapon. That is the same make and model as the state's exhibit. And mine is a semi-automatic pistol, functioning as a semi-automatic pistol.
Glock Model 45. This is my duty issued weapon.
He's
Serial
so
number
hype.
is Bravo Tom Uncle George 256. Empty chamber.
He's like, this is when I had a fun job.
6 round magazine loaded into duty weapon. Range is hot.
He's ready.
Empty magazine.
What did you say there?
I said empty magazine, and I showed an empty chamber, that there are no more rounds inside the pistol.
6 rounds. 1, 2, 3, 4, 5, 6. Glock model number 45, serial number Baker Paul Henry, Whiskey 105. Six-round magazine.
And what do you say there?
I said empty magazine, empty chamber again.
And did that conclude your demonstration video?
It did.
Hold on, Honeybee says that's gonna sound like a drum roll. Guys, remember the love sound effect? The love firearm sound effect. Oh my gosh, what day was that? We need to clip that. Oh man.
Court's indulgence for a moment.
And JB, we love you. We are sending you love here.
When you shot the automatic weapon, did it fire 6 rounds with one trigger pull?
It did.
All right. Thank you. No further questions.
Any cross of this witness?
No, Your Honor. No, Your Honor.
All right, thank you for your time. You are excused. Call your next witness.
Raven Williams?
Okay, I've got another gripe. So, if we see that the magazine that they're using in that instance, right, we're talking 9mm, we had so much beat down testimony, largely from Atkins and Brown, for these other shootings that have nothing to do with this gun. It should be pretty apparent to the jury, even if the state's trying to make this confusing. Hey, we heard all of that other stuff about all those other shell casings. That wouldn't make sense for this type of ammunition. Right? So even though I think the state's trying to be slick and just show a pew-pew being fired off, I think they beat the dead horse so badly when they were talking about the other shell casings that the juries can say, wait, this can't be related to any of that. It's totally different. So, sucks on them for overdoing it. What was it, about 3-4 weeks ago when they were showing picture 48 of a defect in somebody's house?
Raven Williams, Raven Williams.
And good morning, Ms. Williams. How are you?
Good morning, I'm fine.
How old are you?
36.
And do you work?
Yeah.
What type of work do you do?
Home health care.
Okay. And are you from Atlanta?
Basically, yeah.
When you say basic, what do you mean?
I was raised in Augusta.
And how long have you been in the Atlanta area?
About 16 years.
And do you know someone by the name of Shymel Drinks?
Yes.
And how do you know Shymel?
I've been knowing him since Augusta.
Were you both raised together in Augusta?
We wasn't raised together, but we were around each other a lot.
And are you familiar with his family?
Yes.
Do you know his mother?
Yes.
And what's her name?
Sandra.
And does he have siblings?
Yes.
How many?
4.
And did he have children?
No.
Did Shymel have a nickname?
Yes.
What was his nickname?
Peanut.
And is that a nickname you called him when y'all were back in Augusta?
Yes.
Now, I know you said that you all grew up together or were around each other in Augusta. Do you know if he was born in Augusta?
Yes. No, I think he was born in Atlanta, I think.
But was he raised in Augusta?
Some partially. That was back and forth.
When they were back and forth, is that between Augusta and Atlanta?
Yes.
Do you know where in Atlanta he would stay when they were in Atlanta?
I'm not sure when he was staying with his mom, but at the time of death, he was living with me.
Back in 2022, did you ever know him to hang out in the Summerhill neighborhood?
Yeah, I think so.
What about in Mechanicsville?
I guess that's what you call it. I'm assuming.
I want to direct your attention to March 14th, 2022. Did you have the occasion to see Shymel Drinks on that day?
Yes.
Where were you when you saw him?
Home
At the time, where were you living?
in Douglasville.
If you were coming from downtown, how would you get to your home?
20 West.
Sitting here today, do you remember what time he came to your house, or was he at your house all day?
I don't remember the time verbatim. I just know when I got there, it's like it was almost time to get my daughter from gymnastics, and that's normally like I want to say like 6 something, but I just can't remember verbatim. But like around that time frame, I believe.
And we say 6 something, at 6 something p.m.?
Yeah.
Okay. Was he already at your home when you were getting ready to maybe get your daughter from gymnastics?
Yes.
Was he at your home with anyone?
Yes.
Do you know who?
A boy named Barter.
Had you ever met that individual, Barter, before?
No,
Do you know if Barter was a nickname or his given name?
I'm not sure.
Hey, it's Carter with a C.
When you were home, let me ask, did you get home and he was already there with Barter, or did he come to your house and you let him in and he came with Barter?
I kind of think that it was kind of like at the same time, or like a few minutes off. I think he had pulled up and then they were in the car, and then when I pulled up, he started coming into the house.
Did both he and Barter come inside of the house?
He was coming in first with me, telling me who it was, and then the guy was coming up.
Now, I think I may have asked you this, but I'll ask you again. Had you ever seen Barter before?
No,
Had you ever heard Shymel talk about Barter?
no.
Did you all have plans for that evening?
Yes.
What were they?
I was getting ready to cook dinner, so he was coming back home to eat and chill with me and my daughter.
And let me ask you, at the time, were y'all two dating?
Yes.
All right. Did he stay at the house
That night?
that night?
No, he never returned.
You said you had to get your daughter maybe around 6 o'clock p.m. What time did he leave your house?
I'm not sure.
Was it before you left to get your daughter or after you left to get your daughter?
He left just a couple of minutes before me.
Did you know where he was going?
He told me that he was running to the city and that he was dropping Barter off, and then he was coming back.
Was there anything that you saw or observed that kind of triggered him leaving?
Kind of, but not really. I mean, I guess like the boy kept like just trying to insert himself like, oh, you cooking? I'm staying too. Can I stay? And like he was, my niece was there. So he was trying to like court my niece or whatever. And so I want to say the phone rang, if I remember correctly. And that's how he just ended up go ahead and leaving.
Do you know whose phone rang? Okay. When he left, did he leave with Barter?
Yes.
Did he ever make it back home?
No.
Did you at some point learn about his death?
Yes.
All right. Permission to approach, Your Honor?
Yeah.
I'm going to show you what's been marked as State's Exhibit 123VV. Do you recognize individual 123VV?
Yes.
How do you recognize him?
That's Shymel.
Is that a fair and accurate depiction of how Shymel looks prior to his death?
Yes.
Your Honor, this time the state would like to admit 123VV into evidence.
It's admitted.
Permission to publish.
You may.
Are we going to be getting into victim impact territory?
Mr. Drinks.
Yes.
I have no further questions.
Any questions for this witness?
Oh, I'm sorry, Your Honor. One quick
Go ahead.
question. Have you ever heard the name Christian Johnson?
No.
Okay, thank you.
Any
Okay, so
questions?
that's the name we heard yesterday, Christian Johnson.
Okay. Thank you for your time. You're excused. Call your next witness.
Your Honor, court can go to school.
So I've got two questions. We are hearing about a Barter, and we also have this still hovering mystery about DeMarco Boyer. The mystery phone number that was in the phone tolling records. It was the device that Shannon Stillwell was allegedly calling Demeke Garlington on the night that the Waters Roadhouse was getting shot up, I think March 16, 2 days after the Shymel Drinks shooting. DeMarco Boyer owned that handset that the state alleges is Shannon Stillwell whispering on, calling Demeke Garlington. So who are these two individuals? And not for nothing, if I'm reading a demeanor a little bit, it seems like the witness that was just on the stand, Miss Williams,
Whomever it is.
had a funny feeling about Barter.
Your Honor, state calls Philip Norton.
Okay. Where's he going?
You raise your right hand. You swear to affirm testimony you give the truth, the whole truth, and nothing but the truth? Yes, sir. I need you to state your first and last name, and spell your first and last name to the record.
Phil Norton, Philnorton.
Good morning, Mr. Norton. How are you?
Good.
Good. Mr. Norton, would you tell the jury, are you a gun owner?
Yes,
How long have you owned guns, firearms?
my entire life.
What type of guns have you owned throughout your lifetime?
Couldn't tell you.
Have you ever owned a Glock 9mm weapons?
Yes,
All right. Now, when you purchase your firearms or when you obtain your firearms, where is it that you ordinarily get your firearms from?
various places. I make holsters for a living, so I come across a lot of guns.
You make what for?
Holsters for guns.
Okay. And you said, so you come across a lot of guns?
I do gun shows almost every weekend,
All right. And where do you do your gun shows?
all over the place.
During your gun shows, do you buy guns from people or do you just sell them?
Everything, it changes every day. It's almost like a pawn shop.
Okay. All right. And do you
There's a
have-
lot of trading going on, selling, buying, not necessarily just guns, everything.
Okay,
Ammo,
including your
optics,
holsters?
holsters, bags, everything in the industry.
Okay. Do you have to comply with any federal regulations at those gun shows?
If you buy from an FFL agent, yes. If you buy from a FFL holder, yes.
And what is an FFL holder?
Federal firearms license.
All right. Now, when you say if you buy from an FFL holder, you have to comply with federal regulations. During those
Go.
exchanges and during those sales and transactions that take place at the gun shows that you attend, are you either buying from FFL holders or are you an FFL holder?
No.
So there's no restrictions to the way that you sell and
If
purchase
you're
guns?
a private owner or a private seller, under the Constitution, you can buy and sell guns. You don't have to have an FFL license.
Okay,
Just like if you were my neighbor and I sold you a gun.
okay.
I don't know if you know that or not.
I do not, because you just told me.
Yeah.
So when you purchase a firearm from someone, is there any kind of record, or do you keep any kind of record of the types of
Not
firearms?
unless it's an FFL agent, no. Unless, if it's an so in other words, if I go to
Look at her head
Academy
tilt.
Sports, there's paperwork filled out.
Okay.
If it's a private sale, no.
Now, you said you've owned guns all of your life, or at least you've had
Yes, ma'am.
access to firearms. So is it safe to say that you're pretty familiar with firearms and how they work?
Yes, ma'am.
Now, the types of gun that you've owned, have they all been semi-automatic? Have they sometimes been revolvers, pistols, a whole range of guns?
Yes.
Yes to which question, since I asked the
All of
compound
them.
one? Okay. Have you ever owned an automatic weapon?
No.
Have you ever handled an automatic weapon?
No.
Do you know what an automatic weapon does?
Yes.
And how do you know that?
Because this is my business.
Fair enough. And so is it safe to say you make it your business to do that type of research, or you've seen it in action?
It's 2024. If you can't see that on YouTube, it's pretty easy.
Okay,
It's very acceptable knowledge. Everybody has it.
all right. And what about the way that a gun is made or transitioned from a semi-automatic to an automatic weapon? Are you familiar with that as well?
No, not how to do it.
Not how to do it? Are you familiar with the mechanism that causes a gun to go from semi-automatic to automatic?
Which one?
The switch.
I am familiar with it.
All right. Have you ever purchased a switch?
No. I've only seen it on TV or YouTube, I would say.
Okay. Now I'm going to show you what we have marked as states 51XX alpha. May I approach?
Yes.
Thank you. May I approach you, sir?
Yes, ma'am.
Now, are you able to recognize the firearm that is in this box?
Yes, ma'am.
And have you ever owned the firearm that is in this box?
According to why I'm here, yes.
Now, would you explain what you mean when you say according to why you're here?
I believe I purchased this off of a law enforcement agent, and then I traded it at some point.
Okay.
What I've been told, and I believe when I was talked to about it, yeah.
And does this appear to be the firearm that you purchased from that?
Not anymore, now with that switch on it.
Okay. Do you see the switch on it that you're talking about?
I do, I know what they are.
Okay.
I've never seen one. I've only seen it on YouTube.
All right, point two.
That's it, right?
Is it okay if I hold it up, Judge?
Yes,
All
it's locked, right?
Yes.
It is, Judge.
Yes.
It's right there in the back.
Okay. So this little part right here?
Uh-huh.
Okay.
And so somehow that makes it so you just pull the trigger once.
Okay, and what is your understanding of when you say you pull the trigger once, somehow that makes it?
It empties it. It just, you don't have to pull it again.
Oh my
Okay.
gosh.
And given your experience with firearms, is there any particular reason that you've never purchased a switch or utilized?
It's a felony and illegal, be a good reason. Yeah.
Okay. Thank you, sir.
Holy
Yeah.
moly.
And the last time that you owned this weapon, it did not have that switch attachment on it.
It didn't come from the officer like that, and it didn't leave me like that.
Do you remember what you did? Did you sell it at one of your gun shows?
I really don't. I tried to recall. It was quite a while after. I don't know if I traded it or sold it, or I really don't remember.
Okay.
I probably traded it because you can usually trade in it more value.
And when you say traded it, would it have been at a gun show or at a pawn shop?
No, at a gun show.
Okay.
Yeah.
And again, there's not records that are kept of who you would have traded it to.
No, ma'am.
And then once you traded it, you kept no contact with the buyer of the firearm to know what they did with it.
No, ma'am.
Okay, thank you so much, sir.
This is almost like a reverse Perry Mason moment. So this is the guy that sold the thing. He could have switched the barrel. He's like, I wouldn't do that. That's illegal. I would never. I only know about it because of YouTube.
Now, is it, I'm sorry, I'm gonna let him make that like it should be. Is it safe to say, or I should ask you, do you even know a person by the name of Shannon Stillwell or Shannon Jackson?
No, ma'am.
Do you even know a person by the name of Diamante Kendrick?
No, ma'am.
Do you know anyone that goes by the name SB?
No, ma'am.
Do you know anyone that goes by the name Yak Gotti?
No, ma'am.
Do you know a Jeffrey Williams?
No, ma'am.
Do you know anyone that goes by Young Thug personally?
No, ma'am.
All right. And is it safe to say you've never had any transactions with either of those people?
Ask that again?
Have you ever had any transactions with either of those
No, ma'am.
people? All right. Thank you so much, sir. That's all I had.
Yes, ma'am.
God, she thinks this was so
Any
good for
questions
her.
this witness? Mr. Weinstein, okay.
Good morning, Mr. Norton.
Morning.
My name's Doug Weinstein. I represent Diamante Kendrick, who's sitting right over there.
Okay.
Just a couple of questions. You said that when you had this firearm, it did not have a switch on it, correct?
Yes, sir.
You don't know who modified it to put that switch on there, do you?
No, sir.
You don't know if my client, Mr. Kendrick, has ever been in possession of this gun, do you?
No, sir.
Okay. You don't know if he's ever fired this gun, do you?
No, sir.
All right. No further questions. Thank you.
Redirect.
Just briefly, you were not at a person by the name of Jeffrey Williams' house on May 9th, 2022, were you?
No, ma'am.
Thank you.
All right, thank you for your time. You may step down, call your next witness. You're excused. Thank you.
Didn't call Dr. Melissa Sims Stanley.
Guys, can you like rate that as, 0 means it helps the state, 10 means it helps the defense? And just to clarify, the point of that witness was he owned that firearm at some point in time. So Love wanted to call him up there so he could say, I'm not the one that put the switch on it and sold this firearm. And I'm not going to say that on the stand because that would be a federal crime. Like, all about a firearm that Jeffrey Williams just pled to that was found in his home, which may not have belonged to him, but he pled to it already. So, and the jury doesn't know that. This is their case. This is their case.
Raise your right hand. You swear affirm the testimony to give the truth, the whole truth.
I did.
State and spell your first and last name for the court, please.
Melissa Sims Stanley, Melissa Sims Stanley.
Say good morning.
Good morning.
Could you explain to the jurors how you are currently employed?
Currently I'm retired as of July this year.
And prior to July of this year, well, congratulations, one.
Thank
And
you.
prior to July of this year, can you tell the jurors how you were employed or where?
Yes, I was an associate medical examiner with the Fulton County Medical Examiner's Office.
And can you tell the jurors how long were you an associate medical examiner with the Fulton County Medical Examiner's Office?
I began at Fulton County as a locum tenens or contract medical examiner in March of 2020 and was hired full-time in July of 2022.
And prior to beginning your contract work in March of 2020 with Fulton County, can you tell the jurors, were you employed by other medical examiners, agencies in other counties?
Yes, I was a regional medical examiner with the Georgia Bureau of Investigation from July of 2000 to December of 2019.
Now, can you tell the jurors a little bit about your educational background and training that has allowed you to work as a medical examiner for all these years?
I obtained a Bachelor of Science degree from Emory University, a medical degree from the Medical College of Georgia. I did a one-year internship in internal medicine, also at the Medical College of Georgia. I then completed an anatomic and clinical pathology residency, followed by one-year fellowship in forensic pathology at the Medical University of South Carolina.
And can you tell the jurors, in your number of years working in various medical examiners, agencies or offices, approximately how many autopsies have you performed?
Greater than 3,500.
Your Honor, at this time, the state would tender Dr. Stanley as an expert in forensic pathology.
She is so qualified and may testify as an expert in that field.
Thank you, Judge. Now, Dr. Stanley, can you tell the jurors generally when you are preparing to begin an autopsy, some of the first steps that you take before actually beginning the autopsy?
Yes, every medical examiner's office has a staff of medical examiner investigators. So the coroner, if it's a certain county, or law enforcement will contact the medical examiner's investigators to discuss a death. If that death falls within the jurisdiction of a medical examiner's office, then the case is accepted into that office. Cases which fall under the Georgia Death Investigation Act to be autopsied by medical examiner's offices are unnatural or unexpected deaths, unnatural being homicide, suicide, accident. However, every medical examiner's office gets a fair number of natural deaths, drug-related deaths. It's just that they may be in the unexpected category.
Okay, and can you tell the jurors, while working at the Fulton County Medical Examiner's Office, was it a part of the normal procedures and practices for an autopsy to be documented with photographs?
Yes.
And as you do the procedures with the external and internal portions of the autopsy, are you having someone, I guess, take your notes of your findings and conclusions?
I take notes during the autopsy and then dictate the autopsy afterwards to be transcribed.
Okay, and are your findings and conclusions then memorialized in a report?
Yes, they are.
And is that something you did for every autopsy that you performed while working with the Fulton County Medical Examiner's Office?
Yes, sir, that's correct.
Okay. Now, I want to direct your attention to March 17th of 2022. Did you have the occasion to perform an autopsy on a gentleman named Shymel Drinks?
Yes, sir.
Okay. And can you tell the jurors, as it relates to the autopsy of Mr. Drinks, were the policies and procedures that you just described completed? And I mean, were photographs taken and was a report created?
Yes.
Okay. And I want to show you what's been marked as state's exhibits. Mr. Weinstein. I want to show you what's been marked as state's exhibits 126 through 161, and then state's exhibit 162, Victor.
Okay, this just seems cumulative. That's a lot of pages.
Yes, sir.
Dr. Stanley, in your review of state's exhibits, we'll start with 126 VV through 161 VV. Do you recognize the photographs contained in those exhibits?
I do.
And can you tell the jurors how you recognize those photographs?
They are photographs which were taken during the course of the autopsy.
Okay. And are those photographs in state's exhibits 126 VV through 161 VV? Are they fair and accurate copies of the photographs taken during the March 17, 2022 autopsy of Mr. Drinks?
Yes, sir.
And I want to move to state's exhibit 162 VV. Can you tell the jurors, do you recognize that exhibit?
I do.
And how do you recognize it?
It is a copy of my autopsy report.
Okay. And is state's exhibit 162 VV, is it a fair and accurate copy of the autopsy report that you created for the autopsy that you did on Mr. Drinks on March 17th of 2022?
Yes, sir.
Your Honor, at this time, the state would tender what's been marked as state's exhibit 126 VV through 162 VV.
Through, Your Honor, for 126 to 161, no objection. 162, I don't have an objection for admitting it for the record. I guess it's a
Okay, well, those are all admitted. And in terms of what goes out, we'll sort that out later.
Now, Dr. Stanley, can you explain to the jurors when you began the autopsy procedure on Mr. Drinks on March 17th, can you tell the jurors what you did first to kind of initiate your process as it related to the autopsy?
Yes. Before any autopsy, the investigative information, which is written up by the investigator, is reviewed. I always say an autopsy is never performed in a vacuum. You always have the investigative information first, and then a further investigative information or medical history is needed that's requested by the medical examiner. So in this case, as there were gunshot wounds, x-rays were taken of Mr. Drinks. Before the autopsy, every medical examiner's office has the capability to perform x-rays. In this case, it's because if there are bullets in the body, the location needs to be determined and they need to be recovered at autopsy. After that, the external examination is performed, documenting everything from hair color, eye color, scars, tattoos, trauma, obviously, if trauma is present, and then the internal examination is performed.
Okay, and I want to show you, it should pop up on the screen before you, State's Exhibits 127 VV and 129 VV. Now, Dr. Stanley, can you explain to the jurors, I guess, the purpose of this photograph that is taken during the autopsy procedure?
This is a facial identification photograph. You will notice in every photograph there is the unique identifying case number for this autopsy and for every piece of evidence which is associated with this autopsy.
Okay, and in State Exhibit 129, can you tell the jurors, is this the state in which Mr. Drinks' body was received by the medical examiner's office?
Yes. Everyone is received within a sealed and labeled body bag. Once that body bag is opened, photographs are taken along the way as an extra step of documentation. So this is a photograph of how Mr. Drinks was received. The white paper bags on the hands are placed on the hands, typically by law enforcement at the scene for preservation of possible evidence.
Okay. And can you tell the jurors, in your, I guess, when you began the external review of Mr. Drinks, can you tell the jurors, did you notice, as it relates to the injuries, anything like soot or stippling?
No. However, there was what's called pseudo-stippling or false stippling associated with the entrance gunshot wound of his neck.
Okay, can you explain to the jurors what is pseudo-stippling and how is that created?
Yes. Well, first, soot is the combustion of gunpowder, which is associated with contact or near contact gunshot wounds. Gunpowder stippling refers to the burning and unburned grains of gunpowder, which can impact on the skin around an entrance gunshot wound. They look like red pinpoint, very small abrasions. This is characteristic of close range or intermediate range gunshot wounds. In this case, the investigative information and the scene findings I had was that Mr. Drinks was found deceased within a vehicle, and that there were gunshot wound defects noted in the car doors, the front door, the front driver's door, the front passenger door, as well as the front passenger's windshield. So he had what's called pseudo-stippling, so it's not gunpowder stippling, but there were larger, irregular abrasions which were associated with the entrance gunshot wound of the neck. So what that tells you is, in conjunction with the scene findings, that when a bullet passes through an intermediary target, say the bullet passes through a wall or a window prior to striking the victim, that can fragment the bullet, and those bullet fragments can impact on the skin around the entrance wound, or it can fragment the intermediary object itself, the door, the window. So those fragments can impact. So there were those irregular fragments of either the intermediary target or the projectile around the entrance wound of the neck.
And the irregularly, can't say that word this morning, the irregular, the things that you found to be not normal, I guess. My mouth is not going to say that word today. Can you tell us, in State's Exhibit 138BB, can you point out to the jury what you are talking about as it relates to the pseudo-stippling?
Yes, it's easier to see on what's termed the clean photograph. Photographs of wounds are taken before cleaning the body and after.
Yes.
But
145BV, if that will help assist.
Yes, if you can look at the top of the photograph, when we see the outline of his mandible or his lower jaw, I think you can appreciate there are some irregular red or dark areas that are associated around his mandible. And also around what's termed the mastoid process, this bump that you feel at the base of the skull. So those are characteristic of what's called pseudo-stippling. So they're fragments of the intermediary target.
Now, can you tell the jurors, how does that affect your ability to determine, I guess, the range of fire, or how far a barrel of a gun is from the gunshot wound that we're looking at here in State's Exhibit 145, Victor?
Well, once a projectile has passed through an intermediary target before striking the victim, the medical examiner is not able to determine that distance. Say if there is the shooter, a door, and the victim, the medical examiner is not able to determine whether the shot was fired immediately next to the door or 30 feet, 50 feet, or more away from the door. So it's termed indeterminate range. In other words, you don't know the range of fire through an intermediary target. So this was indeterminate range through an intermediary target. That's the range of fire.
So the findings that you just talked about, Are they consistent with someone being shot while in a vehicle?
Yes.
Okay. Now, you talked about in States Exhibit 145 BV that this wound on the neck was an entrance wound. Can you tell the jurors, is there an exit wound associated with this injury, this shot to the neck?
There was not. The bullet was retained within the body.
Okay, and I should have asked you this first. In the exhibit we're looking at in 145 BV, can you tell the jurors what side of Mr. Drinks' body is this gunshot wound to the neck?
This is the right side of the neck.
This would be the side that's, I guess, closest to, if you're sitting in the driver's seat of a vehicle, to the passenger, I guess, compartment.
Correct, yes.
Now, can you tell the jurors, if there is no exit wound, can you explain to the jurors, were you able to determine during the external and internal portions of the autopsy that you performed, the pathway of travel of the projectile or bullet through Mr. Drinks' neck and into his body?
Yes, the bullet entered the right side of the neck. It was going upward, in other words, towards the top of Mr. Drinks' head and to his left. So the bullet passed through the soft tissue of the neck and impacted the base of the skull, fractured the base of the skull, and caused bleeding within the brain case, and also caused a small laceration of the base of the brain.
Now, Doctor, can you explain to the jurors when someone receives a traumatic injury like this, and you said it goes through Mr. Drinks' neck, it fractures the base of his skull, and does it travel upward?
Yes, it was traveling upward.
Okay. The areas of the brain that you just described, that the pathway of travel is for the projectile, can you tell the jury what areas of the brain is affected and what motor skills does it affect as it relates to someone who is shot in this manner?
Well, in this case, the bullet fracturing the base of the skull, this represents a massive injury to the skull and also to the brain. It caused bleeding on the surface and within the brain. And whenever there is massive trauma such as this to the brain, consciousness is lost immediately. However, I could not determine whether this shot was instantly fatal or if Mr. Drinks still had some cardiac and respiratory activity for some undetermined period of time. Sometimes with these catastrophic injuries to the brain can send out a signal to the heart, which causes the heart to either stop beating immediately or to go into a lethal rhythm. So consciousness would have been lost immediately, but whether death was instantaneous or there was some cardiac activity or breathing activity for some period of time, I couldn't determine.
And can you explain to the jury, based on the circumstances you kind of just described, what does, I know you described what the brain, the message that is sent to the heart, can you explain to the jurors, are there other things that the body does under these circumstances? And I mean, are there any involuntary actions that the body can produce as it relates to someone who was shot in this manner?
Well, if there was still cardiac and respiratory activity, then there could have been obviously breathing. As people are dying, they can exhibit abnormal patterns of breathing. So I'm not sure if that's what you're referring to.
And I guess I'll give you an example. In an instance where someone is shot like this, and can someone's hands clench and it remain clenched because of the immediate traumatic injury that they received to their brain?
It's possible, yes.
Now, as it relates to the direction of travel, if Mr. Drinks' head is tilted to the left and he's shot from the right side through the passenger door, would that be consistent with, I guess, why the projectile would travel upward?
Yes. And just a clarification, when I talk of the direction of the bullet, that means the direction of the bullet once it enters the body. I'm not able to determine direction of the position of the gun or the shooter from that.
Okay.
I need a
And so
diagram.
the bullet, it enters the right side of his neck, it travels upward. Can you explain to the jurors where the bullet ended within the head cavity of Mr. Drinks?
Yes, the bullet was recovered within the fractured base of the skull.
All right, I'm gonna pause here because we still don't know who the heck Barter is. We don't have videos of this moment. We just have a still image that's capturing the license plate reader thing. So if you ask me, if I'm unsuspected and driving at a light, unless the other car is rolling down their window and goes, "Hey buddy, I'm about to unalive you," well, how would I know to duck unless, the first shot, if I can react quickly enough, maybe I'm trying to veer away from where the noise is coming from, and that gives me the angle. Versus if I know somebody, because you guys are saying in the chat, maybe somebody was in the car with him. Who's this Barter person? If I know somebody's coming up on me and not just unsuspected shooting from another car window without me knowing, maybe that would explain why I'm already trying to maneuver out of the way in a split second. I have questions here. I have questions.
Okay. Can you explain to the jurors, as you continued the autopsy, were there any other injuries associated with a gunshot wound?
Yes. Mr. Drinks had a gunshot wound pathway through the upper portion of his right forearm. It entered what's referred to as the back or the dorsal aspect of the forearm. The bullet passed through the soft tissue of the forearm and then exited the ventral or inside surface of the right forearm.
And in the exhibit that we're looking at in front of you states that 140VV, is that the entrance wound that you just described as it relates to the shot that he received in his forearm?
Yes, that is the entrance wound.
Now, I want to show you State's Exhibit 142VV. I know you just described kind of the travel or the pathway of travel of the bullet. In this exhibit, 142, Victor, is this the exit wound that you just described?
Yes, it is.
Now, can you explain to the jurors how you're able to determine which is an entry wound and which is an exit wound based on your training and your number of years of experience?
In general, entrance gunshot wounds have a more round, regular appearance. Typically, entrance gunshot wounds have what's called an abrasion border. This means as the bullet pierces the skin, it abrades or scrapes off a thin border of the skin around the wound. Exit gunshot wounds typically have a more irregular appearance. They typically do not have abrasion borders, but there can be exceptions.
And in State's Exhibit 141VV, the abrasion border that you're describing, is that what's in the middle of, I guess, State's Exhibit 141VV, the darker colored area around the gunshot wound?
No, that's more of the flap of skin.
So you're the doctor, I'll let you do it.
This entrance gunshot wound was larger than normal. It was ½ an inch. The entrance gunshot wound of the neck was about 2/10 or 3/10 of an inch. So because this entrance gunshot wound was round, it was larger and more
Don't
irregular.
look at the screen if you're queasy.
That was
My
also
bad.
consistent with this projectile also passing through an intermediary target. The abrasion border was slightly more irregular. So here we see this is a dark abrasion. There's also a thinner rim of dark abrasion on this side of the entrance gunshot wound. This represents a laceration or tear of the skin. And then this area is just somewhat of an irregular flap of skin.
Okay, and then I'm going to bring back up States 142 BV. Can you explain to the jurors the difference in the exit wound that we're seeing here as it relates to the entry wound, and how you are able to make your determinations?
Yes, this is an exit wound. Exit wounds can either look like multiple lacerations or tears of the skin, but one of the characteristics of exit gunshot wounds is that you can reapproximate the skin edges, and that exit gunshot wounds typically do not have an abrasion border. So there's no abrasion border associated with this wound, and it was very easy to reapproximate the skin edges.
Thank you very much. Now, as a part of the autopsy that you performed, I want to show you States Exhibit 147 VV and 148 VV. Can you explain to the jurors, I guess, the analysis that you did as it relates to the jacket that Mr. Drinks had on when he was shot?
Yes, for homicide cases, photographs of the clothing are always made, and then photographs are taken to determine if there are defects in the clothing which seem to correspond with the gunshot wounds.
And when you're examining the clothing of a victim who's been shot, do you look for soot, like you talked about earlier, to help you make a determination as it relates to range of fire?
Yes.
Okay. Now, lastly, I want to show you States Exhibit 161 VV. And you described at the beginning of your autopsy that x-rays are always taken, as well as the fact that you, during the autopsy, were able to remove a projectile from I think you said the base of the fractures of the skull of Mr. Drinks. Is that correct?
Yes.
And in States Exhibit 161 BB, is this the projectile that you removed?
Yes, it is.
Okay. And because my medical terminology is limited, can you explain to the jurors? You said you removed it from the base of the skull fractures. Where is that?
Yes, I actually removed it from the occipital skull. The occipital skull forms the lower back portion of the skull, but also the back half of the base of the skull. I wrote sphenoid skull, which is a portion of the skull which is in the central base of the skull, and that was a mistake, and I noted it in the report. It was recovered from the occipital skull, not the sphenoid skull.
And in 146 VV, can you orient the jurors, I guess, do you see, I guess, the general area where the projectile would have been removed? Is it contained in that photograph, like the base of the skull?
No, that photograph was just to document whether there were injuries behind the right ear.
So I'm going to have you, I guess, show on me where would the bullet have been removed as it relates to the base of Mr. Drinks' skull?
The bullet would have been removed from, it's difficult to point because it would have been, if we think of the base of the skull, it would have been inside, below the skull base, somewhat on the right side.
Okay. Is it near the knot that you described earlier? On the other side?
It would have been internal to that, yes.
And can you tell the jurors, once you removed the projectile and placed it in the clear box with it being labeled, what do you do with it next?
It is then submitted as evidence to the Georgia Bureau of Investigation.
Now, as a part of your autopsy procedures, can you tell the jurors what your determination was as it relates to the cause of death of Mr. Drinks?
Yes, I stated that the cause of death was multiple gunshot wounds.
And as it relates to your determination of the manner of death of Mr. Drinks, can you explain to the jurors what your determination was?
Yes, for the purposes of a medical examiner, if the actions of another individual cause or contribute to the death, then the manner is classified as a homicide.
Your Honor, I have nothing further at this time.
All right, are there questions? Go ahead.
All right, this is going to be interesting, I think. Could be short, but interesting.
Doctor, good morning. My name is Max Schardt. I represent Shannon Stillwell, okay?
Yes, sir.
And Ms. Stillwell is seated right over here. So I want to ask you about this concept of stippling and pseudo-stippling first, okay? Now, you're not saying that stippling is involved in this case, you're saying pseudo-stippling.
Yes.
Which could have been caused by the projectile fragmenting and the low pieces embedding in or affecting Mr. Drinks' skin, or low pieces of the intermediate object, perhaps a window or something like that.
Or door, yes, sir.
Okay. And I'm not talking about the pseudo-stippling that you found in this case. I'm just talking in general. When we're talking about stippling, I just want to clarify something. Stippling, you're saying, is caused by burns around a gunshot wound when it's a close and range shot.
Yes. When one says stippling, it typically means gunpowder stippling, but yes, that's correct.
Okay, and you're saying gunpowder stippling, and that's just what I want to clarify. The stippling is caused by gunpowder soot that is ejected out the barrel of the gun and would affect the skin of the unfortunate decedent, correct?
Yes, gunpowder stippling represents the burning and unburned grains of gunpowder, which exit the barrel and can impact on the skin in a close-range gunshot wound.
Okay, and I know you're not an expert in gunshot residue testing or anything like that, but I just want to clarify. These are two different concepts, correct?
That's correct.
Gunpowder stippling and then gunshot residue testing, where you would test an area or a specific object for the presence of gunshot residue. Those are two separate concepts, both involving gunshot residue.
Well, the determination of gunpowder stippling at autopsy, yes, is done by the medical examiner.
Right,
Yes.
okay. Okay. Now, in this case, as I understand, there were two gunshot wounds that you observed.
Yes.
Okay. One to the arm, to the forearm, and one to the neck.
Yes, that's correct.
Okay. The lethal wound was the wound to the neck.
That's correct.
Okay. And as the medical examiner, you do not know what order those two shots occurred.
That is correct. I do not know
Okay,
the
so
order.
Mr. Drinks could have been shot in the arm first or in the neck first.
That's correct.
Okay. And I want to talk specifically about the lethal wound to the neck. Okay? You talked and used medical terms, and it sounds like there was massive injury to the base of the brain, among other things.
The skull and the brain, yes, sir.
Okay. And you testified, to my understanding, that the ability to consciously control one's body would be immediately lost.
That's correct.
Okay. Death may not be immediate, but the ability to move body parts, to open a door, to move your feet up and down, things of that nature would be immediately lost.
Yes, conscious movement would have been immediately lost. Yes.
Okay, and we're not talking about within a minute, we're talking about immediate because of the severance of the, because the base of the brain was
Because of the
severed.
massive damage to the skull and the brain, yes.
Okay. All right. Thank you. I have no further questions.
Anything? Okay, any redirect?
Very brief. Dr. Stanley, if after receiving a gunshot wound to the neck, as Mr. Drinks did, and prior to being shot, he had his foot compressed on the brake, is it possible, is it consistent with the fact, would his foot remain on the brake? Is that possible?
After sustaining the gunshot wound to the neck?
Yes.
Yes, that's possible.
Okay. Now, you said earlier that the direction of travel was upward. Can you explain to the jury, was it upward to the left, upward to the right? Can you explain that?
Yes, again, this direction is simply from the time that the bullet enters the body. It went towards his head, which is upward, and towards his left, upward and to the left.
And I want to ask you one last question. When someone is shot, would you expect to find gunshot residue on that person?
Not necessarily.
Okay. I don't have anything further on.
Doctor, Mr. Abadi just asked, after being shot in the neck in the way that Mr. Drinks was, unfortunately, whether it's possible that one's foot could remain on a brake if it was already there. And you said that's possible.
Yes, sir.
Okay. What is not possible, you would agree it's not possible after suffering that wound that someone would be actively moving their feet up and down off the brake. That would not be possible.
That's correct.
Okay, thank you.
All right, thank you for your time, and you are excused.
Yes,
How long
I
is your
can.
next witness?
Probably about 35 minutes.
Okay, why don't we take a break, and then we'll get back with our next witness.
All right, here.
All right, you guys. All right. And I don't think rigor mortis is the question here, it's the nerve, right? If you're getting shot in this part of your skull, you lose the ability to move the rest of your body. Even if you haven't, it's not officially fatal, you're still actually alive. You would instantly lose the ability to lift your arm, lift your leg, control your fingers and toes. So, yeah, so where are the blinkers? Got some questions here, guys. And remember, this is only the half of it. We've got
All
the
right.
medical examiner.
10 minutes or whenever the jury gets back.
But we haven't gotten into the detectives, where we're going to see Starks probably, and then Viverito try to lay out their storyline of what they think happened. And then we get to see the defense cross-examine on that theory and how that theory actually holds up. So what we're seeing from the defense attorneys is just laying down little bits that they're probably going to recall later. Yeah, this is a bit, I don't know. Also, big shout out. I know we jumped and got right into it today, but right out of the gate, STS gifted a membership. Very nice of you. And I also saw you say we've got less than 10 days more of the cone of shame, and the cone of shame can come off. So looking forward to that date. FFS is also out here sniping, but is also asking, hold on now. I'm ready.
Oh, guess what day it is? Guess what day it is? Huh? Anybody?
I am prepared. So happy Wednesday, everybody. And big thank you, FFS. And another gifted membership from FFS here. Zion came in the cut and said, look, we're going to drop 5 gifted memberships. So they are piling on. You guys make sure you're saying thank you as you're getting them. I am seeing you guys say thanks. I'm just really late to getting to this stuff this morning. Yes, we've got the hump day in the chat. Guess what day it is? Mike. They should bring that commercial back for the good times. And then Gavakufu said, hold on, I'm sniping also, don't leave me out. So thank you so much, all of you. Shannon Alexander says, Love's job is secure. Fani Willis won her re-election. I pray my dad's case finally gets a court date. Right, move this pipeline along. And what I did think, I would love to compare it to, you know, the breakdowns, you know, the down ballot voters, right? Sometimes you just vote down, you don't know the smaller races. Some people only go and vote for the big ticket, right? And you vote down. And I don't know how this breaks down other years to compare it to anything, but I did see GSU post a stat that Fani was 5 points down from Harris, suggesting that, you know, if people were thinking they were voting in the major race for the same party that Fani Willis is affiliated with, there was a bit of either people didn't vote for her, they skipped her, or they voted for the other side. Whether they were truly voting for the other side to support that candidate or just as an opposition to Willis, there was a 5-point difference there. So I don't know if that's meaningful. Maybe that's how it is every year. But I thought that was a little interesting. Saw it posted by GSU Grinding over on X this morning. So, but yeah, I don't know. I think a lot of positions, you guys, I think are pretty cush once you're the incumbent. So I know people were hoping for some type of miracle that Fani learned a lesson. Maybe she'll do better. I don't really know if that was ever on the table. And I hate to be a pessimist. I really hate to be a pessimist. But hopefully she cares enough about the PR, the optics. I mean, a 5-point difference. And then if she were ever to tune into a YouTube chat and just see like, hey, can we move cases along faster? Can we give some attention to these other things that are sitting stagnant? All right. Maybe one day she'll take that to heart. I don't know. But a whole mess. Yeah, pessimism is life. So yeah, and that's the thing, you know, when you have the thick skin, sometimes, you know, having thick skin can be a good thing. It can keep you working, it can keep you from, you know, giving up on something that you're passionate and care about. But sometimes thick skin means you end up lacking the ability to do some self-reflection or have some self-awareness, right? So I'm a pretty pessimistic person as much as I can be optimistic. It's like, I don't know, it's like a duality. I've got a bit of both. FFS is out here also sniping more memberships. Thank you so much, FFS. Start Pushing Weight Again says, who is this Firearms ignoramus? Now, this is about an hour ago. I don't know if you were talking about Phil or Sarah. But man, Phil did not want to talk to Adrian Love. He was not with it. And she kept trying to ask him these small talk questions. Like, and what else did you sell? Your holsters? You sold a lot of holsters? Yeah, we sold a lot of holsters. Like, come on, guy. Come on, lady. Which is crazy. He did not want to be part of that mess. And when I'm saying, like, I'm doing my wink wink at the camera, I'm really not trying to throw shade at that guy at all. Right? Whatever he does or doesn't do, not really my business. Don't care at all. But as far as his testimony and my read of his answers, if I was sitting as a juror, a little bit of the way he was acting would seem like even if I did something, I wouldn't tell you on the stand. Which means I would probably disregard most of his testimony. So, for what it's worth, I thought that was a very awkward feeling in the room. Just because of what seemed like some kind of tension where Love didn't seem to understand that this guy wanted you to move along with the questions that you got to get to. You sold this firearm. Do you know who you sold it to? Did you modify the weapon? Did you put the switch on? That's really the meat and potatoes. And Love is just like dancing around the room. And notice she was at the podium this time. So that was just like such an awkward chunk of testimony there. Just crazy. But yeah, good to see you start pushing weight. Toothless Tiger, also good to see Toothless Tiger. We have 2.4K people in the chat and 612 likes. Please hit that like button. It is free 99. Kat is the goat at covering this case. I try, but you guys in the chat throw a ton of assists. Especially on firearm stuff. Because I was like, 9mm, I mean, if the jury is lost, I feel like they'll remember that the other calibers weren't 9mm. Even if they're like me and don't remember the specific calibers that were associated with whatever shootings we've talked about previously. I don't remember hearing anything about 9mm anywhere else in this trial, right? So I'm the ignorant one on that subject. I get assists from you guys in the chat all the time. But still, in a way, like, I like the idea of, hey, even if I don't know the specifics, I don't follow the details on that type of subject, if I'm still like, wait, this is kind of out of left field here, why are we focusing so much on this? 3 witnesses talking about this. You know, a bit of a question there. And then Red Bunny becoming a member. And I've had the same thing. Red Bunny, I had to update my credit card. That, and I've had, I forget what channel it was, but it's a channel that I think maybe it was Inside the Law. I kept getting gifted. And, you know, I never actually had to purchase it. And my membership expired. I was like, how did that? They always auto-renew. But when you get gifted a membership, if you don't actually switch it over, if you keep getting gifted a membership, it'll look like you've been a member 3-4 months, and then suddenly it'll cut you out. So I'm a newbie. I'm a rookie back over at Phil Holloway's show. Had to start back at 0 months. But yeah, updating that credit card. Appreciate you, Red Bunny. I feel like I've known you forever, even lurking in other chats many months ago. Always seen you around following this case. An OG for sure. Casey Dog says, not looking at your phone. She sounds like Paige. Yeah, the medical examiner had the same kind of way of pronouncing words, right? Kind of like a bit of the accent was the same, but also the same way of drawing out words. I think Paige has a bit of Valley Girl mixed in slightly there. And the Emmy had that going on as well. NC Tar Heel Mom says, happy hump day, everybody. See, we're all on the same theme today. All on the same theme. Let's see. Oh, was this? Okay, so I tried to watch this. I'm about 3 days behind on the Delphi trial. I did see this mentioned on X. I tried to watch Andrea Burkhardt's live coverage yesterday, watched a little bit, and then just felt like I'm going to go and watch it in order because this is going to fall out of place. I'm missing the other witnesses that testified before whatever happened yesterday. The defense has now rested their case, so we should get into any rebuttals and then closing arguments, jury instructions, deliberations. But interesting, so Big Baby Jane is relaying that an expert states a headphone jack was plugged into Libby's phone sometime in the middle of the night after the girls were deceased. Very interesting. Right, so was somebody in there trying to make sure things weren't on that phone still? Who had the phone and who put it back? That's an interesting case, you guys. Yeah, so Mike Jones says, who? Hey, Kat, I'm dying laughing. Think this guy's about to admit to a switch. Like, and he said, oh, I only know about it because of YouTube, and I wouldn't tell you. Like, I mean, those are the answers. I respect the answers. Respect him for, 10 toes down on the stand. But as a juror, if I was sitting there, I would make a determination that maybe we can't take that at face value. So, yeah, always every time I see you, gotta say Mike Jones. Our resident Mike Jones. Touche says the jury must feel gaslit for 157 days. Guys, can you imagine writing a letter saying that, look, I have concerns, I can't do this for another 3 to 6 months. I think that I'm going to have some bias because of the way that the state is presenting this case. And then the very next day they bring Love back after a little bit of a break from Love. And then we get that long questioning of this witness who was ready to answer the questions that you needed to ask him, and you just weren't getting there. So, oh my gosh. And I don't know, if you missed yesterday, you guys, the Hylton towards the end of the day said she expects that court will go, their case in chief, that they plan to rest next week, and if not next week, the week after. And that's including, there's no court at all tomorrow. So no court, figure out something productive and positive to do. We'll reconvene on Friday for a non-jury day. Monday is a holiday, it's Veterans Day. So that's not that many days left. And Hylton's like, oh, we don't know if we're going to call Martinez Arnold. We're not sure yet. That's Ashley Merchant's client. Today we find out that she seemed like she was going to call Sumlin soon, but now she's saying not until next week. Still have time on that. So maybe they're not sure on that either. And they're just trying to figure out their strategy, their game plan. I don't know. I feel like they could rest in the next week or two for real. I feel like they don't have much left. And again, a part of that I think sucks is maybe they don't care about the rest of this case now that the big fish pled out. So, I don't know. I don't know. Chloe Albert-Serven says the fact that the medical examiner sounded exactly like Paige is just not good for anyone's gray matter. Yeah, just the same way of pronouncing the words. I thought the medical examiner was a good witness. I just don't think, to me a good witness is credible. It doesn't mean a good witness for someone's particular argument. And I think the stuff that she was there to testify to, she's not there to give a narrative. And right out the gate, she said, well, we do have context when we're examining things, right? So as a medical examiner, and we're getting testimony from you, we have to be aware that there could be something that you're told that constrains the way you perform an autopsy, right? You might know of certain context at first. Oh, hey, there was a shooting. The victim was in a vehicle when the shooting occurred. We haven't apprehended anybody, but it looks like, there was a defect. There was a fired shot through the passenger side window. And that all could have been context that was already on this medical examiner's mind while she was doing her autopsy. However, she was aware that that context was there in front of her. And I think that makes you credible, right? We're acknowledging that there might be something that steers the way we look at things. And I don't feel like she was necessarily steered in either which way. So I think she was a very good, very credible witness. But we get the narrative. We're going to get the narrative when the detectives are called to the stand. So I think that's going to be Starks and Viverito. They're going to be the ones that say, well, look, based on what we heard about the entry, we concluded that it must have been fired from this car. And then we followed the license plate reader and decided, hey, this is the car that belongs to Shannon. So that's where we're going to get all of the hot mess, the tangled web. So... yeah, Mr. Meme, this is this is great, I think. My opinion, I agree with Mr. Meme here. Mr. Meme says it better, says what I want to say better. She was a good witness for a poorly prosecuted case. And I'd say perhaps poorly investigated. So... let's see... good point, destined to be. The judge will start excluding a lot of stuff to move it along. I mean, look at Thorpe yesterday. Look at Thorpe. Oh yeah, Betsy. I think, so I clipped the part with the only clip I've done so far today, you guys. I could clip the medical examiner if you guys think that'd be necessary to watch in the future. But I clipped Phil mostly because the tension in the room when he was on the stand, the move it along lady. And YouTube made the auto thumbnail love holding up the weapon. I was like, oh my God, YouTube's gonna hate me. But yes, Ian Runkle would have been yelling at her from the top of his lungs, put it down, ma'am. Oh my gosh. A whole mess. And the gun we heard about this morning, you guys, is the gun that was found in Jeffrey Williams' basement. Or, right? That was like a basement living room lounge. I don't really know the area of the house it was actually in. But it was that area where there was like the pile of the clothes on the ground. And then the Glock, when they tell us that the Glock had the extended magazine. And the issue is that it had the switch. The switch is why it's so big and scary, right? That can tack on extra time. Jeffrey Williams pled guilty to that. But they stuck that count on Jeffrey Williams, Martinez Arnold, and Diamante Kendrick, right? So it's still kind of relevant. The hot mess there, though, is like, if the jury's not piecing it together, the order of presentation here, we did have Schardt and, yeah, like Diamante Kendrick. You never saw this gun. You have no reason to believe that Shannon Stillwell ever had this gun. Doug asked the same questions. You have no reason to believe that Diamante Kendrick ever had this gun. No. How weird does that order of presentation look for the jury? Talking about the May 2022 search of Jeffrey Williams' home, if the jurors caught that and remember. And then we jump back to March 2022 with the back and forth between what the state alleges was, get back for Ford McMiller against Shymel Drinks, and then 2 days later, the Waters Road shooting was get back for the Shymel Drinks shooting. YFN versus YSL. It just seems like the state wants the jury to associate gun with a switch with the Shymel Drinks shooting. So... I don't know. STS has the great summary here for the jury's diary, the notes that they take. Today, love bored me. Another day with love. Same as usual. Like, I don't know. Okay, I think, so we're talking about Jeffrey Williams' house here, right? So Steven says there's no evidence that Shannon Stillwell has ever been at, I'm assuming, Jeffrey Williams, the Sandy Springs home. So, because they weren't friends or in contact. And yeah, love pointed the gun at herself and the people behind her. Oh my gosh. She's probably like, haha, look how goofy I am. I don't know. Loves typical hee hoo ha moments. McDonald's on Cleveland says, hi Kat, we reached out to you via an email for a brand deal. Please reach back out soon. And this is Jordy. Oh my gosh, this makes it even better. So shout out to Jordy. You guys know Jordy in the chat, but Jordy is the mastermind behind the McDonald's on Cleveland account, which has brought us a lot of joy in the last couple days. Great time. Thank you so much, Jordy. Loving this account. Also, you guys, this is a short recess. I'm gonna put this up on. There we go.
Is it possible? Yeah, because there's a gas leak at the corner of MLK and Piedmont.
Gas leak?
He's getting out of his car at walking.
Do you have another witness? They said they won't let him talk.
Paige is not
I
playing.
mean, if we hadn't taken our break, he'd be like 30 minutes late already.
But that happened, he would be there.
Do you have somebody else you can call?
Yes, sure.
All right, call somebody else. Let's get the jury out. Please.
Paige is not playing.
We're ready for the jury. That's all right. Take his time.
All right, I don't think we have much we're only like 13 seconds behind. So can't really skip all of this. Oh, hey, Granny of Five. If you missed this morning, straight out the gate, Whitaker said something and Love started arguing back, and Love's like, I'm not disagreeing with the court or anything. While disagreeing with the court. It seems like they might be crossing or walking a thin line with testimony relating to Antonio Sumlin. Either through Antonio Sumlin's testimony on the stand or Viverito on the stand.
Raise your hand. You swear affirm the testimony you give today, the truth, the whole truth, nothing but the truth?
I do.
Have a seat. And then you state, spell your first and last name. And then spell your first and last name. I'm sorry, pronounce your first and last name, and then spell your first and last name for the court, please.
Harshida Davis, Harshida, last name Davis, Davis.
And where are you employed?
I work for Enterprise Mobility, which operates as Enterprise Alamo and National Car Rental.
And how long have you worked for Enterprise Mobility?
23 years?
And are you here locally?
Yes.
Tell the jury briefly about your time with Enterprise.
So I've worked with Enterprise in several different markets. I started in North Carolina, in Charlotte, North Carolina. I have worked in the Chicago market, the Fort Myers market, and most recently here in the Atlanta market. I've been here for just over 5 years, and I manage the risk management program for all of Atlanta and Atlanta metro area and suburbs and north of Atlanta.
And if you can tell the jury, what does your group do as far as the risk management program?
So my department is primarily responsible for vehicle safety, security, investigations, compliance, and litigation.
And in your role, are you familiar with the official records of Enterprise Holdings?
Yes.
Right. And are those documents or records generated when an individual rents a vehicle?
Yes.
And are those records kept in a regular and ordinary course of business for Enterprise Holdings?
Yes.
Tell the jury, what are the documents that are generated when an individual rents a vehicle?
So we generally have the rental agreement, which would be signed by the person renting the vehicle. And then we also have documents that are generated once the rental agreement is initiated, documents that can be generated throughout the rental, within the computer system.
And when you're renting a vehicle with a rental agency, a part of Enterprise Holdings, are there security cameras and security footage at the locations?
There are typically security cameras at the locations. Not every single rental location in our company has security cameras.
And if there are certain facilities with surveillance videos, are those surveillance videos kept in a regular and ordinary course of business for Enterprise Holdings?
Yes.
Miss Steele.
Can you generally describe the rental process for an individual renting a vehicle with Alamo under the Enterprise umbrella?
So typically someone renting with Alamo where specifically, it would be different based on location. So I'm just wanting to make sure which location you would like me to.
Let's talk about the location at the airport.
At the Atlanta airport.
Atlanta airport, yes.
Okay, so at the Atlanta airport, an individual would typically, they could walk up for a reservation or they could book a reservation in advance. They would arrive at our counters at the rental car center, and we would validate the reservation, validate form of payment, as well as validate the driver's license for the person who would be renting the vehicle.
And when you say you validate the driver's license, what exactly do you do in order to validate?
We visually validate the driver's license, that it belongs to the person who's renting the vehicle.
And are cars with Alamo sometimes rented through third-party businesses?
Yes, you can book through a third-party agency, so there's different agencies that book rather than going just straight to the Alamo website.
Is the rental process different if you book through a third party versus going directly to the Alamo website?
It's not. The only difference would be the form of payment may be prepaid versus paid at the counter.
You talked about verifying identification. What identification needs to be presented to rent the vehicle with Alamo?
If you have a valid U.S. driver's license, we would just require you to present your original, true valid driver's license. If you have a foreign driver's license, we would need the foreign driver's license. If the foreign driver's license, we're not able to interpret it, we would require also an international driver's license be presented alongside the foreign driver's license, and then a copy of we would view the passport.
When individuals rent cars with Alamo, are they allowed to have a secondary driver?
You can add a secondary driver to the contract.
If the secondary driver is a spouse, do they have to be added to the contract?
We do not add spouses to the contract. Built into our contract, a legal spouse with a valid driver's license is able to operate the vehicle.
Now, if a renter approaches with an individual and they say that's their spouse, can they be an authorized user? Do you verify whether or not they are actually married or not?
We do not.
Now, with Alamo, with your fleet of vehicles, when an individual rents a vehicle from Alamo, are they allowed to tint or manipulate the vehicle in any way?
No.
We earlier talked about surveillance footage. Is there surveillance footage at the Alamo location Alamo rental location at the Hartsfield-Jackson International Airport?
Yes.
Generally, how long are surveillance videos kept at that location?
At that location, surveillance should be kept for a minimum of 60 days. Depending on how much data, you could get a little bit longer than that, but it's a minimum of 60 days.
And in your role, do you sometimes get requests from law enforcement to assist with law enforcement investigations?
Yes.
Now, earlier you talked that part of the risk management job duties is to ensure vehicle safety and security. How do you go about ensuring vehicle safety and security?
Well, we have a lot of internal processes in place, but there's also external laws and guidelines we have to follow in regards to keeping vehicles safe. And our job in our risk management department is to coach and train all employees that come through are hired on in the company to know, how to ensure that they are only renting safe vehicles, and how to properly inspect vehicles, and what condition they should be rented in.
I want to direct your attention to March 16th, 2022. Did a member of Alamo Security team get a request for documentation for a rental vehicle associated with a tag number of MD8ED7071 from the Atlanta Police Department?
They did.
Okay. And were you able to provide any documentation or any other information regarding that vehicle?
I'm sorry, what?
Sure. Were they able to produce any documentation to the Atlanta Police Department?
Yes.
And have you had the opportunity to see that documentation prior to your testimony today?
Yes.
Am I tripping, or was Shannon Stillwell detained on the 17th? Because the police showed up and responded to Waters Road. But I remember yesterday And it could be the attorneys mincing the dates, right? That's totally possible. But I remember Schardt saying, and on the 17th, you asked Shannon Stillwell about the 16th, and he told you he was present and people were shooting at the house, the Waters Road house. And that's when you asked him what car it was. So unless Schardt was getting the dates messed up, this I have notated as, now let's talk about the 17th. And I did the way I took my notes, I switched the days as Schardt moved along. You started asking about the 16th. So they already made the request for the tag to Alamo. But yesterday, they were acting like they only looked at that car because Shannon Stillwell told them it was his. And that's the only reason they started treating him as a suspect. I am telling you, he was detained as a victim and should have been Mirandized. I think this is hugely problematic.
Permission to approach her?
You may.
I'm showing you what's been marked as Stacy's Exhibit 186 VV and 187 VV. Tell me if you recognize those items.
I do.
First, start with 186 VV. How do you recognize 186 VV?
These are the rental agreement details for the rental in question.
And how do you recognize 187 VV?
This is the signed rental agreement that was initiated at the time of that rental.
And are these two documents, the rental agreement details and the rental agreement, kept in the regular and ordinary course of Alamo business?
Yes.
Your Honor, this time the state would like to admit Stacy's Exhibit 186 VV and 187 VV into evidence.
Those are admitted.
Okay.
Permission to publish.
Just a weird button on StreamYard. My bad. Let me share the screen. I have it paused so we didn't miss anything. There we go. And also to note that after Schardt asked a specific question to probe at, so you found out that's when you started treating him like a suspect, talking about the 17th or the 16th. Flores, the one on the stand that couldn't be shown yesterday, said, no, we connected the dots a few days later. But what are they doing here on the 16th? Independently.
And if we are able to zoom in. Looking at Stacy's Exhibit 186 VV, what document is 186 VV?
So this document is the printout of the rental agreement details.
Okay. And let's start from the beginning. What is the rental time and date for this vehicle?
So the rental time of pickup is March 14th, 2022 at 14:58 hours, and the estimated return time is March 20th, 2022 at 1500 hours.
Okay. And it's 14:58, 2:58 p.m.
Yes.
Right? And is there any other information contained within this first portion of the document of note?
Just the rental agreement number, which is our file number for this rental, the reservation number, as well as it does, the 258 timestamp is when the contract was started. And then the 3:07 or 1507 minutes just is when the contract was completed.
And is completion when it is actually signed?
It's when the vehicle is added to the rental and completed at the exit.
Okay. All right, I want to scroll down to the second portion of Stacy Exhibit 186 VV.
Look at
Now,
MLS
looking
showing
at
love.
the
Drop some
second
MLS in
portion
the
where it
chat.
has frequent traveler program, what information is contained in this second portion of 186 VV?
This is just information regarding how the vehicle was booked and what the rates, contract numbers are. But you can see where it says Priceline package, it's just saying that it was booked through Priceline.
All right. And going down to the next portion, do we see the license plate number?
Yes,
And what is that license plate number?
it's AED 7071,
And-
Maryland.
And are you able to see here what type of vehicle it is?
It does not state
I'm the one breaking it 'cause I'm
exactly
trying to
what
find
type
out
of vehicle
Lego
it is
law.
right here. However, it does, it provides the last 8 digits of the VIN, the vehicle identification number, and then it also states that it's a luxury car.
Okay. And within your luxury fleet at Alamo, are Audis a part of your luxury fleet at Alamo?
I'm sorry, what was the question?
Sure. You said it was a luxury vehicle.
Yeah,
Within your luxury fleet, is an Audi considered one of the vehicles that's a part of the luxury fleet?
correct.
All right. I want to scroll down. Who is the renter for this contract?
Shannon Bernard Jackson.
Right. And there's some information redacted. Would that be the information that would have been provided as a part of the rental agreement?
Yes, as part of this document, that information this section is the contact information for the renter.
Okay. Scrolling down. And let's start at the beginning of the note section. What information is generally contained within the note section of this rental agreement detail?
So it's just your basic information when you first pick up the vehicle. It tells you if any products have been added to the contract, just what's been done to initiate the rental.
And looking at 258 on March 14th, 2022, what, if any, information was provided within the note section?
There's an alert that came through that, we needed to verify ID and payment method,
All right.
which is standard.
I want to scroll down to March 16th, 2022 at 13:36. What, if anything, happened on March 16th, 2022?
So it appears that the renter contacted our customer service department and extended the rental. The customer service department provided a new rate, a new extension date for the contract, and indicated that the renter agreed.
Okay. And is it fair to say that the initial agreement was for March 14th through March 16th, but then on March 16th it was extended to March 20th?
Yes.
Is there any other information contained on 186 VB? You can scroll.
No.
No,
There is, I think you skipped over the section in the personal information. There's a little section of just that does provide a driver's license number for the person renting the vehicle, but it was blacked out.
okay. And would that have been verified like we discussed earlier?
Yes.
All right. Now looking at 187 VB. Looking at State's Exhibit 187 VB, what is 187 VB?
This is the signed rental agreement that was initiated at the time of the rental.
All right. And does it contain some of the information that was in the rental agreement details that we just looked at?
Yes, it does contain some of the same information.
Now, what was the address of the rental location where this vehicle was rented from?
2200 Rental Car Center Parkway in College Park.
And is that your Atlanta Airport location?
Yes.
And what, on here, does it tell us what type of vehicle was rented on the rental agreement?
It tells you the type of vehicle, and it does tell you the rental information. It doesn't actually provide the VIN on this document. It provides it, it's in the rental agreement details.
All right. And I want to scroll down to the middle. Is this the document that would have been provided to Mr. Jackson at the facility when he went to go pick up the car?
Yes.
All right. And looking at the signature lines, is it signed SJ?
Yes.
All right. And then flipping to page 2 of the document. Is there a final signature at the bottom of the page?
Yes. Yes.
And generally, what is the renter agreeing to by signing this document?
The renter is agreeing to our terms and conditions of the rental contract.
And would the terms and agreement include not manipulating or adding tents to the vehicle?
Yes.
All right. Now, at the airport facility, does that facility have surveillance video?
Yes.
Okay. And as a part of the request from the Atlanta Police Department, were you able to provide surveillance images for this rental?
Yes.
Commissioner Approach, you may. I'm showing you what's been marked as State's Exhibit 189 VV and 188 VV. Tell me if you recognize 189 VV and 188 VV.
Yes.
How do you recognize them?
They're screenshots from video footage from our camera system.
And those, do those appear to be a fair and accurate depiction of screenshots from the surveillance images from the rental on March 14, 2022?
Yes.
You're right. This time the state would like to admit State's Exhibit 189 VV and 188 VV into evidence.
Those are, thank you, admitted.
First, we're going to publish State's Exhibit 188 VV. When a renter, while we're waiting for it, when a renter calls in or requests for a vehicle extension, do you ever ask for a reason for the vehicle extension?
No, it's a pretty common practice.
All right. Looking at State's Exhibit 188 VV, can you tell the jurors where at the Alamo, is this the airport facility? Is this the Alamo Airport facility?
Yes.
Okay. Where would this surveillance video image be captured?
At our exit booth.
Okay. And looking at the exit booth, do you see a young woman in the driver's seat?
Yes.
And are you able to see anyone from this picture in the passenger seat?
Yes.
Okay. Are you able to tell City here if that's a male or a female?
I think it's a male.
Okay. All right. And what is happening generally when this images is being captured?
There, when the renter completes the contract, they go out to the garage where they select a vehicle. And so at the exit booth, the vehicle is then added on to the contract. And they just, have to show the information that they were given at the counter. And this is where the completion of the contract happens.
Do you have to show your driver's license again at this particular portion of the rental process?
They may request it.
Now I want to show you what's been admitted as Exhibit 189 VV. Where is this image being captured?
So this is at our counter, at the Alamo counter that's located in the rental car center.
And would this generally be the beginning of the process to rent the vehicle, or to pick up the vehicle, I should say?
Yes.
Now, to your knowledge, was this vehicle ever returned to the rental facility on March 20th, 2022?
It was not.
Did you ever recover this vehicle?
We did.
And where was it recovered?
It was recovered from the police.
And when vehicles are recovered, do you take pictures of the vehicles once it's returned back to Alamo?
We will if the vehicle is damaged or it has any change of condition from when it was rented out.
Okay. Permission to approach again, Your Honor?
Ma'am.
I'm showing you what's been marked as State's Exhibit 176 BV through 185 BV. I want you to take a moment and look through the. Do those appear to be fair and accurate depictions of pictures that were taken of the vehicle when it was recovered and brought back to Alamo?
Yes.
Your Honor, this time the state would like to admit State's Exhibit 175 BV through 188 BV.
Okay, before you said 176 through 185, what is it really?
Yes, Your Honor. Sorry, 176 through 185.
Okay, those are admitted.
And first, I want to start with State's Exhibit 185 VV. Looking at State's Exhibit 185 VV, is this the vehicle that was rented to Shannon Jackson on March 14, 2022?
Yes.
And in looking at State's Exhibit 185 VV, do you notice anything different about the vehicle when it's returned to Alamo?
The vehicle does have a significant just amount of tint on it.
And where do you see that significant amount of tint on it?
In this picture, I can see it on the windshield.
And would Alamo have had any tint on the vehicle when it was rented?
We do not tint our vehicles.
I'm going to show you what's been admitted as Exhibit 176 VV. I'm going to show you 184 VV and 180 VV. Do those pictures also show a similar level of tint on the vehicle?
Yes.
And sitting here now, do you know when that tint was ever put on that vehicle?
I do not.
Hylton wanted her to say, when Shannon Jackson had it.
Now I want to show you 182 VV. (183) VV. And 177 VV.
That type of mess looks like somebody was ripping that car apart to try to find something. Who does that? Who rips cars apart to find things?
First, let me ask, where is this facility, or what facility is this where the car is?
So this facility is located at 4100 Global Gateway Connector. It is at our service center lot where vehicles are taken after, you know, they've either been towed in from being damaged, or they need to be serviced, or, you know, returned by the police if they were involved in an investigation. It's not the rental car center. It's an off-site location at the airport.
And in looking at, again, 182 VV and 183 VV, do you see any differences on the inside of the vehicle that would not have been present when the car was first rented?
Yeah, I mean, you can see where the headliner's down, parts of the vehicle have been dismantled. Appears that the windshield was taken out. So there's just different things that have happened to the vehicle.
And I want to look at 183 VV. You just mentioned the headliner being taken out. Looking at 183 VV, where would the headliner have been prior to it being removed from the vehicle?
It just would have been surrounding what is like the sunroof up there, where I guess it's just hard to describe, but that area. Can I point?
Yes, you can. Do you have a statement?
I don't know, but. Thank you.
And you can stand.
So this is where you can tell that something's been removed. You know, that was originally there.
All right, thank you. You can take your seat. Now, I want to go back to the tent. To your knowledge, did Mr. Jackson ever request or ask anyone at Alamo if he could have an exception to the rule and tint the vehicle?
No.
If he would have called and made such a request, would one have been granted?
No.
Course indulgence for one moment. Looking at 172 VV and 173 VV. And the item that we see on the ground, this Scott item, is that just an item that's in the facility?
Yes. It appears that it's just a piece is leaning up against it, and that would just be stuff that we have in our service center.
Okay. Now looking at 179 VV. What is contained in 179 VV?
So this is the dash of the vehicle, and this is just a typical picture that we take whenever we're taking pictures of a damaged vehicle. We would take this standard picture of the odometer.
All right. And as I wrap up, going back to State's Exhibit 186 VV. The driver's license information that's contained on this document, would that have been the driver's license information of Mr. Jackson?
It would have been the information of Mr. Jackson as the renter of the vehicle.
Okay. And then my last question, when we looked at the tinting on the vehicle, were all of the windows significantly tinted?
I don't have the pictures right in front of me, but based on what we just reviewed and what I've looked at, yes. Yes.
Court indulgence.
It appears that all of the windows are tinted.
This is her close, and she wants the word tint to ring out loud to the jury. So the word tint sticks to the jury. To me, that signals that's the worst thing that's to come out of anything that we just saw. And I don't think she was very clear. She did ask for where is this car located when it's all torn apart. And the witness gives an address. But how clear was it to you guys that that could have been a facility where that actually was taking place? To me, it's not clear. They're not touching the line of where that car could have been, right? It was returned to them at some point by the police. That's all we know. So Hylton, after all of that, is showing this picture of the car torn apart. And the worst she can say to the jury, if this is going to be her punchline, if she's about to pass this witness, is remember the tint. Remember the tint.
Court indulgence for one more.
Which he could have removed if he was able to have the car and return it himself. Heck yeah, and I know Schardt's going to reference the tinting testimony, and I hope Hylton tries to object.
Yes, Your Honor.
Heck yeah, let's
Ms.
go,
Davis,
Schardt.
Good morning still. My name is Max Schardt. I represent Shannon Stillwell, okay? All right. And let me just, Shannon Stillwell is also known as Shannon Jackson. Okay, so Shannon Jackson, I may say Stillwell, Jackson Stillwell, same person, okay?
Okay.
All right. Ms. Knight, would you do me a favor and just put up 189 VV? Thank you. Ms. Davis, if I ask you any questions about specifics, I'm going to have this picture published, but just let me know if you need to refer to any of the other documents in front of you.
Okay.
Such as the rental contract, et cetera, okay? All right, so as I understand, Mr. Jackson, or I'm going to say Mr. Stillwell. Mr. Stillwell came in to rent a car on March 14th at approximately 3 p.m. Is that correct?
Correct.
Okay. Was that car, do you know if that car was already booked online or if he just, with his friend, arrived at the counter to rent this car?
Based on the information from the rental agreement, it appears that there is a reservation attached to the rental.
When was that car reserved?
I do not have that information.
Okay, so we don't know when the online reservation was made. All right.
No.
State didn't ask.
Okay, so Mr. Stillwell shows up with this, do you know this lady's name?
I do not.
Okay. So he shows up with this lady and to pick up his car that he booked online, correct?
It appears that way.
Okay. He came into the Alamo rental desk where there's surveillance videos himself. He didn't send someone else to come pick up the car, did he?
I don't believe so.
Okay. He provided his name, correct?
Correct.
Okay. And I know certain things were redacted. He provided a address from his license.
Correct.
He provided a telephone number.
Correct.
He provided his license.
Correct.
He paid using a credit card, correct?
He had a Priceline reservation, so he would have had a credit card on file, but likely it was prepaid through Priceline.
Okay, so he had a credit card on file.
Mm-hmm.
Okay, all that information was presented and known by Alamo when he came to pick up this car that he reserved at some other time earlier, correct?
Correct.
All right. And he signed the rental agreement, correct?
Correct.
In his real name.
Correct.
All right. So then, and that was, he picks up the car on March 14th at approximately 3 p.m. And then on March 16th, he recorded the records, and I know you were not on the phone personally, right?
Correct.
All right, but you're the custodian of records. According to the records, he calls on March 16th at 1:37 p.m. and wants to extend the rental on this white Audi, correct?
He did call. I might have to refer to the document to confirm the time. Yes, at 1:36 p.m.
1:36 p.m.
Now-
ET.
We'll talk about the tint. Ms. Knight, could you put up a picture of Kyle with the tint? Okay. When you received this car back from the police on March 20th, right? 2022? Was it March 20th you received the car back?
I don't know the exact date it arrived on our lot. March 20th is the estimated return date of the rental, but the vehicle wasn't returned through the normal return meet.
Fair enough. Don't worry about the date. When you received this car back from the police, right?
Yes.
Okay, it had tint on it.
Yes.
Okay. And tint was a violation of the rental agreement, wasn't it? Applying tint to the car.
We do not allow folks to alter the vehicle.
Mr. Stillwell violated assuming he applied the tint to the car, he violated the rental agreement, didn't he?
Yes.
Okay. Did you charge him with any crimes?
Violating a rental agreement, I did not charge him with any crimes.
Right. Okay. It was just a rental agreement, right?
Correct.
Okay. Are you aware that prior to renting a car from you, 2 separate attempts had been made on Mr. Stillwell's life?
Objection, Your Honor.
It's in evidence.
Objection, what's your objection?
It's not an evidence, but it
Were
is.
you aware, when you came to testify, that 2 different attempts had made upon Mr. Stillwell's life?
I was not aware.
Were you aware that one of those attempts on his life was made when he was in a car?
I was not aware.
Okay. Ms. Knight, if you could please display 172 VV first. Okay, I just want to be clear on this. This picture, and maybe, I'm sorry, Ms. Knight, maybe 173 would be better. Okay, the purpose of this picture is to show, and we're going to get to the headliner in a second, but when you received the car back, the sunroof, is it moonroof, sunroof? Whichever one it is.
Yes.
Okay. Had been damaged somehow before you got the car back.
Yes.
Okay, and you don't personally know if that was damage done by Mr. Stillwell or done by the police when they were manipulating the car. That's fair to say?
Correct.
Okay, and the purpose of this photo is just to document the damage to the glass in the sunroof.
Correct.
Okay, and I just want to be clear what we're talking about. These other supplies, those are just supplies that were in the Alamo business, wherever this was, a storage facility, and not anything more than that.
Correct.
Okay, cool, thank you. And if you could just put 183. And again, this is the condition you got this car back from the police, correct?
Correct.
And you're familiar with the term headline?
Correct.
Okay, and the headliner had been removed, correct?
Correct.
Okay. I have one brief moment.
There you go, Lois. Damage from removing the headliner.
I have no further questions. Thank you, Ms. Davis.
Thank you.
Anything, Mr. Weinstein? No question. Any redirect?
I'm going to show you part of what's been admitted as the 170 VV. Tell me if you recognize 170 VV.
I do. I do.
It was 170 VV.
It's the invoice that we received when we had to pick up the vehicle from the police and have it towed back to our facility.
And what is the date on that document?
March 24th.
And would that be when the vehicle would have been returned back to Alamo?
Yes.
Mr. Schardt asked you a series of questions regarding potential attempts on Mr. Jackson's life. Do you know if he has rented any other vehicles between 2015 and 2022?
I'm not aware.
Probably weren't asked to look.
Sitting here today, do you have any idea why a renter would put substantial tint on a vehicle that they were just renting initially for 2 days?
Oh, she's asking if she knows. So if you know, then you can answer.
Want me to repeat it?
I have my, I mean, a renter would,
Sustain,
I'm not saying
sounds like
don't
she does
speculate.
not know.
yeah.
All right. Think I have no further questions.
Any recross?
Sure, I'm sorry.
Oh, that's all right. Go ahead.
During the course of your time with Enterprise, how many cars have you had that may have had their headliner removed?
I wouldn't be able to answer that question.
Okay. Thank you so much.
Recross? All right, thank you for your time. You are excused. Do we have another witness that won't take us more than 30 or 40 minutes?
Is the other witness here?
How much time do you need?
I mean, 40 minutes?
Oh,
Okay, call your next witness then.
We're going to call Tyler Bateson, Your Honor.
Okay.
love for direct. So we'll hear more about this car. We'll hear more about this car and what they found, probably through Starks or Viverito or maybe some other APD officer. That's not the end of that, you guys. It's just you can't ask this rental lady about stuff that she wasn't there for.
Your Honor, can we approach before we begin on this witness?
Oh, the SWAT
Do you want me to
people.
have the witness step back out, or does it matter? Sorry, thank you.
All right, so are we skipping back to, are we going to be jumping events? Who is the SWAT guy? 250. They approach the bench. This is, guys, to me personally, this is suspenseful to me because a lot of where I think these pieces are going to weave together, right? These witnesses are just bringing us like kind of like tangible, but supposed to be objective things. They're introducing objective things into evidence. But when it comes to the detectives, that's where we're going to see shots fired from both sides. This is our narrative. This is what we think happened. How could that be? That doesn't make sense. And I'm really excited to see. I guess this will probably spell out across today, Tuesday, Wednesday, right? Where we get into the actual, how is this all supposed to fit together? Well, it couldn't fit together because that wouldn't make sense this way. So this is big suspense in my opinion. I'm excited to see where this goes and how state tries to hold it together. Also, Angie Lay, thank you earlier, gifting a membership. Very nice of you. As soon as we started talking about surveillance video here, KC Dog said, in walks Brian Steele. Did someone say video? Yeah, missing Brian Steele for no reason whatsoever. And let's see if we get any indication about what this approach was all about. You know, sometimes it's not related to what's about to happen, but often, hey, before this witness actually takes the stand, can we clarify something that relates to this witness and potential testimony? Fashionably Fit Life, I agree. They're weaving the stuff to confuse the jury, to think it's all related. Because in their minds, everything is related. All the time and only can be related.
You raise your right hand. You swear affirm testimony to give the truth, the whole truth, nothing but the truth?
I do.
Absolutely. State the spelling of your first last name for the court's group. Now into that mic.
I'm Tyler Bateson. Tyler Bateson.
Good morning still, Mr.
Morning.
Bateson. How are
Morning.
you?
Good, how are you?
I'm good, thank you. I see you have on a shirt with markings. Where are you currently working?
Forsyth County Sheriff's Office.
Did she
All
steal
right.
Schart's line?
How long have you been with the Forsyth County Sheriff's Office?
Approximately 7 years.
All right. Do you carry a service weapon or firearms in your position with the Forsyth
Yes.
County Sheriff's Office?
Yes, ma'am.
What is your position with the Forsyth County Sheriff's Office?
I currently work patrol, uniform patrol division.
Now, are you a gun owner outside of your work with the Forsyth County Sheriff's Office?
Yes.
And how long have you been a gun owner?
Probably since I was 18.
Since you were 18?
Yeah. I'm currently
If I
29.
ask you how old you are now?
29.
All right. And how long have you been with the Sheriff's Office?
Approximately 7 years.
All right. What types of firearms have you owned during your time with the Sheriff's Office?
Like assigned to me from the Sheriff's Office or just owned in general?
Owned in general?
All kinds. Bolt action rifles, semi-automatic rifles, semi-automatic pistols, all kinds of weapons.
And have you ever traded firearms or sold firearms that you owned
Yes.
privately?
Yes, many times.
Where typically do you sell those firearms?
We sell them locally in Georgia, if party to party. We just show concealed carry permit typically and sell firearms privately. Usually I use a website. One of the common ones I use is called the Outdoors Trader.
Outdoors Trader?
Yes.
Okay. Now, do you ever trade or sell your service weapons?
No.
You only sell the ones that you personally own?
Correct.
All right. Do you keep a record of the firearms that you personally own?
No, not really. If I have them, I will. Once I get rid of them, I don't really.
Okay. I'm going to show you what has been marked as State's Exhibit 229 Victor Victor. That has been provided, but I'll let the defense see what it is that I'm walking up to you with. If there's a part that is, can I name the defense briefly? Is there a part that you want to know?
No, this stuff's supposed to be done before we get the witness on the
Is this the only
stand.
part?
Paige, sorry, Whitaker.
Okay. So, Your Honor, I think that a part of it was attached that should not have been attached.
Okay.
And I don't think that there's anything beyond this page that there's an objection to, is there? Okay.
Not now.
Okay.
I appreciate the opportunity.
That was a mistake. Showing you State's Exhibit 229, Victor Victor. All right. And asking you if you recognize 229 Victor Victor. Do you recognize what that document is?
Yes, I filled out multiple of these before.
And that particular one, is that one that you filled out personally?
Yes.
Would you look at it and tell us if that is a fair and accurate representation of the document that you filled out?
Yes.
Your Honor, the state tenders State's Exhibit 229 Victor Victor as evidence.
It's admitted.
Would you tell the jury what 229 Victor Victor is?
Yes, this is a form that you fill out when you're purchasing a firearm from a dealer. Basically, they fill out your personal information, some questions to qualify you to own a firearm, and then they do a background check right there, and then they can transfer you the firearm. So it's a transaction record.
And that transaction record, does it have on it the type of firearm it is that you're purchasing?
Yes, it does. It has the serial number as well.
And were you the purchaser of that firearm?
Yes.
All right. What type of firearm is that a transaction record for?
This one is for a Glock 45. Okay. The model is 45. It's in 9mm.
Glock 45 9mm?
Correct.
And what is the serial number on that weapon?
BPHW105, Bravo Papa Hotel, Whiskey 105.
Are you familiar with whether or not the serial number on a firearm barrel typically matches the serial number on
The slide.
this? Yes.
Yes. Yes, it does.
And when you purchased that firearm, did the serial number, did you check to see if the serial number on the barrel matched the serial number on the slide?
Yes, and it was brand new from the factory as well, so it would been how it came from the factory. So.
Okay. I'm going to now approach you with what has already been admitted as State's Exhibit 51XX Alpha, which has been made safe. Would you take a look at State's Exhibit 51XX Alpha and tell me if you recognize any part of that firearm?
Well, most of it. I can't see the serial number on the barrel because of how it's fashioned right now, but the serial number on the slide matches the one on the form. I do not recognize this part on the back of it.
Now, you're holding it in your hand and you pointed to the serial number on the slide.
Correct.
Would you hold it up for the jury and just point to the area where that serial number is? And what serial number are you reading off the slide?
It's BPHW105.
And when you say you recognize the serial number on the slide, but you don't recognize the serial number on you can't see the serial number on the ballot?
Correct.
All right. And you also said you didn't recognize a portion of the gun that was on the back.
Yes.
Which part?
This extension coming off the back. That's not factory. I believe that's a bang switch. I've never actually seen one in real life until now, but I believe I know what that is. So
is it safe to say it wasn't on there when you purchased it?
Oh yes, it's just not there.
Okay. Do you remember how long ago it was when you purchased that firearm?
Well, can I reference the form?
Yes.
Okay. Yeah. So this was 2020. It says. Yeah.
You purchased it in 2020?
Yes, 7/25/2020.
All right. And did you purchase it for personal use?
Yes.
All right. I'm going to swing back around to the serial number that you read off when you were reading the transaction agreement. You said BPHW105, and then you said Bravo Hotel Whiskey 105.
Bravo Papa Hotel Whiskey 105. BPHW105.
All right. Thank you.
Mm-hmm.
Did you ever sell that gun to anyone?
Yes.
Who did you sell it to?
A gentleman named Phil off the Trader. He's another popular member on the Trader. He has a lot of positive feedback, and so I met with him. I believe it was March 9th of 2022.
Okay. And when you sold it, was it in the same condition that it was when you first bought it?
No, it was, it had, actually, I believe it had night sights on it. This one has the factory sights. So it had different sights on it, or maybe it came in the box. I know I sold it with extra sights and 3 magazines when I sold it.
Okay.
So I can't remember exactly if it was, but I didn't change any internal parts, just the sights, if anything.
Okay. Is there any way for you to, you said you couldn't see I'm going to take this. You could not see the serial number on the barrel.
Yeah, from how it's positioned right now.
Okay.
Actually,
Now,
there should be something on the bottom too.
See?
Yeah, that serial number is also the same, BPHW105.
Now, if that serial number on the barrel is different than the serial number on the slide, would that be a barrel that was sold with the gun at the time that you bought it?
No.
All right. And would that be a barrel that you sold to Mr. Norton or Phil?
The serial number would have matched the slide when I sold it because I did not change any internal parts on this on the firearm.
Okay. Just one moment. And when you said Phil, do you know whether the last name of the person to whom you sold the gun was Norton?
I'm assuming it's Norton because his handle on there is Norton Concealment from the Outdoor Trader, and he addressed himself as Phil.
Okay.
I glanced at as a concealed carry permit, but I can't remember exactly what it was, so I'm assuming it was Norton.
All right. Thank you, sir. I think that's all that I have for now.
Okay.
Thank you, Judge.
Questions from the defense for this witness?
No questions, we have still. Some questions.
All right.
Thank you.
I'll leave this out unless you want to do that.
You can do anything you want to with that. Thank you. Good morning.
Good morning.
Good afternoon, I guess.
Yeah.
I'm sorry, I didn't get your rank.
Deputy first class.
Okay,
So,
okay. Deputy Bateson, I'm Doug Weinstein. I represent Diamante Kendrick. Okay. I just have a few questions.
Yes.
As you looked at that weapon, you see that it's been modified with a blank, is it?
The
Anyway,
switch?
Switch on the back, yes, correct?
Yes.
And you
So you
say
know
you
what
did
it
not
is.
modify that weapon, correct?
No.
Okay,
Other than the sights, I may have changed the sights at some point. I couldn't remember off the top of my head. It's been 2 years. So.
right. You don't know who modified that weapon, correct?
No.
You don't know that if my client, Mr. Kendrick, modified that weapon?
Oh, I don't know who possessed it after I sold it, other than Phil. But that's no.
You have no knowledge that Mr. Kendrick ever possessed that weapon, correct?
I don't know.
And you have no knowledge of Mr. Kendrick, that Mr. Kendrick may have ever fired that weapon, correct?
I do not.
Okay, thank you. No further questions.
All right, redirect.
Just briefly. Do you even know Mr. Kendrick, Diamante Kendrick, the defendant sitting over here?
I do not.
Okay. Would you have any way to know whether he fired that weapon?
No.
And do you know Shannon Stillwell?
No.
And were you anywhere near the home of Jeffrey Williams on May 9th, 2022?
No.
Thank you.
Sounds like he didn't sell it to those two that
All
are in the
right,
room.
yeah, go ahead.
Do you have any reason to believe that Shannon Stillwell was anywhere near the home of Jeffrey Williams the day it was raided?
I don't know anybody,
You
so I
have
don't know. I sold the gun. That's pretty much my involvement. I don't know anything.
I
so-
appreciate that.
Okay.
Thank you.
Okay.
All right, thank you for your time, and you are excused, and we'll take our lunch break now.
Thank you, Your Honor.
Yeah, Miss
Let's be
Candy,
back at
I agree.
1:15, please.
All right, so they're gonna do their lunch. That's gonna be a bit longer. I know we had a.
Oh, yeah, that's fine, thanks. Sorry.
Yes, unless there's anything anybody needs to put on the record, I'll see everybody at 1:15. Thank you.
Right, so they're not gonna do nothing to argue big, fireworks over lunch. I thought one thing we could look at is, and I don't know the exact term, but the Supreme Court in Massachusetts, like the Commonwealth, there's a different acronym for it. I'm going to get it wrong. But we had a good time watching the appeal in front of the Georgia Supreme Court yesterday, watching the questions the justices asked. So I thought it might be interesting if you guys are down for it. We could check out an appeal argument in the Karen Reed case up in Massachusetts. So if you guys want to do that for a little bit, help us pass the time through lunch. That's one option on the table. I don't really have much going on with this. I agree here with Miss Candy. This guy wasn't Bateson. Doug establishes, like, you don't know Diamante Kendrick. And then Love gets up there like, haha, yeah, you don't know him, right? But at the same time, if you're bringing up these witnesses and you're eventually trying to establish that somehow this firearm came into the possession of somebody, I wouldn't want to be highlighting that your second witness that's had possession of this gun at some point has never been the person that has ever seen these people, right? You would think you wouldn't want to highlight that, right? We understand that there's a possibility just because you sell a gun to somebody doesn't mean they're going to be the end user. They've established previously, prior years, back in the 2015 era, through 2017, that Quindarius Zachary was kind of the person that would procure weapons and wrangle them around to different alleged YSL associates, right? But now we're speaking about 2022. So unless Love is just expecting that the jury's going to infer out of thin air that, all right, somebody else is getting these guns and just giving them to these guys, why would you highlight, underscore, that, yeah, I didn't give them to those guys, I don't know who they are, because you're trying to prove that they're the ones that were in possession of something, at least Diamante Kendrick. Shannon Stillwell is not listed in the indictment for having possession of this Glock with the switch in May of 2022. But Yak, Martinez Arnold, and Jeffrey Williams are. So, I don't know. I don't really think that redirect was necessary there. Big thank you again to lots of gifts in here today. Tat Flocker became a member and also said, look, I'm going to bring a +1, which is super nice. So glad to have you here, Tat Flocker. MLS, so you guys saw me say I was dropping 2 different links in the chat. MLS is an actual attorney, but he also does a Lego show, right? So I'm going to share 2 channels again. The first link is, we'll call that the main channel, right? I don't want to say it's the law channel because he talks about law with Law and Lego. But the second is a Lego and law conversation style show where different panelists get together, and it's usually 4 panelists, and they build Lego while they talk about things that are happening, often with a flavor of, legal commentary, what's going on in the law nerd space. So Andrea Burkhardt's been a guest, Nick Starrow's been on there, tons of familiar faces. So the second link here that I'm calling Lego Law is that channel. I was invited to be a guest, but I have commitment issues, so eventually one day I will be on there at some point. Love to you, MLS. Thank you for the invite. Ike says, I've been a member for 2 months. Only have 98,000 more months to go. Oh my goodness. And I'm going to bring someone with me. Look, Ike is bringing someone along for the ride. Thank you so much, Ike. Super nice. And always love to have you here in the chat. Not only are you very funny, but you also give me a lot of assists with some of this firearm stuff that I don't know all that well. Although I do know Love was looking like a goofball, like shuffling the firearm all around, like hot potato or something. Kiki, good to see you. Thanks for being a member for a month. Hey everyone, sending love today. Love right back to you. Touche says 2 choppy and 2 in the weeds. If it weren't for Catnut Williams' summary, I would have forgotten the state's theory on this. And this is in reference to this March 2022, the back and forth shooting, right? All this Glock conversation is related to the May 2022 search of Jeffrey Williams' home. All the other stuff is related to March 2022 shooting of Shymel Drinks with Quamarvius Nichols, Miles Farley, Shannon Stillwell, and Demikian Garlington. Brain's getting a little mushy there. Right, so we're talking about 2 different things today and going back and forth between these witnesses. But the state's theory with Shymel Drinks, remember guys, is the Ford McMiller shooting on March 12th, the riddled with bullet call that came the day after, that Atkins argued for admissibility as excited utterance, even though it wasn't in the heat of the moment. They were so panicked because they just found out their car was riddled with a bullet. So it still technically should come in under an excited utterance exception. Then on the 14th, you have the Shymel Drinks shooting, and then the 16th, you have the shooting at the Waters Road incident, where the state alleges that Shannon Stillwell, using a device, a handset associated with DeMarco Boyer, is whispering on the phone with Demikian Garlington while this shooting is like just ending, and they're like hiding in the crawl spaces or whatever of this Waters Road house. The state's theory is that it's YFN and YSL shooting back and forth across these days. So that's the theory there for that. Highly recommend. I pulled a clip yesterday for day 117. I wonder if I threw it in the description of this video. I shared it on X. Highly recommend going back and rewatching day 117. And maybe if this appeal thing with Karen Reed is short, we can get that in there as well. But it's where they argue these evidentiary issues about that crawl space phone call and the search warrant issues. And Marissa Viverito is going to be, I'm sure we're going to hear a ton of cross-examination on these search warrants executed at the Waters Road house. Because that's where Love had that hot mic moment. They removed everything before the police searched the home. She hot mic'd. But what did we hear yesterday from Detective Flores? That even the backpack they recovered with narcotics in it from somewhere outside the home, they never charged anybody in this indictment with what they found. It doesn't seem like they actually think, whether it was removed from the house or not, that the stuff actually belong to anybody named in this indictment. So, a little bit of a problem there with the state's own theory. Where was this link? All right, so this link I'm dropping now is the day 117. We might watch it during the lunch break. And I saw a bunch of people like tagging Max. I have no doubt that Max is fully prepared, has all these details and ducks in a row, these contradictions in a row, and it's one of the reasons I'm so excited to see Cross with Viverito and company play out. So it is confusing, Touche. It is confusing, but that's their theory. Ashley Linnell says, Kat, if I was Schardt, if they took his deposit, they wouldn't have taken it if it was manipulated. They would keep the deposit. I was in HR when we acquired National and Alamo. They get vehicles from other states. And Ashley, the problem here is it seems to me that APD, who filed the request, and then also the district attorney's office in the course of their investigation, it seems like they didn't request all that much. They wanted the copy of this paper rental agreement and the surveillance of when they're in the lot driving the vehicle and at the desk to sign out and pick up the vehicle, right? And then we see even on redirect, we only get the towing invoice to show when the vehicle was returned because Love suddenly seemed like she needed to punch back at Max Schardt. I don't really think it moved the needle at all for Love to get up on redirect, or maybe it was Hylton, I don't even know, and say, look, what does that invoice say right there? Oh, the tow was sometime around March 24th, 2022. The point is that it wasn't Shannon Stillwell who returned the vehicle, and we don't know what happened to the vehicle and the condition of the vehicle between when it left the lot and when it got back to the rental company. If it was torn apart only on the inside, and then, of course, we have Schardt elicit, nothing criminal, right? There was no vandalism. We didn't ask to press charges against Shannon Jackson, when he returned this vehicle. So I think that's going to get ripped apart when we have whatever officer gets on the stand and tells us about looking at that car, impounding that car. That's the right witness for Schardt to really attack. And I cannot wait for it. So I agree, Ashley. Big questions there. And I think it comes down to the state being selective with what they're trying to procure. And APD being selective with what they're trying to procure in the course of their investigation. Angie says, maybe that's where they lost the watch. Oops. That dang watch. That pesky watch. And this is true too, Ike, right? He could have rented the car and it could have looked like that on the inside if they only have the picture. I mean, I don't really think the mirror was hanging in that picture that they were driving, but, But true. Yeah, KC Dog says, all right, Love, just take me to jail for tinting a car. And that's the thing, I really want to underscore this, and I'm super appreciative of having the chat because the anecdotes matter. There's several people sharing in the chat. I'm familiar with it too. People will have rental cars for a very long time, and they'll just keep extending it and extending it and extending it and extending it. It doesn't necessarily mean anything weird if somebody extends a rental. It doesn't necessarily mean something weird if somebody treats a rental like it's the car that they own. Would I do that personally? No. I'm not going to treat a rental car like I own because I'm too lazy to have to get together and clean it up before I return it, right? I'm always thinking I don't want to be doing extra work when I have to return it, so let me not destroy, damage it, make a mess out of it while I'm using it, right? But I know plenty of people. I have a good friend who had this SUV for the longest time, and suddenly one day she got a different car, and I was like, you got a new car? And she's like, well, it was a rental, I swapped it out. I'm like, you've been driving this for months, girl. What are you doing? And the tint, he could have taken it off if it was in his possession when he returned it. So I get that there is a possibility that people do stupid stuff in cars that can be traced back to them, right? That is absolutely something that can really happen. I get that somebody could put tint on their car because they want to hide something suspicious that they're doing. But on the flip side, The state has the burden to prove that this is what's happening beyond a reasonable doubt. On the flip side, I know plenty of people that just like to have tint on their car because it's hot. We're talking about Atlanta, right? It gets hot. It gets really hot in Atlanta, especially if you're in an area that's like a giant parking lot that hasn't had great urban development planning, right? Lots of heat coming up off the pavement, right? There might be reasons you want tint. We've also had testimony in this trial from Kenneth Copeland. We tint windows because it's dangerous to stop at streetlights, to the point where we don't care if we get pulled over and get a ticket for having tint. We'd rather have our lives, our safety. We have that testimony on the record in this trial. So if this something that Hylton wants to object to is facts not in evidence, well, yes, it is. Yes, it is. She already had to withdraw a facts not in evidence objection one time here. So just for people that might have a hard time conceptualizing, there are plenty of people that have randomly held onto a rental car and kept extending it. There are people that put temporary tint on windows and pull it off before they give the car back to the friend or the person that they're renting it from. There are people that flex and get rental cars and put tint on it just so you don't have to see that little rental sticker and know it's not really their car. So all of those things are kind of contradictory to the state's, what the state wants the jury to just assume is the story plot here. But it's supposed to be the state that provides the evidence and proves that this really is the thing that's happening. And I'm not there with it. I am not there. So that's all I've got on the tint. But yes, I really think this is it, Casey Dog, that tint equals guilty according to Hylton's theory. And she really wanted that to be the last punchline of her examination of the Alamo witness. So T. Roberts, been a member for a month. Thank you. Thanks for all you do. And Shemax. So this reminds me of ShamWow. Shemax is the Shannon and Max combo. Love it. Love it. I always love a good name combo. Thank you so much. K. Grammer, very generously. We've got you in the banner, which I have down. Let me put this back up. Had you in the banner a long time. Took a minute to get to these, but thank you so much for gifting 5 memberships. Super kind of you. FFS also with the rentals. In order to rent a car, you do have to be 25 years old, but rental agencies have a policy agreement that you can pay either, and there's like an extra fee to rent if you're under 25. And I believe you because I've done it. I've done it when I was younger and needed to take longer trips and did not have a very reliable car. You just pay that extra. That's probably why the rental was a bit higher than people were expecting, right? Because they do tack on an extra fee per day for you to be able to do this as an underage renter. So thank you for the info there, the reminder there, FFS. Very important information. Chloe Albert's Revenge says, Your Honor, Hylton is about to riddle herself with false objections because she's brazy. I really think this is going to be the case, and it's going to happen with Starks and Viverito, because those are the investigators that they want the narrative to come in through. And as soon as that narrative is challenged, Your Honor, they're ruining my case. Like, all right. And then Ashley Linnell, thanks so much. You guys are so smart in the chat. Ashley Linnell says HR keeps the record. And again, this goes back to, I don't think they requested it. So, makes you wonder why. A lot of things that they didn't request in this trial that you would think they'd be interested in. You guys can name some examples in the chat if you'd like, but I'll go with maybe financial records for the leader of the pack. STS, thank you so much for gifting another membership. Ariel celebrating 1 month with the Catnut Williams gang says yay. Yay to Ariel. Ike with the weather forecast says partly cloudy skies, 50% chance of mistrial. Yeah, that's love. And again, we heard her like, oh, oops, hee, hoo-ha. There's stuff attached here that's not supposed to be attached. And Love is just guffawing, laughing it off. Like, girl, that could be another mistrial thing that we just had a whole ordeal about 2 weeks ago. So I don't really think that that's funny, but okay. Maybe laughing is your way to deal with it. Oh, man. Mars Get says, Good morning, Kat. The biggest question is if they find any residue, because if not, they have nothing on him. And these defense attorneys already know the answer to this, right? And we've got to wait till we get the APD, the detectives, whoever, to come actually be able to speak on this testimony. What they found, what they didn't find. I'm telling you, I cannot wait. I hope they get to it today. Because if not, it's going to be a cliffhanger all weekend. So, Mars, you were absolutely right. Thank you so much for the support. Paulette says, wouldn't it be great if the defense could call Brian Steele to the stand? If only. And they've been calling folks from the investigator's office from Fulton County. So, I mean, we're doing weird things in this trial anyway. So, interesting. And hold on, your name gives you credibility, AJ's Auto Wash and Detailing. Your name is just, we're just going to treat you like the expert witness because of your name. It's a CV letter. That's all you need. It looked like the car was already tinted when the window was down. So that surveillance picture, that still frame, right? And I think Ike was talking about this in the chat as well. Like, we don't know. And all the lady said, if you listened, and what was her name? Did I note her name? I don't think I noted her name. Yeah, unfortunately, I just put car rental because I was late to notate when she took the stand. I missed her name. But the lady from Alamo, when she was asking this question, asked this question about, you know, are the windows of your cars tinted? Hylton, that was kind of a bad question. But she very, very carefully answered this question. And the way she answered it was, you know, we do not put the tint on our vehicles when we get them. She didn't say that windows couldn't have tint when they acquire them, right? So there's a difference in the meaning there. So very possible that, you know, those windows could have been tinted. We didn't get into that with Schardt. I think Schardt's explanation of the idea that it could have been temporary tint, you put it up to protect yourself. If there's any jurors that know that temporary tint exists, I think they've got enough going there with the defense. So, but great to have you in the chat. Why Turner, and this is the way Love did her voice, her tone of voice. Nah, Love, talk to him like you did the fellas. And she sure got up there and said the same thing Max said. And it's still morning, or however he said it. I don't know word for word, but she mimicked it. She mirrored it and then spit it back out with the next witness. Like, try to just be a little less obvious. White Turner, thank you, also says that tone is y'all not stopping-ish tone arrogance. Yes. Yes, I totally agree. And I do not think it resonates. I do not think it comes off well. But you guys know how I feel about Love. KC Dog says, good, bad, or indifferent, no one wants to be there. Right, and then the last one is like, I mean, I don't know anybody. I'm only here because I sold a gun. Like, the juror 56 was probably like, bro, I feel you. Oh, man. Tracy Fagan says, why is he still holding the weapon? Shock value. And that could be, or like, you know, that could... really any party questioning, but in this case it was the state in the moment, could have said, all right, you can put that back in the box or whatever. And they didn't do that. So he probably didn't know if he could put it down, but they also could have been not instructing him he was okay to put it away because they were fine with him holding it for as long as visible to the jury. So the stupid little tricks like that, they think will win their case for them. And I don't think that that's the case. Mark in Texas, good to see ya, says, hey y'all, been super busy, been lurking, love you, we love you back, we love our workers and lurkers in the chat, really good to see you, Mark in Texas, hope you are doing well, love that your M is still green, thanks for stopping in and saying hey. Miss LJ says, was the gun actually tied to a shooting? Not that I've heard, and I don't see anything mentioned in anything that I'm able to see in the records relating to this case. So, you know, not going to say we won't find something, but as past performance has shown me in this trial, I would think it's more likely than not we're not going to hear anything nefarious about this Glock, except that it had a switch, and that the state's theory is somehow it was in the hands and possession of Arnold, Williams, and Yak. They're all responsible for it. They somehow all conspired to put this switch on together. And it wasn't how they bought the gun or acquired it or whatever. So, a whole mess. A whole mess. Why Turner says, can you talk about the Shannon and the mem rights? Miranda rights? Right? Is that what we're getting at? I think mem might be Miranda. So guys, and every state kind of has different case law. Miranda rights are a gray area, so I don't have much that I can say with particularity on how this should play out in Georgia. But just generally, if your intent as an officer, if you think somebody could be a suspect, and you have them in a position where they may or may not be able to leave, or you have them in the capacity where you want to ask them questions in furtherance of your investigation while you're already marking them as a suspect, you should read them the Miranda rights. They should be Mirandized, right? And likewise, if there's a perception of the individual, you know, detaining someone just to ask them questions versus detaining them, they can't leave, they're under pressure, the perception of the individual could also come into factor here. So it can be kind of subjective, but we're starting to check off more and more boxes where it seems like they already thought Shannon Stillwell was a suspect by March 16th. They were already looking at this Audi. So Flores, to me, lied on the stand when he said, oh, he wasn't a suspect until the day after, a few days after the day after. Because he told us on the 17th a bit more. We spoke to him on the 17th, and that's when he said that that was his car. And then we connected the dots a few days after that. But you already connected the dots on the 16th before you came and detained him. So if you ask me, the stars are aligning that you already are treating Shannon Stillwell as a suspect by the time you have him sitting in the back of the car when he's a victim of the one incident. So I do believe that this was what you meant by mem, the Miranda rights. That's my rant on that. Again, and it's such a gray area because you're going to have a cop get on the stand and lie and say, no, we didn't think he was a suspect. So how do you prove that you did, in fact, that officer, that detective did think he was a suspect when he was talking to Shannon Stillwell? It's a messy issue. And that's why it pisses me off, because the mess seems to be helpful to the police, to the investigators, more than it's ever helpful to the defendant. It's so rare that somebody's Miranda rights. I really feel like it's so rare that somebody actually sides with the defendant who may have not been properly Mirandized. So, but it's constitutional right. Oh my gosh. And now they're using that against him. He said it was his car. And then we're going to work backwards and say it was this car that did the shooting. Right? So it's just a circular way to act like somebody incriminated themselves. Jay Kelman. Oh my gosh, Jay Kelman. Thank you so much. Jay Kelman is out here dropping 10 memberships in the chat. This is super nice. Let's get some J's in the chat there. Big thank you. Shout out to all the new greens. And Jay Kelman also says paying it forward. Hit that like button. Free 99, you guys. Thank you so much, Jay Kelman. Chris Hayes is out here sniping too. Look at you guys sniping the gifts here. Toothless Tiger coming in for the 5. Thanks for hanging out with us, Toothless Tiger. I feel like, you know, you're busy because you have your show that you run. So I'm really happy that you're coming in and hanging out. I've seen you in the chat for quite a while today. It's really nice to have you here with your insight. Some of your commentary and your advocacy for the community is something I really appreciate. And I've got to catch one of your lives. I always miss your lives. I've been missing everybody's lives. But let's see. Aha, I knew it. Okay, so tonight, this is tonight. I knew I saw a live premiere scheduled from you earlier. So here we go. And this is great. This is going to be a rewind, a short-term rewind, because it's going to be about the full plea hearings that we just saw over the last week and a half. So come hang out over there at 9:30 p.m. I think I'll be able to catch that and come hang out Toothless Tiger. So thank you so much for gifting 5 memberships, and also excited to come hang out and lurk in your chat. So excited. Thank you so much again. And then Crescent Wings Project is gifting a membership. Thank you so much. Oh yeah, okay, so finding good, and this is probably a good time, guys, to make sure you're able to accept gifted memberships on a channel. Hold on, there's 2 ways to do it. One is if you click the little $sign where you type in the YouTube chat, you should see an option for gift settings, and you can turn on the ability to receive gifts. If you don't see it, you've either turned it on already, or you might be on an Apple device, which can be finicky. So the plan B is, and you only have to do it once on any channel, and it should work for any other channel. So it's going to look like I'm giving you a link to my own channel to turn it on, but if you go to this link, it's like an allow gift link. You should be able to turn gifts on if you haven't already turned the receive gift membership setting on. So use that link there. Or actually, I'll pin it to the top of the chat. Let me see my comment here. And that's just like a stupid feature of YouTube. So we'll pin that up there so people can find that. And speaking of gifts, holy moly, Peter Ortiz is dropping 10. You guys know what we do. When Peter Ortiz gifts, we do the boom emojis. It's a good time. Love to see the booms. There we go. Is Jesse visiting us? I heard the sound cut out. Oh, nope. All right, so they're going to be back around 1:15. The appeals are short, they're time limited. So we're going to check that out, the Karen Reed appeal. Where I had it pulled up. They were about to start. And to be honest, I have not read the brief. I know some in the chat are probably familiar with the brief. But the Karen Reed trial, as a short recap, ended with a hung jury, right? And there was some talk that jurors were ready to acquit on the top charges, second degree murder, right? And also, I think, fleeing the scene of a crime. And then there was the middle, like, manslaughter with some underlying criteria about the intoxication level, right? So there's been some jurors that came out and said, look, all of us were fine acquitting her of second degree murder and leaving the scene. As far as her being intoxicated, I guess we were split on that, whatever. So with this appeal, the Commonwealth plans to retry her, but her team is arguing you shouldn't be able to retry her on something that the jury wanted to acquit on, but didn't feel like they were able to put on a piece of paper they wanted to acquit, because the instructions from the judge were unclear and maybe even misleading. Judge Beverly Canoni. So that would be what this appeal argument is going to be about. In short, I'm sure there's people in the chat way more versed than me. So I'm going to be going into it a bit blind, but we'll check that out. It should be interesting to hear what is argued. I love watching appeal arguments, so.
That the prior jury reached a unanimous decision, uncontradicted, 4 jurors. Actions. Associate Justices Martin Weinberg on
SJC 13663, Commonwealth versus Karen Reed.
Good morning, Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed. Today's appeal goes to the core issues regarding double jeopardy protection that safeguard defendants, in this case Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent, and we now.
So without manifest necessity, you guys, would mean, look, we have to discharge this jury. It's something beyond the fault of either side. And because it's by manifest necessity, really a retrial wouldn't be barred because there's a reason that we absolutely have to let this jury go, discharge this jury. So he's going to argue that this jury was not discharged out of manifest necessity. Therefore, we have a question of retrial issues, double jeopardy attaching. So.
No, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first...
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis to...
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof that a 5th juror contacted the defense. A juror who could have been one of the 5 and could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof that there was a final and binding...
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous decision.
Well, you cite Taylor, which is the case in Quincy where the judge, basically, there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error.
Yes.
That case is an opposite to what this situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declaration.
But that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was...
Doesn't Fiddler caution to not inquire into the, to not to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations, and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count one? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry, Judge.
You seek to impeach the written communication of the foreperson, correct?
I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges. But count two by itself, read vertically, had multiple charges. Horizontally, there were 3 separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial, and I contest that there were at least 3 viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
You've got an exhausted jury writing this very eloquent message saying, we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words in deadlock.
There's no inkling of what's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best, it's exhausted, it's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is there an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
Once the judge discharged the jury, once the judge thanked them and said the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Como versus Enid Brown, where the jury was sent, the jury goofed, essentially. There was a miscommunication between the clerk and, you know the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that signed that or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge?
I guess the point I'm asking Mr. Weinberg is, there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do, the lawyers then talk about a scheduling conference and timing of it. Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
There was an opportunity, but not a responsibility. The law in this case, starting 39 years ago with Stewart, places the heavy burden on the Commonwealth, which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there were 3 things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds, if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question, and has no capacity to coerce, the jury into redeliberating. It would illuminate the implied ambiguity, which is illuminated by the jury declarations, that there were 2 ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes 2 previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given.
Yes.
I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks...
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note, and the third note.
Yes.
That would indicate any less of an impasse between the first, second, and third notes.
Yes, what happened is that...
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all 3 notes are ambiguous. The defense...
That was not the argument you made below.
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there was no argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was that there was ambiguity.
Not at the motion to dismiss, at the time.
They had no opportunity at the time to...
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a request for TUI.
Was there any ambiguity argument made in response to the second note?
There was a request for TUI. But the only time that I suggest matters is the third note, where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the 3 notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on 1 count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the 3 alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's notes...
At the moment of the declaration of the mistrial, what suggested in the notes, the 3 notes, that there was any agreement as to any of the 3 charges?
Facially, they said they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, not yet. And then there was the second note, where again, they report that they're in an impasse, quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez, and she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some of us agreed that beyond a reasonable doubt, that the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for
So
one.
your
They
rule
asked
would
for a
be
Tui
that anytime there's more than one charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to count 1? Are you at an impasse as to count 2? As to count 3? That's the rule?
When there's a multiple count indictment, that's the rule as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a mistrial.
I thought it was a may, Mr. Weinberg.
The may was in the rule. The reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in. And
In the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples, but 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Weinberg, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. Here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go and the notes that there's an agreement, or at least partial agreement on a particular verdict, correct?
Yes, those notes were subject to one of 2 interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-Tui of seeing whether the jury wanted to deliberate on any one of the 3 counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here the problem is the record doesn't reflect the trial judge's consideration
As a matter
of
of
these
fact, were
alternatives.
there 3 separate verdict forms?
There was actually more than 3 verdict forms because the verdicts on count 2 had multiple, they had 3 different options.
Count 1 and 3, were there separate verdict forms for those?
I believe there were separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask, how are you, the judge says she can't ask the questions that you're saying she could without interjecting herself in deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations. Can you tell us how?
Yes.
Why? How would she do this? She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what your thought process is on that.
My thought process, one is that this court has the option of essentially informing the court what questions can be asked. And two, if we're going to delegate.
Require follow-up questions. And unlike extraneous influences where you can say, okay, we only want to inquire about whether there was a racist statement made or something to that effect. This is different. We're going to have to require what their votes were and how solid they were. Isn't that going to get into deliberations inevitably?
I think you could ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation. But I want to ask you the following questions. One, did you take a vote on count one? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that going to, the jury can change its mind, right?
Could, but there's no.
But isn't that going to result in asking that type of question? When you say final, if you don't get your way on two, is it final?
Was it ever reconsidered? You know, my contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror, who they served for months, says to anybody, to the court, to the clerk, to the court officers, to the prosecutor, wait, I didn't agree.
They also don't write in saying we agree with the other five or anything to that effect. They're silent, as their deliberations are supposed to be silent, right?
But it's an almost unprecedented meeting of the burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what Juror D says. We went to the bus and says no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time?
So, and the answer to the question, and I understand the question, in the Bluford case, you know, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, you know, we allow a court to ask about mental processes. Was there communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Ms. Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend, a unanimous vote. We should have the opportunity to have Judge Cannone conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an external source.
Right, but when it's an extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not guilty?
So the question asked to juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2. We were not yet done.
And that would reflect two
It's
things.
the jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannone, if conducted, that was my vote, it was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? We have a long line of jurisprudence that says we presume that the jury follows the instructions.
And
They were asking questions.
Cases where, when mistakes are made by jurors, where they don't fill out the verdict slip accurately, the Capen case.
That's not this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict, we're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity. And
before you shift back to that, what's the best case? That's federal, because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after? If we want to go back and read one case that's going to do what you want us to do, what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus State, but the amici brief
brief
brought us to where they read the
It's a state
newspaper.
court case, right?
Yes, it is.
Any federal cases? Because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case
This is
that has the, you're asking us to direct Judge Cannone to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
Well, this court has a long history of applying federal
We don't have any
constitution.
cases except extraneous influence cases. I'm just looking, again, your chance.
You do
Best
have-
case that we should look at for you.
You do have one example, which is the McCallum case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial bias.
That's extraneous influence. That's different.
It's internal to, I think it's closer to the core of 606B.
No federal case we can turn to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by this jury, it's not going to open the floodgates for post-voir dire.
Well, actually, that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, you know, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think she was, he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty, and
So the jurors submitted affidavits?
The jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules, Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether to...
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think, potentially, a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving the Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table, is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
So let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If your honors would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open. The jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections. So
The judge said they're at an impasse, bring in the jury?
Bring in the jury, and you can actually hear a door open.
Okay,
So
and you have 30 seconds to object?
But you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the
You
jury
can say,
can't
Your
hear.
Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in
But
the
they
note.
did know that the jury had reported to her that they were at an impasse.
They were at an impasse, bring the jury in. Yes, that was possible. but to
What was possible?
to ask to go to the bench, but
Yes.
this court...
And did that happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial,
After a
correct?
careful consideration of all alternatives and after giving the defense an
Explain why,
opportunity.
perhaps, the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted the verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives TUI,
Yep.
and then the jury comes back and says, we're deadlocked, is articulate as this jury was or not, and then the judge does something different other than just declare mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
So in the face of that, do you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect, were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was on July 1.
And the statute, again, is a may, correct?
The statute says, 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, the number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence, where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it life imprisonment. I thank you very much for the privilege of appearing before you today.
All right, so state's counter-argument. Commonwealth counter-argument.
Good morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the Court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, Effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given to E. Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death that allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more into
Rather than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or the obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. Perhaps as a matter of...
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant argues...
So it's not inherently coercive?
So
the judge has a discretion, it can't be coercive, correct?
Well, no, it's a matter of discretion, and then consider the factors that inform the exercise of that discretion, and that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It would be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits, now 4 or 5 days of deliberations. They've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why wouldn't we talk about what potentially we could do short of saying, mistrial, let's start again?
Certainly, Your Honor, and I think, in hindsight, seeing, the quote-unquote remarkable turnaround of the defendant's position, would it have been better, would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse, there is a manifest necessity for a mistrial, there is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your Honor.
Really?
Find consent through the lack of an objection here.
Even the burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get manifest, you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first 2 notes. And what was the defendant's response to those notes? It was to argue in favor of doing thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room, and even after that, they still could have brought it up. And we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room, and at that point, the judge did still consider counsel's arguments. And I think, given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
You might have, I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor, and very different than Hogan. So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Hogan is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not...
How do you know the defendant is advocating for a mistrial as opposed to pushing a verdict?
Because, Your Honor, not just what they argue, but what they argue...
Because TUI, there's two results of TUI. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial, they could have been just as well advocating the jury for that final push. As the TUI Rodriguez instruction says, you need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as to just TUI Rodriguez, although as a practical matter, as Justice George has pointed out, experienced defense counsel understand that there's not going to be a mistrial before that instruction has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations, but counsel also know that it could very well, it's a flip of a coin. It could be a verdict or it could be a mistrial.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time, let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, we believe there's been sufficient time. Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a TUI instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor, there was manifest necessity for the declaration of a mistrial here.
And so absent the consent, we can just, you think the manifest necessity existed?
Yes, I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and were discussed with my brother.
But counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues, where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial. There could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this, and perhaps we can all come to some other vertical other than declaring mistrial.
Yeah, and I think it's clear from the judge's order that she was cognizant at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps. But the judge's determination here, which is owed some deference, if not abuse of discretion, was not outside the range of reasonable outcomes, given the jury's notes and these other considerations, Your Honor.
You don't think it would have been coercive to say, come on, jury, I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs, but did you reach a verdict on count one?
I do think that would be extremely coercive, Your Honor, yes. And I would point the court to footnote 5 in Ray v. Commonwealth, where this court said or noted, there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry, but that is not the prevailing practice here in Massachusetts and is not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 doesn't, there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But so I see your point on the note is so compelling that they've worked this to the end. But and the problem comes when we get this new information that's somewhat inconsistent with that they've, I mean, the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
Yeah, and I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already...
I get that point. I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation here. Is there no obligation whatsoever, I guess, is what?
No, and we argue below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
The judge makes a finding that she finds them credible for the purposes of this motion, right? So she doesn't say they're unreliable, but rather accepts their reliability and then concludes that nonetheless that she can't inquire here without invading deliberations. It's different for reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
Are credible, right? So it's not a reliability issue that you can rely on, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged, they've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their deliberations.
That's a separate matter. You said that, you can't bring this jury back. You can bring them back for post-verdict inquiry.
Well, it's one...
under the guidance of Fiddler, et cetera, right?
It's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a verdict that was never returned.
What Mr. Weinberg argues is what we protected of the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike...
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of 2 competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations, and I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've sent back jurors on race. I can't remember how many years. It was like a decade later or so. Timing's not going to be a winner for you, is it? It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence. So it's,
our post-verdict inquiry is guided, and we always say to the jurors, and we tell the trial judges, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that was the specific question they proposed, but I understand. I take Your Honor's point.
I mean, however they phrase it, it's a limited yes/no question.
Yes, and my point is that's an artificial inquiry. Or take, for example,
Have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the line, right? Or is it?
No, but again, I want to re-emphasize the point that was raised earlier, which is imagine a juror had tentatively agreed to find not guilty on a particular charge. But that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else, I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial exercise to say,
Is that what Bluford, is that, Justice George asked your brother counsel about Bluford? Is Bluford the answer for you, that that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it, it's only in lesser included that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
I would argue that it is, and I actually take it one step farther, which is not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty. So even if, like counsel wants to argue, this was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is that different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form, although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement where it said, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Is Bluford limited to lesser included, or is Bluford broader than a lesser included opinion?
I don't read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser included or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do, and it wasn't inconsistent with the instructions. I want to emphasize one other point, which is, at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short-circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You can imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless Your Honors have any other questions, Commonwealth would ask the defendant's petition be denied.
Okay, thank you very much.
Thank you.
Court, all rise, please.
We're still on the seal over on YSL. In short, I think that ending there, it was kind of like, hee hoo ha, I know what you're gonna say. This seems like a very favorable thing to the state, which bears the burden, the Commonwealth, which bears the burden. But I'm gonna make one final mic drop, or try to make a mic drop that says, no, it would be beneficial for the defendants as well. So don't go and set new precedent that changes this thing against our favor in this instance, because it could harm defendants in the future. But what's the problem with that? Double jeopardy is something that's in place to protect defendants. Double jeopardy doesn't exist to protect the state. So if someone were to come back on an informal poll and say, yeah, I mean, we're stuck, but we were leaning to guilty. Well, if the form was there and they could find guilt on some charges, hung on others, that's a separate question. But an acquittal, unanimous acquittal on a charge to protect the defendant's rights, double jeopardy, and I see the argument here. If the manifest necessity, the reason to call a mistrial, is because we're hung on a particular charge, but the rest are unanimous, double jeopardy attaches. That's a protection offered to defendants. That protection does not exist for the state. So that last argument there was a real reach. Was a real reach. And I see some comments, debating on whether or not she was framed, but keep in mind that the argument at issue here really has nothing to do with the theory of the case presented at trial by either side. The issue here is you have your second-degree murder, you have your manslaughter, and you have your leaving the scene. So we have this mistrial because the jury says they're hung. The question is whether, when there's a mistrial because the jury's hung, double jeopardy doesn't typically attach because that mistrial is called out of manifest necessity. We have to discharge this jury. They're at an impasse, and we need to retry all these things because they were hung on all of these things. The question being asked in this courtroom is, well, if they weren't actually hung up on 1 and 3, they were actually unanimous for an acquittal on 1 and 3, then the impasse was really only for count 2. So manifest necessity isn't in the way of count 1 and 3, and double jeopardy therefore should attach. She shouldn't be able to be retried on 1 and 3. And again, this is all separate from the theory of whatever the defense or the Commonwealth presented at trial. It's irrelevant. But the question here is, who's at fault? So we heard a lot of questions about counsel. Well, maybe they could have asked something. And the defense, the appellee, said, hey, there wasn't enough time. They got this note, she announced the note, she discharged the jury. What was the defense supposed to do? And it's not really their requirement for them to do so. And what I think was the most telling question from all the justices, my opinion, what stood out to me, was the question of, to the Commonwealth, there's been cases, there's been rulings where courts have found that a judge not exercising something that's within their discretion, even if it's a may issue, they may choose to do it. Courts have found in more than one instance that a court not exercising something that's available to them is a harmful error and reversible. So by Judge Beverly not exercising something she could have done to probe in on these charges to figure out, are we really hung up on all 3? The mechanism of the error here would be the judge. So lots of questions here. I have no read on what I think the court will do, but I think these are huge questions because, and this is a double jeopardy question. Double jeopardy is an important thing. We don't want to be able to just try someone over and over and over again until we get that guilty verdict, right? So these justices have to decide, is this giving too much room to prosecutors who would try to do this? Or should we protect the sanctity of double jeopardy? So that's where I am on that, you guys. Loved all the insight in the chat. Again, we're still waiting on YSL trial. That was the Karen Reed appeal that we were looking at for anyone tuning back in, waiting for court to come back from lunch. They are half an hour late, so there you go. Also, I saw a lot of recommendations. The Lawyer covered this trial if you want to do a rewatch. I think most of my watching was across probably Lawyer a lot Andrea Burkhart and Potentially Criminal. Because one thing I love about Potentially Criminal is he'll always remind the audience that just because you did it doesn't mean you're guilty, because the state has to prove it beyond a reasonable doubt. So always love that reminder. Mr. Nobody said FFS fireworks. I can't hear anything. Are you okay? I don't know what you mean about fireworks. Are you okay over there? Hope you're doing well. Fireworks can be loud and crazy, and it is just like, I don't know. Oh, like because of the election? I'm like, what's going on with a Wednesday? Maybe that's it. I'm piecing this together a little late. Hope your ears are okay. Hope you can tune it out, put in some earbuds. Positive Q says, hello, cat mods and chats. Yeah, this jury would be losing their mind if they were dealing with YSL. So 157 days, 6 weeks. And again, I was just watching this in the bushes, largely on channels. Potentially Criminal would speed up the feed. I think Lawyer does recaps. Andrea was really the only space I was watching it in real time. And it was still too long. It was 6 weeks, way shorter than YSL. So, yeah. Imagine the impasse here. And we've already had a signal from Juror 56 that we want this to move. Thank you so much, Positive Q. Chloe Albert's Revenge says the McAlberts are a trashy suburban gang. There's a RICO that might stick. And what I think is interesting about that trial is we just have a bunch of people driving around that all, I think there's enough on the table, the reasonable assumption that people were drinking, pulled up to the property, drank more within the property, and then were all driving. And like one person kind of painted that they had a scenario where they had a sober driver, a mostly sober driver. But for all the rest, it's like, oh my gosh, you guys are largely in law enforcement, or you're hanging out with law enforcement, and you guys are getting like smashed and then driving in icy, slushy weather. So a totally separate takeaway is just, a reckless disregard for the lives of others by a group of people. Guys, do not drink and drive. That was a huge mess in that case to me, and it's not what was on trial. But it was just it was something that stood out because these are the people that would pull you over and try to give you traffic tickets or say that you're drinking and driving under the influence, but then they're doing it themselves. So, just very hypocritical. I was not happy about that. Chloe also says, I can't stand precedent. Your Honor, the precedent is the one that you will be setting if you grow a spine. Respectfully. And we don't need the respectfully in there. But that's the thing. How do you get precedent if you're unwilling to set one? Right? So this is a great point. And I think it's one of the reasons, and this isn't really precedent in terms of case law at the appeals level, but informally, I think the judge in the Alec Baldwin trial kind of sent warning shots to anybody that would come in front of her in her courtroom. Don't try to play with Brady material in my courtroom. Don't do this again. So different than precedent as far as case law, but precedential in its own way, right? And that's something I think a lot of people really appreciated from Judge Summers over there. So, Heart of Inspiration, tons of gems in the chat. Heart of Inspiration says, I have seen many trials at this point that when this happens, the judge at least asks if the jury is deadlocked on all counts to see if they've reached a verdict on any of the counts. And, sometimes I do think there's a risk. I do think that was a valid point raised. It could kind of edge them to be,
that
we find them guilty.
any of the attorneys believe they want to ask. Do y'all know that now, or do you just want to? Yeah, I will plan to be the one making the queries, and then I'll ask everybody if they've got any questions. And if you do at that point, you can let me know.
Jury issue?
All right, we need juror number 387.
There's a juror issue.
Please. Yes.
There are 387.
No. What? Not filmed. It can be like audio recorded, but not filmed. Okay. I mean, you can't film the juror. You can film the rest of us if you want to. I think you stand even if it's just one juror.
Okay, so the defense is standing, but the state is not. Okay, there we go, they are.
Hey, if you could just grab a seat. I got
On
a
the
couple
witness
of
stand?
questions. So I know that earlier this week, your employer reached out to you and inquired whether this this trial that you're on was over. And eventually just said, okay, just send me the next juror excuse note. And I have been in contact with the employer to find out exactly what got said. And so she shared with me y'all's text chain about that. And essentially she says, she just asks, are you still on jury duty? And you say yes. And you ask if everything's okay. And she says, yes, your teammate came in asking which trial you were a juror for and that a specific trial was over. And your response was, everybody and their mama keeps saying that. So what we would like to find out is what anybody might have communicated to you. And I know sometimes you cannot help if people just come up and blurt something out, and hopefully to say, I can't talk about the trial, but what has anybody communicated to you about? And you know that we started with 6 and we now have 2, and I instructed you,
Age is leading.
don't worry about the reasons for it. Has anybody communicated anything to you? And if so, what?
More so the decrease of the defense.
Okay,
That's been most of the communication where people assume I wasn't here this week.
okay, all right. And let me ask you one more thing. And then she, after you say that, she says, well, that's the reason I'm reaching out. And you said he was one of 6 to are finishing the trial. Who do you mean by he?
The communication when I got it was more so specific to say who wasn't here anymore and why they assumed the case was over.
And who would you have gotten that communication
The
from?
teammate called. The teammate that made it
Oh,
to her.
okay.
Called to specify what she meant. I didn't call her, she called me.
Okay, and what did she communicate to you? Just that,
Williams wasn't here.
okay. And did she say anything other than Williams isn't a part of the trial anymore?
No.
Okay.
They assumed him not being at the trial.
Meant the trial was over with. Okay, and do you recall the instruction I gave you on Monday, you and the rest of the jury on Monday morning, to essentially not speculate about any reasons why, and that shouldn't have any impact on your verdict or your deliberations?
Because the communication with staff was just trying to figure out how we were supposed to address it.
Okay, yeah, and I mean, you haven't done anything wrong, we just have to figure out, because obviously y'all are supposed to only consider the case based on the evidence and the information you get from here in the courtroom. So just want to make sure that you are able to, I know this communication came after my instruction, so are you still able to follow that instruction?
Yes.
Okay, great, perfect. I'll excuse you back to the jury room. We'll have all of y'all out in just a sec.
He wants to go to the finish line. She wants to go all the way to the end. I think this is good for the defense.
Okay, anything anybody wants
this is
to
where
put on the record
my
after
read.
Your Honor, given that she didn't indicate, as the court said it was looking to hear, I don't suppose so.
No.
Yes.
Mr. Schardt?
We have to still, we're fine, and ready to continue forward.
Okay, and Mr. Weinstein?
No issues for Mr. Henry.
Okay, great. Then let's get the state's next witness and we'll get the jury out.
All right, guys, so we'll skip this jury thing, but especially if you just got back looking from lunch, they made a query with a juror, a different juror than juror 56. This was like juror 387. Holy moly, that's a lot of jurors that they had to go through to seat this jury pool. It seems like an employer, someone on her team, wherever she's employed, heard news that the big fish all pled out of this trial, and she provided the conversation to the court to disclose it, and she has to tell her employer that the case is still ongoing. Her employer is probably just trying to find out, we're paying you, when are you coming back to work, is the case done? And so Paige asked 2 particular questions. What exactly did you hear? I see he was mentioned. Who's the he? Well, Jeffrey Williams. Well, did you hear anything else about Jeffrey Williams? Can you still follow the instruction that I gave, that you're not supposed to speculate as to why the defendants are no longer with us? And she's good to go. She's in the clear. I think Love wanted to fight it, but didn't know how. And defense is very happy. And guys, you do not want, if you want this trial to end, you don't just want to root for a mistrial because of juror attrition. If we don't have enough jurors, if we go down to 11 jurors, which is not enough to go to deliberations, that's manifest necessity for a mistrial. And when you have manifest necessity for a mistrial, you can retry. Double jeopardy is not going to stick most likely because the reason for the discharge was unpreventable, right? Just manifest necessity. We have to do it. So a mistrial because the jurors ran out, it'd be another trial. So her staying on, I think, is a huge win for the defense. Their body language echoed that as well. Also, big shout out here, Classy Beats. I want to give a big thank you to Steph JK in the chat for dropping the link to Classy Beats. We're going to hang out over there tonight. You know, it's good music. There's some good commentary, but you also get to hang out with the chat and a lot of familiar faces. Classy had snuck in here and dropped 10 gifted memberships while we were on lunch watching the Karen Reed appeal. So super interesting. Wonder, what did you think of that, Classy? Always interesting, in my opinion, to see appeal arguments. They're short, sweet, kind of spiky, real quick. And thank you so much. Sorry I'm late on getting to these, but thank you so much for gifting the 10. FFS had came in and not only dropped 10, but then another 20. So we've got 30 new gifted memberships from FFS. So this is your chance to say FFS in the chat. I know it's like a disguised way to say something. You guys have the free pass to do it. So take advantage of it and show some appreciation for FFS. And again, happy that FFS is free once again, no longer stuck in timeout. And then Darcy. We've got another 20 gifted memberships from Darcy, which is super generous. Darcy, thank you so much. Also love anytime someone has a green icon, because we joke that these gifted memberships, you're getting slimed. So your icon matches. Love to see it. Thank you so much. We've got you in the banner. Gwen and Garnett, again, my apologies for saying Paige instead of Whitaker. Got to rewire my brain. Thank you so much for gifting. And Chris Hayes with the nice commentary here says, great insight into how our legal system works. So guys, I love to talk about the law, but I think this is a very kind comment. I think it's worth reiterating. I'm not an attorney. I just really like trials, talking about things. And when there's room to improve, I like to point it out. So let's see. Where's our next witness? We're getting the jury back. I checked in with the person. Oh, is this Hogan? Guys, Hogan's back. So we're going to get some more on Shymel Drinks because he also investigated that. Here we go, you guys. Al Hogan.
And I can't remember if it was detective or investigator.
Either one.
Okay. You've been with us before, so I'll just remind you, you're still under oath, and you can go ahead and have a seat.
All right.
Detective Hogan, welcome back.
Thank you. Good to be here.
How are you this afternoon?
I'm great, thank you.
All right. I want to direct your attention to March 14th, 2022. Did you have the occasion to respond to the 400 block of Windsor Street Southwest, the intersection of Windsor Street and Interstate 20, Atlanta, Georgia?
I did, yes, ma'am.
And is that location in Fulton County?
It is.
Why did you respond to that location?
I'm a homicide investigator. There was a homicide that occurred in that intersection, and I was assigned to be the lead investigator for that.
What time did you respond to that location?
I think I got the call around 10:30 at night. And then I arrived sometime after that.
Once you responded to the location, what, if anything, did you find?
Oh, well, I was told that the incident occurred at the intersection of I-20 or underneath the bridge or close to the bridge, I-20 on Windsor Street. I came in off of Fulton Street, I believe, and came in and saw there was a large area surrounding the intersection that was surrounded by a crime scene tape. I pulled up. I was informed by one of my coworkers who was already on scene that the person that had discovered the car and the body was still on scene. And also I checked in with the person that was keeping track of the crime scene log, and I chose to talk with the person that discovered the body first. So I approached him first, and and interviewed him.
Okay. I'm going to show you what's already been admitted as 65 VV.
Okay?
I'm going to also show you 67 VV. Is that the area in which you responded?
Yes, ma'am, it is.
Now, you said you spoke with a witness on the scene. Do you remember that witness's name?
It's Mr. Cheeseborough, I believe his name.
And was he able to provide you information? Without telling me what he said, was he able to provide you information?
Yes, he told me what his experience was there, yes.
Were there any other officers or investigators assisting you when you arrived on scene?
There were, I think Sergeant Butler was there from homicide, as well as a Detective Churchill was already on scene. Those are the two I remember offhand that were there. I know Sergeant Butler, I was at home when we received the call, so I had to come from home. They were in the office. Sergeant Butler had checked the camera and knew that there was a camera at that intersection. He happened to save the photo. The camera at the DOT there does not record, but it does show live images, but that camera just so happened to have frozen at the point where Mr. Cheeseborough was getting out of his car to go check on the person in the red car.
When you got there and after you spoke with Mr. Cheeseborough, spoke with Sergeant Butler, spoke with Detective Churchill, did you make any observation about the vehicle?
I did.
What did you observe?
Well, the car was in the intersection in the far left lane at the red light, stopped. The driver's side door was open. There were bullet holes in the passenger side of the car, and some of the glass is broken out. And the driver of the vehicle was sitting in the driver's seat, deceased, and there was a pistol in the front seat laying in the passenger seat. It had the passenger side glass is broken out, and there was glass fragments on top of the pistol.
And I'm going to show you what's been admitted as 77 VV.
There you go.
Now, looking at 77 VV, was there any significance to you about how the glass was sitting on top of the gun?
Yeah, from my experience, I believe the gun was sitting on the seat when the shooting happened, and the glass was broken and exploded inward and landed on top of the gun, which indicates to me that it was not used in the interaction. It was just laying in the seat.
And did you ever have the occasion to view more in-depthly the victim who was in the driver's seat?
I did, yes.
Did you notice anything with the victim when he was in the driver's seat?
Most notably, his right hand was inside his pants.
Commissioner?
Go ahead.
Commissioner?
You may.
Okay, so maybe he thought he had his weapon on his, like, whatever area you'd holster it. Didn't realize, I got in my car and put it on the driver's seat, but it happened too quick and he was immobilized. Because remember, we had that testimony from Schardt saying that, even if it didn't kill you instantly, you wouldn't be able to move your limbs. You wouldn't have control over movement, right? So if you're reaching with your hands in your pants, it's either how you drive, the thing about sitting with your hand in your pants on the couch, whatever, or you thought that's where your weapon was at the ready, right? So
I'm going to show you what's been marked as 202 VV and 203 VV.
Yes,
Do you recognize 202 VV and 203 VV?
I do.
And how do you recognize it?
Those were, when the crime scene's there and the medical examiner's there, they examine the body, the medical examiner does his examination, and our ID unit follows behind and also takes pictures. These photographs are of when the medical examiner was examining the body, and he was pulling back the pants to see what he was holding on to.
Okay. And I'm gonna, this is a fair and accurate depiction of what the medical examiner saw back on March 14, 2022.
Yes.
Your Honor, this time the state would like to admit 202 VB and 203 VB into evidence.
They're admitted.
I'm gonna publish 202 VB on the screen, and I'm gonna hand publish 203 VB.
This might be, if you're queasy, guys, here's your warning.
Victim's hand when you walked around, saw the body.
Yeah, the medical examiner is pulling his pants back, but it's very similar, yes.
Okay, and then looking at 203 VB, is that where his hands were?
Yes.
Now, once you made some observations of the body, what, if anything, did you do next?
Well, part of my initial visit to the crime scene is I try to gather any physical evidence or determine if there's any kind of evidence on the scene that's going to be interest to me or make further investigation. In this particular instance, we did a very thorough search for any shell casings. So obviously, we assumed there should be some shell casings in the intersection, or at least near the car, because of the amount of the shots that went into the car. We didn't find any. We did a very thorough investigation, and we didn't find any shell casings. No physical evidence outside the car was discovered.
And as an investigator, was that a note to you that you did not find any shell casings?
Yes. I mean, at that particular time, I had a couple theories. Was either he was shot, the shell casings landed in the intersection, and during the period of time before the shooting happened and he was discovered, with the cars driving through the intersection, it might have kicked up some shells and moved him out of the way. They got gone. Or he was shot from inside a car, and the shell casings were inside the vehicle he was shot from. And those were just my assumptions on the scene at that time.
And while on scene, did you have crime scene come and process the scene?
Yes, ma'am.
And as you already discussed, did the medical examiner's office come out and also examine the body and also remove the body from the scene?
They did, yes.
When you first arrived on scene, did you have knowledge of the identity of the victim?
Not immediately, no, but there was a fingerprint scanner that was brought to the scene. That's a device that we use when we're trying to identify anybody, really. But it's a pretty slick machine where you can take a fingerprint, place it on. It's a mobile device, like this pretty large cell phone shaping.
And were you able to determine the victim's identity?
Yes.
And what was his name?
Shymel Drinks.
And you have an age and a date of birth?
Yes, ma'am. His date of birth was 11/8 of 98.
And how old was he?
I don't know, do some math. 98. I don't know, I can do it. Hold on a second.
Okay. Would he been 23?
24, well, it depends on his birthday. 23, 24, yeah.
Now, after Mr. Drinks was taken from the scene, did your investigation continue?
Yes.
How?
Well, I didn't really have a whole lot to go on at that time on the scene. We had identified the victim, but other than that, physical evidence was really non-existent. I received a phone call from a Detective Grimsley. It's a friend of mine who works in auto crimes enforcement in the city. He was working that night, and he had taken upon himself to look at some of the city cameras to see if he saw anything, and he called me and said that he saw two cars following out the victim out of the BP station. You could see on the camera the red car and the two white cars going down to that intersection, the two white cars pulling up beside, and then they take off to the intersection and the red car stays there. So that was a clue for me to go back to at least investigate and gather the video from the BP station at the corner of Windsor and Fulton Street to see if there was anything on that video that might help with the investigation.
Did you initially try to look at the city cameras that Grimsley first observed what he told you?
I did. I looked at them.
And
that particular camera is a long ways from the intersection. You can see, but it's grainy. It's not very clear. It just gave me really just a clue or an initiative or a idea that, yeah, there may be something there, but there's nothing definitive could be determined from the city video.
And the cameras that he was looking at, did you know where those cameras were located?
Up near Richardson, I think. Richardson and Fulton Street.
Richardson and Fulton or Richardson and
Or
Windsor?
Windsor, I'm sorry, yes.
All right. Permission to approach, Your Honor?
You may.
I'm going to show you what's been marked as 217 Victor Victor and 218 Victor Victor.
Yep,
Tell me if you recognize 217 and 218 Victor.
I do.
How do you recognize 217 and 218 Victor Victor?
Both of those pictures are taken from Windsor Street at Richardson, where the camera is located.
And do those appear to be fair and accurate depictions of the area of Windsor and Richardson Street? Fair and accurate depiction, Fulton and Windsor Street. Windsor and Richardson Street.
Yes.
Right, Your Honor, this time the state would like to admit 215,
213 VV 218, or 217 218.
217 and 218 VP
That's your minute.
Permission to publish.
You may.
And I want to look at 218 VV. Your permission for Detective Hogan to step down briefly? Permission for him to step down briefly?
Sure.
Looking at 218 VV, where would the BP gas station be as it relates to this intersection of Windsor and Richardson?
Sure. Go down to the next intersection on the other side of Fulton Street on the right-hand corner. Is that
And from this picture, are you able to see where I-20 is?
yes, but it's in the distance.
Where is
You
this?
see the bridge right there.
All right, thank you so much. Now, did you ever go and obtain the surveillance video from the BP gas station?
I did.
Did you obtain any other surveillance video?
I did.
Okay, where else did you obtain surveillance video from?
From the BP station, King's Liquor Store, which is in the same building behind the BP station downstairs. And then there's a FedEx building on the west side of Windsor, closer to the intersection of Windsor and I-20.
And did you view the surveillance video that you obtained?
I did.
And did you find anything of note on those surveillance videos?
I did.
All right. And have you had opportunity to look at those surveillance videos as well as a compilation video in preparation for your testimony today?
Yes, ma'am.
Your Honor, permission for me to sit while I publish some videos? Thank you.
You may.
I'm going to publish State's Exhibit 116 BB. Can you orient the jurors as to what they are looking at in 116 BB in this particular surveillance video?
These images are from an elevated position in the front of the BP store. At the top of the screen is Fulton Street that runs east and west. Off the screen, but to the right side of the picture is Windsor Street that runs north and south.
And I'm going to begin publishing at 39 seconds. And do you know this is camera 19 of the surveillance video?
Yes.
Was there anything of note looking so far in camera 19?
Well, the white Audi that just pulled in and backed into the parking space off camera, that turned out to be important.
I'm going to pause at 1:08:09. Next, we're going to go to camera 3. Beginning at 00. I'm going to pause for a moment at 17 seconds. Do you see anything that occurs in the top left corner of the video?
Yes, ma'am, that's the Audi that backed into the parking space. When it went off camera on camera 19, it backed into the front, from near the front doors of the store. And you just, this camera angle just barely caught the right rear of the car backing into space.
And I'm going to continue playing at 18 seconds. And is this the inside of the BP gas station?
It is, yes.
Pausing at 1 minute and 2 seconds. Was there anything of note for you in that frame?
Yes, ma'am. I determined that the person who just walked in with the pink hat on was involved.
Your Honor?
Yes.
Just moving forward, I'm just going to object to conclusory statements.
Sustained. Disregard that last answer.
I'll ask the question. Was there any person of interest to you in that photo? I mean, that portion of the video. Without saying why, was there a person of interest?
Yes,
And who was the person of interest?
the person in the pink hat.
back to camera 19.
Your Honor, can we vote for a second?
Yes.
I was interested.
We're going to fast forward to 1 minute and 59 seconds. And was there anything of note to you in this particular frame?
Yes, I was interested in the white car that just pulled into the gas pumps and the occupants of that car.
And there's
Yes,
two white cars, one that's kind of backing up and then one at the pump. You said,
that's correct. Yes, at the gas pump.
thank you.
So, Ms. Hylton, are you the one operating the
Yes.
screen right now? Okay, if you recall what we discussed at the bench.
I'm just trying to get some stuff.
Maybe y'all need to leave that with Ms. Knight.
Now pushing at 137. Did you see the individual that got out of the white vehicle and turned to the store in this way?
Yes.
For the record, which individual walked out of the white vehicle? Was the individual in the beige outfit?
Person that we have with a beige jacket and the green hoodie underneath.
Now beginning this at 26 seconds. And looking at the video, do you see in this upper corner outside of the store that say white Audi? Are you able to see it?
Yeah, you see the tail light shining through the window.
And is that here where the arrow is pointing?
Yes. You can see the door just opened and somebody exited the driver's side and is walking in.
And did you see the same individual in the pink as we saw in the earlier camera footage walking as well?
Yes, yes.
And then do you see the same individual in the beige and the green hoodie walk in as well?
Yes. And then the person with the pink hat puts the item on the counter and the person with the green hoodie pays for it for him.
And the third individual that just walked in, was there anything of note for that third individual for you?
Yes, the young man that had the shower cap on and the white shirt that said Slimer down on the back, he was a passenger in the white car at the gas pumps, the Ford Fusion. He got out of the car and came in the store after the driver had come in.
And you eventually see the person with the green hoodie at 4 minutes and 14 seconds in the video come back into the store.
Yes, he had walked back to the car and then walked back into outside the store and made another purchase.
Now, does this camera or video image pick up where that last one ended?
Yes.
And we're starting at 0.3 seconds within the video? 48 seconds within this frame. Starting back at camera 19 at 00, we're going to fast forward to 1 minute and 13 seconds.
The red car pulling into the gas pumps there now is the victim, Shymel Drinks. He's alone in the car.
Is that the same red vehicle that you see at the light?
That is, yes, yes. And you see the driver of the Ford Fusion walks up and gets in his car. Mr. Drinks exits the vehicle and walks into the store.
Fast forward to 3:47, 59, 3:47.
I think Schardt is going to go bananas on can you actually see someone in this car?
And then Mr. Drinks returns from the store into his car.
Going to publish camera 14. Beginning at 2:04.
That's Mr. Drinks walking in with the gray sweatpants and the black hoodie.
The medical examiner, the coat, it looked more like a coat, like a brown coat than this, but maybe it's just the lighting. So they're trying to say that they saw him walk past while they're sitting in the car. Because of the lights here.
He exited the store
And is that what picks up on the camera and we just see when he walks
when he
back?
returns to his car, yes.
Showing back camera 3 at 14 seconds. Is this just a close-up view from behind the register of what we just saw in those last 2 clips?
Yes, that wasn't the victim, but yes, it is.
Was that the other individual that we've been talking about?
It's the driver of the white Fusion, yes.
That's a lot of peach rings. Are those peach rings? This whole end cap?
Starting at 143. And is this still the Audi that we saw earlier?
Yes, it's still sitting there with the tail light. You can see the tail light in the left-hand top corner of the frame.
Is this supposed to be, I don't know what Garlington looks like. Is that supposed to be Garlington or something, or is he leaving with drinks?
That's correct.
So who is that we're watching? Or are we just supposed to be watching that he's there at this time checking out for his product? And I need an assist from the chat. This is like the Ask the Audience on Who Wants to Be a Millionaire. Is that guy in the white shirt supposed to be relevant, or are they just trying to show us that Shymel Drinks happens to be in the camera view and this guy in the white shirt just buying his stuff has nothing to do with this?
And going back to camera 19. a second? Do you still see the red vehicle and the white vehicle both at the front?
Yes.
And based on your observation, had this white car been sitting for a few minutes at this point?
Yes.
And is the Audi still over here,
Yes, ma'am.
off camera?
That's correct.
How do you know? Explain to us how you know. I get that I myself said I see the headlights, but Hylton should elicit that.
And it's a red car pulling up.
Yes.
And are we at?
See the red car pulls out on Windsor Street, exit, the Audi follows directly behind, and then the white Ford Fusion falls in behind the Audi.
And was that everything of note to you on the BP gas station video?
Yes.
And did you also then review images from the King's liquor store video?
I did.
Now, do we get videos from this part? Because he seems like he watched some city cameras that his buddy also watched. Grimsley or something like that. So if they're rewatchable, do we get to see them? Seems like they're not ready to, maybe they don't know what they actually want to show.
And we're going to begin 36 minutes into the video.
So this camera is posted on the outside of the King's liquor store there, pointing out toward Windsor. It's not as detailed, it's a little further away. It's not as high quality of an image as I was getting from the BP, but I was able to see from that vantage point.
And is this Windsor Street right here?
That's correct, yes.
And on the bottom of here, while there's a toolbar cover, is there a timestamp at the bottom of the screen?
Yes, ma'am, I believe so, yes.
I mean, I don't see, if it's behind the lawn crime thing, I don't see it.
Starting at 36. Do you see the timestamp down at the bottom?
I can't see it now.
You can or cannot?
I cannot.
This is the angle from the liquor store that's like
But-
in the same plaza.
Do you see the timestamp in the far right corner?
No, ma'am.
Look behind you.
Oh, yes.
And what was the,
It's not on this one.
I'll just. What is the time on the bottom right-hand corner?
This is 10:01 p.m. on the 14th of March, 2022.
Are they gonna tell us that that car in the background was the white car as the other car turned in? It's a car going the other way.
You see the red car go by?
Was that approximately 10:01:08?
Yes, then there's a white car closely followed behind it. At 10:01:20
I see
something.
the person walking.
And there was another white car as well, follows in.
Okay.
Why is his testimony like not matching what's happening on the screen like as it's happening?
Is this the red car?
There you go. Yep.
And is this the first white car you
That's
saw?
the first white car, yes.
Is this the second one?
There's the second, yes. It's difficult to determine make and model from that vantage point, but the colors were the same.
Now, Shirley was admitted as 117 BB. publishing. Looking at what's in minutes 117 DB. Where's this surveillance video from?
This is from the FedEx building. It's on the west side of Windsor. The top left-hand corner is where you see the light shining. That's the intersection, the red light intersection just before you go under I-20 at Windsor Street.
And is this the light right here where my arm, where the hand is circling?
Yes.
I'm gonna fast forward to 1 hour and 1 minute into the video. Approximately 1 hour and 44 seconds.
The car that just pulled up to the light now is stopped. That's the red vehicle.
This car right here?
Yes. The Audi, the first car to follow the red car out is the Audi, the white Audi. It's right next to it.
That right here?
Yes. And then the Ford Fusion is right to the right of that.
That right here.
That's correct.
Now, is there traffic going in the opposite direction where the cars are stopped right now?
Yes, there's traffic now trying to go onto I-20 eastbound.
Nichols is just,
And so the
he's
car
zooming
where
forward.
it's Drinks and the two white cars are a red light.
That's correct. It's red light now. And the Audi takes off through traffic, through the red light, as well as the white car, the Fusion.
So the Audi and Fusion go through the red light.
Well, the Audi did, yes, ma'am.
And was there still oncoming traffic coming as they were going through that light?
Yes, there was. And then that car did a U-turn, which is a little odd.
Why do you say it was odd?
I don't know if that, what they witnessed or if they heard anything, but it's suspicious to me that at that particular time, since the red car no longer does not move, and it was at around the same time that the murder occurred, that vehicle might have been privy to some information. It's my assumption.
Were you able to locate or find it?
Say again?
Were you able to determine what vehicle that was that made
No,
it?
no, ma'am. No, ma'am.
Now, when you approached the vehicle, the red vehicle, when you got on scene, were there any defects to the back of the vehicle?
All were on the driver's side.
But driver's side, passenger side?
I'm sorry, the passenger side of the vehicle, yes. I don't recall any in the rear.
And this now the car's still stationary?
Yes, it does not move anymore. It stays there till we get there.
I'm going to fast forward to 127.
If you pulled up next to a
And
car
as I fast forward, is the car still sitting there?
Yes, ma'am.
and someone was bleeding out, would you book it out of there? Or would you be like Cheeseboro?
Start at 127.02. And at 127.02, is the car still sitting there?
Yes.
And do you see your car pull up on the opposite side of the street to the red car?
Yes.
And based on what you know,
Oh, why are we doing that law and crime? I think we're a little bit behind. Let's go back a little.
the timestamp on the video.
Sorry, guys. We were like 2 minutes behind, so let's go right to here.
That's correct.
And the car was stationary beginning at 1 hour and 1 minute into this video.
That's correct.
Permission to approach her?
You may.
Have you had an opportunity to look at a kind of a compilation video of all of those 3 videos kind of spliced together?
Yes.
And did that appear to be a fair, accurate, is this what's contained in 250 BB?
Yes.
And does that appear to be a fair, accurate depiction of those surveillance images that we just watched?
They were, yes, they are.
Right, this time say like a trigger in the mid 230 BB.
All right, those are, that is admitted, 230 VV.
Does anyone know if the white Audi, that model, has like a rear window light at the top of the rear window that would be a long rectangular band of light? Because when they were driving up on that road, on the angle we just saw, it looked like there was a long strip of light on the back rear window of the one car only. So is that model? Because like that would be what I would want kind of laid out. And they didn't really ask the rental girl about that feature. So, same time.
I'm sorry, Commissioner Publisher.
You may.
So the Audi comes in, backs into the parking space.
Because I can't see a light, I just see reflections.
And looking at the bottom of the video, is there a timestamp on the video? Can you see the timestamp?
Yes, it says 21:51, which is, it's 9:50, 9:51 p.m.
And is it on March 14, 2022?
Yes. Fusion arrives at the gas pump, and the driver gets out, walks inside.
Yeah, because I don't see a light strip on the back of this. Is this where I would see it? Like, should I see that light band in this moment at the top?
He's followed inside a short time later by the driver's side rear passenger.
And what time is it now? This is the time.
It says 21, when the camera changed, it changed to 21:50 on the March 14th, 2022. See the car backing into the space outside the window. See the tail lights on the car.
And again, that's it with the Audi, correct?
That's correct. That's the alley that backed into the front just prior to the person arriving. At some point, you can see it. It's hard to see, but you can see through the window that the driver's side door opens, and the driver steps out and walks inside. You can follow him from this angle, follow him to the front door, and it's the young man wearing a pink hat and glasses. So that's at 2051, and then shortly thereafter, the driver of the Ford Fusion comes in.
And did you mean 2151 or 951?
That's correct. That's what I said. I probably said that.
And at the time, did you know the names of any of these individuals who were in these videos at all?
I had no idea. So 21:52, 11 seconds or thereabouts, driver the Fusion in the beige jacket and hoodie, green hoodie coming in. He comes in and he buys something for the driver of the Audi in the pink hat. Then the passenger from the Ford Fusion comes in, and the driver of the Audi interacts with him, indicating to me that they knew each other. And then the passenger exits with the other two drivers. Okay, now we're back at 21:53. 9:53. The driver of the Fusion and the passenger walk back to the Fusion. I'll get back in the car and sit there for a few minutes.
And what time is it now?
21:54, 20 seconds. It's 9:54, it's almost 10 o'clock. on the same day. Driver of Fusion is out and wants back in the store.
And so that's saying 9:54 time.
That's correct, 9:54. Makes a purchase.
Okay, it just jumped. The video just jumped.
And is this the red car with Mr. Drinks arriving?
That's correct. So Mr. Drinks arrives as the driver of the Ford Fusion is walking back to his car.
And what time is it now?
It's at 21:56. I believe, yep, 21:56 on the same day. 4 minutes before 10 o'clock at night.
And has the driver of the Ford Fusion already gotten back into the car?
Yes, ma'am. He's returned to his driver's seat, and they sit there, both the Fusion and the Audi sit there until Mr. Drinks leaves.
You know what Shymel Drinks needed on his windows?
Mr. Drink goes in to the store, makes a purchase,
And what time is it now?
21:57 on the same day.
And at this juncture has the Ford Fusion been sitting idle for approximately since about 21:56 p.m.
Sure, yes.
They're like skipping the in-betweens of the walking to the store, right?
And the Audi, have you seen any more activity since 21:54, 21:55?
No, ma'am. Mr. Drinks leaves.
And what time is it now?
21:59. We're at 21:58 now on the camera 19. $21.59. There's Mr. Drinks exiting the store.
And it has the Ford Fusion now been sitting idle for about 3 minutes.
Yes.
And from your observation, have multiple cars come and gone in in the period of time when both the Audi and the Ford Fusion are sitting idle?
Yes.
But what's all this up here? Like, all the white cars. There's two driving back here.
And what time is it now?
So it's 10 o'clock, 2200.
And is it 22:01 or 10:01 p.m.?
It's 2201 right now on the video.
Thank you. And does the red car pull off at approximately 10:01 p.m. in the video?
Yes.
And is it only then that the white Audi pulled off?
That's correct.
And has the white Audi been sitting idle for about at least 5 minutes prior to him pulling off?
Yes. And then the Fusion as well.
And has that been sitting idle for about 5 minutes prior to him pulling off?
Yes. This camera is capturing images. The metadata on that says it's not in military time. The red car go by at 10:01, followed by the white car at 10:01 in some seconds. And then the third car, the white car, at 10:01.
And then does it pick up with the FedEx images that we saw a few moments ago?
That's correct.
Now, did you, as you were watching the video, take still images of some of the certain portions of each of those videos?
I did.
I'm going to show you State's Exhibit 204 VV through 215 VV. And have you had the opportunity to look at these previously? And then 245 VV through 247 VV.
Yes, I have.
And were those very accurate pictures, the screenshots that you took from the surveillance videos that we just seen?
Yes.
Your Honor, this time the state would like to admit 245 VV through 247 VV, and then 204 VV through 215 VV.
All right, those are admitted.
Now, Investigator Hogan, how many homicides have you handled where there has been a vehicle associated with the potential perpetrators of the homicide?
I hadn't kept count, but a great number of homicides or vehicles are utilized.
For those cases that you have, about how many of those cases does this target vehicle have tinted windows?
Judge, Your Honor, relevance.
Can you establish the relevance of that?
Yes. Let me back up. The Audi vehicle that you were observing, did it have tinted windows?
It appeared to, yes.
And in the cases that you've dealt with that have target cars or vehicles related to a homicide, is it uncommon for those target vehicles to have tinted windows?
Relevance.
Seems sustained at this point.
Space.
Now, after looking at the surveillance video, did you receive any assistance from a Detective Bender?
I did.
And how did Detective Bender assist you?
Well, we work together quite often in our investigations. Detective Bender is, she sits real near me in the office, or sat real near me in the office. And she asked if she could help, and I asked her to help me identify. I knew that she was very good with our camera system, our LPR system, that captures tags. So I asked her to help me identify the cars, see if she could find the cars on the system and identify their tag numbers for me, which she was able to do pretty quickly.
And were there any particular LPR reads that were significant to your investigation?
Yes.
Okay. And what were the reads that were significant to your investigation?
So Detective Bender was able to find a white Audi that hit on a license plate reader at Windsor at Richardson Street, which is right around the corner, at 9:49 p.m. on the night of the murder, as well as a white Ford Fusion that was closely following behind it. That was at 9:50. So one was at 9:49, one was at 9:50. They were both headed in the direction of the BP station.
And is that the same area where that Vic camera was located in the picture that we looked at earlier today?
Yes, yes, ma'am, it is.
Now, after learning of the LPR reads, did you get any other investigative assistance?
I did.
What other assistance did you receive?
I was at my desk, I was going through the video, and I had some really good video of who I consider persons of interest or suspects in the murder, but I didn't have any idea who they were. So I was going through the video and taking screenshots out of facial shots as close or detailed as I could get. My intentions were to post those in a citywide email throughout to the police department to see if anybody would recognize who they were, and I could put a face with a name or a name with a face. As I'm doing that, Detective Bender is searching the LPRs. All this kind of came together at the same time. And then a Detective Marissa Viverito and Sergeant Belknap from the gang unit visited the office and came to my desk. Detective Viverito happened to see, or I asked her, do you recognize this guy? And she said she did, and since she recognized two of the individuals that I had identified as suspects in the murder.
Okay.
Between her and Sergeant Belknap.
And do you recall what day of your investigation this interaction occurred with Investigator Viverito?
It happened on the 14th. It was either the 15th or the 16th. I don't remember exactly what day it was. Took the warrants out, I think, on the 16th. So I don't remember when I got the video, but it was the 15th or the 16th, one of those days.
And was Investigator Viverito able to show you any pictures regarding any of the individuals that were contained in the video?
Yes, she had been called out, and the gang unit had been called out to an incident where there were several gang members inside of a house that they, being from the gang unit, went and responded to the house. And while they were there, they took pictures of cars and of the people that were there and detained. And she showed me images of the people that were there. including the two people she'd identified, and they were still wearing the same clothes. The third, the one image that I spotted was a young man in the back seat who was wearing the leopard print shower cap. He had it in his pocket at that residence on the call that Detective Viverito was on.
Okay. And at the time, do you recall, was Detective Viverito working in Atlanta Police Department, or was she working somewhere else at the time?
She's kind of jumped around. I think she was either with the DA's office and assigned there, or she was with the gang unit, but she was in between, or one of the two.
Okay. I'm going to show you what's already been admitted as 166 VV.
Okay.
And does 166 VV, is that the image that she showed you when you saw her at APD headquarters?
This is the image that Detective Viverito took on the call she was on after my murder. Again, the pink hat, the hoodie, the same hoodie, and just recognize the face.
Okay. And I'm going to show you 167 VV. Was this another one of the pictures that she showed you while you were at APD?
Yes.
Okay. And were you able to get a name for the individual in 167 VV?
Yes.
And what was that person's name?
Miles Farley.
Okay. And then were you able to get a name for the picture, for the person who was in 166 VV?
Yes.
And what was that person's name?
Shannon Bernard Jackson.
And were you ever able to get a name for the third individual who was in the beige jacket and the green hoodie?
Yes.
And what was that name?
Quamarvius Nichols.
Now, were you also shown pictures of any vehicles by Investigator Viverito?
Yes.
And what picture did she show you?
I remember seeing a picture of the Audi.
Now, after looking at the surveillance video, looking at the LPR readers, and speaking with Investigator Viverito, did you request any other assistance as related to your investigation?
Detective Grimsley helped me with, once we determined the tag numbers of the Audi and the Ford Fusion, we discovered that the Audi was a rental car. Detective Grimsley, who was in auto crimes and has connections in regards to that, I asked him to help, and he made it was rented from Alamo. He contacted Alamo, or put me in touch with a person from Alamo to give me the rental information for the Audi.
And were they able to provide you that rental information?
He did, yes.
I'm going to show you what's been admitted as 186 BV. A. Tell me if you recognize 186 VVA.
Yes.
And how do you recognize 186 VVA?
This is the information, or it's a copy of the information I received from the rental car company.
Okay. And who was the renter of the vehicle?
It's indicated here it was Shannon Bernard Jackson.
It was that the same person that you had identified from the two surveillance videos?
That's correct, yes.
Excuse me, from the surveillance video, from the picture?
That's correct, yes.
Did you ultimately take out warrants in this case?
I did.
And who did you take out arrest warrants for?
For Quamarvius Nichols, Shannon Jackson, and Miles Farley.
And for what charges?
For murder.
Now, is there any significance to you as a homicide detective or investigator in the fact that a suspect vehicle is a rental vehicle?
Yes, I've found in my experience that,
Overruled.
it's been my experience that rental vehicles are quite often used when there's a crime going to be committed or they're planning on doing a crime.
And what about, is there any significance of tint on vehicles as a homicide investigator?
My experience that people at tint windows are trying to hide who's in the car, or prevent people from seeing inside the car to see who's in it.
Court's indulgence for a moment.
I would disagree. I don't want extra sunlight in my car or to see my chin. I don't care if people see me in it, but I don't need them staring at the side of my head. Like, and this is Atlanta. If you guys are not from, like, the United States, Atlanta gets really hot.
No further questions, John.
All right.
What a
I
weak
assume
thing to
there's
end
going to be a
on.
cross of this witness. Do
The
y'all
damn
want to take
tint.
a break before, or is it just going to be short?
It's going to take us to the end.
Okay. I mean, I figured it was going to take a little while. So let's take our afternoon break, and then we'll come back with the cross of this witness.
So that's the second witness that Hylton wanted to make a punchline out of tinted windows. Like, that's her sticking point, is, oh my god, the tint! You're a criminal! So, oh my goodness. So, Sean Street, and he didn't have to super, I actually started this before you super, thanks for the super. For me, on timestamps, it doesn't feed that way. It works in negative, so, I mean, are you trying to have us look back at this video where they're at the gas station? Because while the feed is live, it's only going to show me the negative time read, how far away we are from live. So do you mean this video? Was this the right start point? Wait, is this before?
What time is it now?
21:54, 20 seconds. It's 9:54, it's almost 10 o'clock.
Back
on the
further?
same day.
Wait, what? You can make the time go opposite? Click what part? I didn't know that. That's
Driver
cool.
Fusion, it's out, and it's back in the store.
Okay, before the red car leaves.
It has the driver before Fusion already got back into the car.
Yes, ma'am. He's returned to the driver's seat, and they sit there, both the Fusion and the Audi sit there until Mr. Drinks leaves. So Mr. Drink goes in to the store, makes a purchase,
And what time is it now?
21:57.
And from your observation, had multiple cars come and gone in the period of time when both the Audi and the Ford Fusion are sitting idle.
Yes.
So you're talking about this guy? There's a little zippity-doo-dah car over there. So the question is, this guy in an earlier video is getting into a different vehicle.
And what time is it now?
So it's 10 o'clock, 2200.
Yeah, I don't know. There's something like, can we look at that rear light? Where was the parking?
And is it 22:01 or 10:01 p.m.?
It's 2201 right now.
This is where they show the angle from the lot.
1 hour and 44 seconds.
So that has the higher light up. Oh, I paused it when it's like behind a tree. Oh, let's try that again. Right, so this has a significant, like these are the proper rear of a car, right? On the body. But then there's this band of light up here that isn't visible in anything except one of the SUVs that drove by earlier. It looked a little higher up. So where is that on the Audi in the gas station footage at all?
The car that just pulled up to the light now is stopped. That's the red vehicle.
This car right here?
Yes. The Audi, the first car to follow the red car out is the Audi, the white Audi. It's right next to it.
That right here?
Yes. And then the Ford Fusion is right to the right of that.
That right here?
That's correct.
Now, is there traffic going in the opposite direction where the cars are stopped right now?
Yes, there's traffic now trying to go onto I-20 eastbound.
And so the car where Mr. Drinks and the two white cars are a red light?
That's correct. It's red light now. And the Audi takes off through traffic, through the red light, as well as the white car, the Fusion.
So the Audi and Fusion go through the red light?
Well, the Audi did, yes, ma'am.
And was there still oncoming traffic coming as they were going through that light?
Yes, there was. And then that car did a U-turn, which is a little odd.
Why do you say it was odd?
I don't know if that what they witnessed or if they heard anything, but it's suspicious to me that at that particular time, since the red car no longer does not move, and it was at around the same time that the murder occurred, that vehicle might have been privy to some information. It's my assumption.
Where you're able to locate?
Have been privy that, or if they.
Let's watch the UE. I mean, this could have just been.
Coming as they were going through.
Who is this
Yes, there
person?
was.
And was there still oncoming traffic coming as they were going through that light?
Yes, there was. And then that car did a U-turn, which is a little odd.
Why do you say
Who is
it
this
odd?
person walking?
I don't know if that what they witnessed or if they heard anything, but it's.
Right, I'm not crazy. That's a person.
Well, the Audi did, yes, ma'am.
So the Audi and Fusion go through the red light?
Well, the Audi did, yes, ma'am.
And was there still oncoming traffic coming as they were going through that light?
Yes, there was. And then that car did a U-turn, which is a little odd.
I mean, it'd be like that sometimes.
I don't know what they witnessed or if they heard anything, but it's suspicious to me that at that particular time, since the red car no longer does not move, and it was around the same time that the murder occurred, that vehicle might have been privy to some information. It's my assumption.
Were you able to locate or find it?
Say again?
Were you able to determine what vehicle that was that made?
No, ma'am. No, ma'am.
Now, when you approached the vehicle, the red vehicle, when you got on scene, were there any defects to the back of the vehicle?
Most were all were on the driver's side.
But driver's side, passenger side?
I'm sorry, the passenger side of the vehicle, yes. I don't recall any in the rear.
And this now the car still stationary?
Yes, it does not move anymore. It stays there till we get there.
I don't know, is that a person here too? I mean, is this just a place where a lot of people walk? Or is that just like a shadow on the road further up? Or this looks like a person, right? You don't really see them until you see them. And then now this is like Sasquatch videos.
127.
All right, you guys. I did not find myself any closer to clarity. I'm a little bit like, what is going on? And the quality of this camera, you can't really see certain things. When the cars are parked at the intersection and the frames are paused, they have like this, I'm sure you guys can see it, but there's just like this weird shape around the vehicles. I don't know. Waiting to see what Schardt comes up with. Okay, yeah, so there could be traffic for a variety of other reasons that's completely unrelated. Yeah, they just keep on moving. The people and the U-turn car. Oh, Nick. Nick says difference between this trial and Sasquatch is there's more evidence for Sasquatch. I don't know. This is all a mess. Sean Street, I know Sean Street is like doing the greatest work here, trying to point me in the right direction. And I'm like, there are a million cars. And then there's people. That the camera really isn't helpful. The quality of that camera is definitely not helpful. And I think the questions I have are if the injury caused to him immobilized him right away. I don't know. I would imagine he wouldn't just be rolling if he was shot earlier and be able to come to a stop right at the lane, right at the intersection. Right? So, I've got some things that aren't computing in my head there. Sherry Aguilar is saying, the longer we go, the more confused I am. But yeah, Sean Street says that the guy across, so going back to the footage from the BP where we have this extra white car in the corner, there's a guy across. The guy across never completes his walk, but turns around and hops in an SUV. The guy in the car never goes to the store or pumps gas. But they know which seat to wait on, the guy, because they know there's cameras. Right? To me, moving around like that is a bit more questionable. And I'm not going to say I've never, like, there could be a reason someone pulls into a gas station and they're not going to purchase anything that isn't criminal at all. Right? There might not be a plot. But doing that is a little bit different than somebody going to the store and making a purchase and then speeding off and shooting someone at an intersection down the street. If it's supposed to be some, we don't want to be caught. We're planning this, right? The concept is that it's planned, according to the state. The state is trying to say that Shannon Stillwell and the guys planned this so far in advance that they reserved this car, put the tint on it to carry this out. and happen very luckily to see Shymel Drinks at this gas station and say it's go time. Right? Their argument is that it was planned out. It was not just a spontaneous thing. Why would you go into this gas station and put yourself on the camera? Right? You might not realize there's cameras outside, but why would you go inside? Make yourself known. Right? To me, what Sean is like, I feel like you have the pointer on the board here, Sean, like virtually. Like, watch this guy. That's a little bit more like, okay, we're not going to make a purchase with a timestamp and we're not going to go inside. It'd be a little bit more consistent with somebody doing some better planning. So, yeah, and it could be Cheeseboro that was turning around like that. Did he tell us what kind of car he drove? And I do really feel like the defense is going to clear up a bunch of our questions, or at least give us a alternative explanation, right? But I'm still just like waiting for that. I'm like, so shout out to Sean Street. Wish we had like a virtual pointer and a board for you. But again, Sherry, I agree. The longer we go, the more confused. Particularly with this incident and how they're laying it out. And we heard that there was some footage that the colleague showed Hogan that he got to watch. And I don't think it's this footage from BP or the footage from wherever that parking lot angle is. It's showing the drive up to the intersection. It seems like he was hinting that there was more that he saw than that. So, I don't know. KC Dog says, there we go. Police have tint in South Florida. I mean, apply the logic. Apply Hogan's logic right there. There you go. Exactly. My gosh. Positive Q also says, I have tinted windows. Am I hiding something? They prepped him well. He studied those videos. Now he's a storyteller. Jury 56, take us away. And, it might not even be prep with this witness. I think his style, his pursuit of an investigation is to come up with the storyline, right? He's very narrative from the testimony that we've seen from him. And just from the small look we've had at the Blaylock appeal, it seems like we got a look there on the flip side. Built the testimony, built the story. Wanted the witnesses to say, yeah, that is how it happened. Marlena Max says, I sit in my garage longer than 5 minutes. I mean, you go to the gas station, you buy a wrap, you roll it up. You go to the gas station, you buy a snack, you sit in your car and eat it before you start driving. Would you rather us start driving and do these things while we're driving, while we're operating a vehicle? Like, pick or choose the battle here. There are so many people that sit in, like, Buc-ee's. They have 1,000 million gas pumps because they know people sit at the gas pumps and go inside and shop for like 20 minutes and then go out and eat their food before pulling away. So they're a very busy gas station chain, and they accommodate not just for having a high volume of traffic, customers in general, but also that people will take a very long time before leaving away, driving away from the gas pump. Like, yeah, I sit in my car until my favorite song goes off, right? You gotta play it out. Gotta play it back. Sometimes you gotta run it back. That reminds me of when, I think it was the song Monster, the Nicki Minaj, where she had the verse. When that song first came out, I was living in Buffalo, New York, and somebody for 2 hours straight was parked outside my window playing that song on repeat. When I tell you I learned the words to that song just because it was on loop. It was on loop. It was very loud, but it was okay. Yeah, you need time to use the bathroom, right? It's not like at a gas station, if you don't buy something, if you don't pump gas, if you don't get in and out, it means you're sitting there looking for someone to follow necessarily. So, Yeah, and I think this is it too. Like, he's full of it, trying to make anything seem sketchy, and he's so prepared here to say, tint is always sketchy. People want to hide. Why do people sit at gas stations? I don't do that. That's weird. You know, maybe not in anybody else's experience except your own, Al Hogan. So I agree, Maverick. Just adding some extra flavor to his story. So, and I can't wait to, I hope Doug Weinstein is just like, so every time someone makes a U-turn, it's sketchy. Oh my gosh. I totally agree, Casey Dog, that the defense is sitting there salivating. It kind of sucks that when they have the exhibits on the screen, we can't see all that. But yeah. And I'm not saying it's not, guys, when circumstantial evidence is presented, right, there is still that, you know, why would this just be a coincidence? Circumstantial evidence can be enough to convince a jury. I'm not sure about juror number 56, but, you know, circumstantial evidence, the jury can make a determination that, you know, we think that this is more likely than not. We think that beyond a reasonable doubt, this has to be the explanation for it. And that's kind of scary, right? That's a scary prospect in a way. Because imagine you were in a white car that happened to leave the gas station at the same time and go down the same intersection.
Why someone would rent a car.
Oh, they cut out his cross, guys. They're starting in the middle of it.
Reason why someone would rent a car.
I don't see why not, sure.
Could that be a reason why someone would repeatedly rent cars for years, switch them up, so people couldn't track him down and kill him? Could that be a reason?
Overruled.
Could that be a reason?
Sure.
How about an individual whose friends had just been gunned down 3 days prior? Could you envision a situation where that individual would want to rent a car so no one knows what he's driving?
Objection speculation. Overruled.
You made him
Yes.
speculate.
Okay, and tinted windows. You said tinted windows can be used to commit crimes because you can't see in as well. Could conceal an identity.
That's correct. That's what I said, yes.
By that same logic, couldn't tinted windows keep people who are trying to kill you off of your scent, off of knowing what you're driving?
Yes.
Especially 3 days after they have murdered 2 of your friends in cold blood?
Sure.
Could that be another reason why someone would rent a car?
Yes.
Could that be a reason why someone would rent a car and break a rental agreement and put tint on those windows?
Yes.
Thank you.
You're welcome.
All right. This warrant that you took out, sir, for the rest of Mr. Stillwell, you charged him with murder, the murder of Shymel Drinks, correct?
That's correct.
Okay. And you specifically charged him with the shooting of Shymel Drinks, correct?
I'd have to look at the wording, but I think he used the word partaking.
May I approach, Your Honor?
You may.
Impeach, impeach, impeach.
We're looking at a copy of the warrant that you took out, assist you in remembering the wording.
Sure.
Grab the wrong one. Got it.
Thank you.
Yes, sir. And just refresh your recollection, and if, after your recollection is refreshed, if you could look up.
Sure. Yes.
Okay, and fairness, you did say participate.
Yes.
In the warrant, but you said by shooting Shymel Drinks.
That's correct.
Okay, on 3/14/2022.
That's correct.
Okay, so specifically, your allegation in that warrant is that Mr. Stillwell was the shooter of Shymel Drinks, correct?
Yes.
Okay. And we've talked about some of the evidence that you think you have on this case. Let's just call it what it is. I know that we've been referring to the man in the pink hat, okay, or the man with the slime or die shirt. You have BP video from the corner of Windsor and Fulton Street, correct?
Yes.
Clear video.
Yes, very good, yeah.
And it shows my client wearing a Pink Floyd hoodie and a pink hat. And it shows Mr. Guamarvius Nichols, correct?
Yes.
And it shows Mr. Miles Farley, correct?
Yes.
Okay, cool. And you had that video, and then you also have these rental records of renting the car on that day. Now, let me ask you this. Is there any indication at all, if we're talking about planning something, is there any indication at all that anyone would have known that Shymel Drinks was going to show up at the gas station at that time?
No.
Okay.
Not that I know of.
Okay. Do you know where Shymel Drinks was coming from?
No.
Okay. And then you have video from the FedEx, correct?
I do.
Okay, and that shows Windsor Street.
Yes.
And you maintain that that video shows that my client in his white Audi pulled up next to Shymel Drinks' car.
Yes.
And you maintain that that video shows that my client shot Shymel Drinks.
Participated, yes.
Okay. I mean, your theory is that my client was driving.
Yes.
Okay, and your theory is that the shot was fired out of the driver's side of the car.
Of the Audi, yes.
Yeah. Your theory is that Shannon Stillwell was in that white Audi and shot Shymel Drinks at that stoplight.
Yes.
And your contention is that video, that FedEx video, will back that up, ultimately.
That's my conclusion from my investigation, yes.
Okay, cool. All right, so let's go back to where this investigation started. Evening of 3/14/22.
Okay.
Okay? And you see this red car with this gentleman inside who's sadly deceased, correct?
Yes.
And you arrived before the body was removed, correct?
That's right.
Okay. Now, this is your crime scene. I know that you weren't the first one there, were you?
No.
Okay, but this is your crime scene.
Yes.
So you're in charge of knowing the status of the crime scene and where everything was at the time it was first discovered.
Ultimately, yes, I am.
Okay. So, let me ask you. The Nissan Versa, the red Nissan Versa, before anyone came to the assistance, before Mr. Cheeseborough showed up, was that car still on?
When I was there, I don't remember it being running, no.
No, I'm asking, since it's your crime scene, when the first people showed up, to your understanding, it's your investigation.
I wasn't.
Speculation calls for hearsay.
Is he the lead detective? Okay, well, overruled on the speculation, and would your report contain all of that?
It doesn't, if the car was on or not. I know the lights were on. As far as the car was running, the door was open when I got there.
That's the next thing I'm going to ask you.
Yeah.
Okay, so you're not
Sounds
certain.
like he doesn't know.
So you're not certain. Okay, so the car was running. Or is
Obviously,
that what you're not certain of?
Obviously, it was running when he pulled into the stoplight. When I got there, I don't recall if it was running. I know the lights were on, the door was open. I don't recall if the car was still running or not.
When you got there, the
When I
lights
got
of the
there,
car were on and the door was open.
The lights were on.
Right, the lights of the car were on and the door is open. When we say the door, we're talking about the driver's side.
That's correct.
Front door. Okay. Now, my question is, before you got there, before anyone got there, was that door open? That front driver's side door to the Versa?
It's my understanding it stayed closed until the paramedics or EMTs opened the door to check on the victim.
Okay. How about Mr. Drinks's feet? Were they on the brake?
I believe they were, yes.
How about the gas? Was 1 foot on the brake and 1 foot on the gas?
I don't recall that.
You don't know, or are you saying no, that's not true?
I don't know.
Okay, fair enough. And when one of your first tasks was to determine the identity of this gentleman, correct?
It's one of the first things, yes.
Okay, and you weren't the only one there, there were other officers there, correct?
Yes.
And among those officers was representative from the gang unit, correct?
Yes.
Okay, Investigator Flores?
May have been, I don't recall.
Okay. Either way, even with the assistance of the gang unit on scene and all APD resources, no one recognized this gentleman, Mr. Drinks.
He was not officially identified until we did the fingerprint scan.
Right, and that was about 1:06 a.m. that next morning, correct?
It was while we were on scene. I don't know exactly what time it was.
Okay, fair enough. Miss Hylton, if you could do me a favor, please, could you I'm sorry, Mr. Abadi said he was going to help me. You're going to help me with something else. Thank you. 107 Victor. Thank you, Miss Knight. Cell phone, do you see that cell phone in Exhibit
Sorry,
107,
warned.
Victor?
Is it the one in the pocket there? Is that what that is? Yes, I see it. Oh, it's on his arm. I believe, yes. Plugged in.
Do you see that cell phone?
I do, yes.
Okay. As an investigator of homicides, do you often collect cellular phones?
Yes.
And that's from victims and suspects, correct?
Yes.
Okay, and reality is, cell phones, if you're able to get into the cell phones and have authorization to get into cell phones, they have a wealth of information, correct?
Sometimes they do, yes.
They can have call logs, they can have contacts, correct?
Yes.
They can potentially have tracking information, who you're in contact with, places you've been.
Yes.
You can learn a lot about a person from a cell phone, correct?
Yes, you can.
You can learn who their friends are.
Yes.
You can learn who their enemies are, potentially.
Potentially, yes.
Okay. In this case, as lead investigator, you are aware that actually 2 cell phones belonging to my client have been seized in this case, correct?
I believe so, yes.
And their contents have been extracted, correct?
Yes.
Okay. Now, Mr. Drinks, as lead investigator, did you ask the crime scene tech or crime scene tech Davis or any other individuals to seize or to collect Mr. Drinks' cell phone?
Yes.
Okay. And were you ever able to analyze the contents of Mr. Drinks' cell phone?
I don't recall that, no.
Okay, you don't recall ever seeing the contents?
No.
Okay, so as far as you recall, we don't know who is in Mr. Drinks' contacts?
No.
We don't know what he's been texting about leading up to this incident?
No, I'm not aware of it.
Okay. We don't know of anyone that he's had disagreements with or squabbles with or anything like that from his cell phone?
I'm not aware of any of that, no.
Okay, and you're not aware because not saying that none of that exists in his cell phone, but you just haven't seen the contents of his cell phone?
That's correct.
Okay. All right. I want to talk to you about these videos, if that's okay.
Sure.
And Mr. Abate, I'm going to ask you to just be on standby in case I need to publish anything. Thank you. Detective, we have the BP video.
That's correct.
Several different camera angles.
That's correct.
Okay, including outside of the pumps, inside the store from different angles.
That's correct.
Okay, we have the King's Liquor video,
Yes,
the surveillance video, and then we had the FedEx video.
that's correct.
Okay, let's talk about the BP video first, and I'm not going to replay all the videos. You see my client, Shannon Stillwell, in the pink hoodie and pink hat, arrive in the white Audi, correct?
Yes,
In the white Audi that was rented in his name,
that's correct.
and the white Audi that he told investigator Viverito on March 16th, yeah, that's the Audi I'm driving, correct?
That's correct, yes.
Okay, and it did have tinted windows, didn't it?
Yes,
All right. You see him arrive at the store, and then you see Mr. Quamarvius Nichols arrive in a Ford Fusion shortly thereafter, correct?
yes, sir.
Mr. Nichols pumps gas.
Yes,
Okay. Mr. Farley is an occupant of Mr. Nichols' car, correct?
that's correct.
Okay, they all enter the store. They're on video.
Yes,
Okay. Mr. Farley's wearing a slime or die shirt.
that's correct.
Okay. Do you know anything about Mr. Farley's background or history?
No, sir.
Okay. Do you know that he's a clothing designer?
No idea.
That he creates those shirts, those slime shirts, and sells them to the public?
Okay.
Okay. You were not aware of that before today?
No, sir.
Okay. So you see those three individuals go in and out of the store. First, you see Mr. Nichols go up to the register with Mr. Stillwell, correct?
That's correct.
All right. And in these videos, in all these videos, you don't see anyone with a handgun or anything like that.
No, sir.
You don't see anyone that seems to be irate or upset, do you?
No,
Well, maybe some people in the store, but not these three individuals.
that's correct, yes.
All right. You see Mr. Nichols make a purchase and buy some gum for Mr. Stillwell, correct?
Yeah, he bought something for him. I couldn't tell what it was.
Okay.
But yeah, he did.
And this is the first time Mr. Nichols was in the store, before he pumped his gas, correct?
That's correct. That's correct.
And you see Mr. Nichols joking around with the clerk, acting like he's pulling out all these bills.
Right.
And then you see Mr. Farley come in.
Yes.
And you see Mr. Stillwell turn around on Mr. Farley and act like a monster and kind of scare Mr. Farley, and Mr. Farley does this weird pirouette.
Right, yes.
They're playing around.
That's correct.
Okay. Everyone seems, from the video, no one seems upset.
No.
Okay. Later on, you see Mr. Nichols come back in the store to make another purchase, correct?
Yes.
Okay. Do you know what he purchases?
No.
Okay. Ms. Hylton, I'm going to ask if you could play the video of where Mr. Nichols comes into the store for the second time and makes a purchase.
They didn't ask anything. They didn't talk to the clerk according to Flores. Oh, man.
If you could play that. Please. Are you able to see what he is purchasing?
Wrap or a lotto ticket? I think it's a wrap. It was a thicker package. I don't know for sure, though.
It looked to me to be like some Black and Milds, maybe? That's a guess, I don't know.
Okay, appreciate that answer, and I know that it's noted that it's just a guess.
Make him feel stupid.
And you can stop yourself. Thank you. Your Honor, may I approach with DS-56?
You may.
Sir, I'm approaching you with what's been marked as DS-56. Do you recognize that image?
Yeah, it's an image from the series of video we just watched.
Okay. That's a still image from the video we just watched?
It appears to be so, yes.
Okay. And is that a fair and accurate representation of the video we just watched? An image from the video we just watched?
Sure, yeah.
Okay, thank you. Your Honor, at this time, I would move to admit DS-56 into evidence.
Look at love.
It's admitted.
Permission to publish?
You may.
Could those be backwoods
There you go, guys.
blunts?
Yes.
Okay, and do you know what backwoods are?
So like a little cigar, isn't it? Something like that.
Okay, is it also something from your experience that can be gutted and used to roll a marijuana blunt?
Yes.
Okay, how long, to your knowledge, if you know, have you ever seen anyone, we'll just say on video, through police, through detective work, have you ever seen anyone roll a marijuana blunt?
I'm aware of how it's done. I've never witnessed it.
Okay, it takes some time, correct?
I would
Depending on
assume.
how experienced you are?
Yeah, I would assume it would, yes.
Okay, and is this purchase made right before Mr. Nichols returns to his car?
Yes.
When he's sitting there for like 4 minutes as idle, as Miss Hylton said?
Yes.
Okay. Do you know, yes or no, whether what was going on in that car with Mr. Nichols was Mr. Nichols was sitting there using those backwoods to roll himself a marijuana blunt? Do you know?
I don't know.
Okay, thank you. Okay, in the entire BP video, we see Shymel Drinks show up, correct?
Yes.
Okay, and again, no indication that anyone was expecting him to show up.
No.
Okay. While Shymel Drinks was present at the BP, he walks into the store, correct?
He does.
How many times does he walk in the store? Once or twice?
Just once.
Okay. And he makes a purchase.
Correct.
And there's apparently some other man on the video that's trying to steal some condoms or something, and the clerk is having a problem with him, correct?
Yeah, there's a little kerfuffle.
Okay.
Sustained.
Do you see a man getting into it with the clerk and then suddenly pulling condoms out of his pocket and throwing them back at the cashier?
I remember that interaction. I don't know his condoms, but yeah.
Okay. And then Mr. Drinks has some interaction with that individual, and they leave together at the store?
Yes.
Okay. Do you know who that person is, the person that Mr. Drinks was interacting with?
Do not.
Okay. Have you ever interviewed the clerk about what was going on in the store?
No.
Do you know who the clerk was?
No.
Okay. Throughout the entire time that Mr. Drinks is on the video, and quite frankly, Mr. Stillwell is on the video at the BP, Mr. Farley, or Mr. Nichols, do you see any interaction between Mr. Drinks and any of those three individuals?
No,
Do you see any hostility between Mr. Drinks and those three individuals?
no.
Okay, Mr. Drinks was having some hostility with the clerk, right?
He was observing that, but yes,
Okay. But not with these individuals. You don't see any mean looks or anything, do you?
no.
Okay. So then we go to the King liquor store video.
Gotcha.
Okay? And just to be clear, do you know how we have timestamps on some of these videos and no timestamps on other videos, right?
Yes,
Okay. The videos that have timestamps, and I understand that King Liquor and the BP are under the same management, right? You don't know?
not privy. It makes sense, but
Okay.
I'm not privy to that.
All right, but do you have any reason to believe that the BP video, the timestamps would match perfectly with the timestamps, or they're perfectly synced up with the FedEx video, for instance?
Oh, I don't know.
Okay, and do you have any reason to believe that any of these videos would be perfectly synced up with phone records or anything like that? Like records held by Sprint or another phone company?
No,
In your experience as an investigator, businesses that have these surveillance systems, there are times, you know, you can get an hour of footage, but the time on that footage can be off, correct?
it can be, yes. If not set correctly, yes.
Okay. All right. In the BP video, besides the Ford Fusion, the Nissan Versa, and the Audi, did you note any other vehicles of interest that piqued your curiosity in the BP video?
No,
Okay. How about in the King's
Didn't even try to
liquor
look.
video, when you see three
Wow.
cars driving up Windsor Street? Did you see any other cars that piqued your curiosity?
no.
Okay. Let's talk about the FedEx video. We do see the red Versa go up to the left lane, correct?
Yes, we do.
And we do see what appears to be the white Audi, and especially when you link it up with the BP video, end up in the center lane, correct?
That's correct.
And then we do see the white Ford Fusion end up in the right lane.
Yes,
And we do see the white Audi run a red light, don't we?
we do.
Okay.
Sorry.
Do you know anything about the history of the attempts on Mr. Stillwell's life?
I do not.
The Woody
Okay.
question.
You don't know that in 2015, a car gunned up behind him or sped up behind the car that he was in and riddled the back of that car with bullet holes?
Objection, he said he doesn't know about any attempts.
Sustained.
Have you ever heard the name T.R. Jones?
No,
Okay. Anyways, you see Mr. Stillwell run that red light in the white Audi.
I do, yes.
And then you see Mr. Nichols in the Ford Fusion run the same red light.
Yes.
Okay, cool. In that video, we see well, I'll get there in a second. Let's talk about LPRs. Detective Bender helped you with the LPRs in this case, correct?
She did, yes.
And you consider this an important part of police work because you're able to track the movements of specific cars.
Yes,
And you, at that time, felt that the white Audi was a suspect car, correct?
I did.
And you wanted to track its movements.
Yes,
And you thought the white Ford Fusion was a suspect car.
I did.
And you wanted to track its movements.
I did.
And Detective Bender was able to get you all that information about the movements of those cars, or I shouldn't say the movements, but different places in time and different times where the LPRs picked up those license plates throughout those 2 days that you ran them. Believe it was 2 days.
Yes, whatever she found, she was able to identify the tag numbers and the cars and where they were, yes.
Okay. As lead investigator, besides the Versa, besides the Audi, and besides the Fusion, did you ask Detective Bender to run LPRs on any other specific cars that you may or may not have seen in any of those videos?
I couldn't ask her to run something I didn't see, and there was no other cars. No.
No other cars that piqued your interest?
No, sir.
Okay. All right. You were able to obtain the rental agreement for this Audi, correct?
Yes, sir.
And you're aware that Mr. Stillwell rented this car on 3/14 at approximately 3 in the afternoon?
Well, let me check. Yes. That's correct.
And you are aware that he gave all of his personal information, his license, his signature, his phone number, his address. He appeared on surveillance at the Alamo. He did all those things while renting that car.
Yes.
And you're aware that in the early morning of March 16th, which would be 2 days after this incident, Investigator Viverito and Investigator Flores spoke to him in the back of a police car after the house he was in was shot up, correct?
Yes.
And they took pictures, right?
Yes.
And you're aware that he told Investigator Viverito, yes, that's the car I'm driving.
He did.
And you're also aware from the Alamo records that later on March 16th, 2022, he actually called Alamo to extend his rental on that car until March 20th, correct?
I wasn't aware of that.
Okay. Could you look at your investigative summary, if you would? And I'm going to refer you to page 19.
Okay.
Okay, does page 19, it's page 19 of 25.
Yeah, at the very top you're talking about?
I'm about 2/3 of the way down. Do you see a notation, 16 March 2022, 1337? Shannon wants to extend the rental or the rent?
Yes, I do see that.
Okay. And then at 1337, they talk about a rate, and then Shannon agrees.
That's correct.
Okay, so under your theory, my client appeared on video at the BP with this rental, is on video shooting man out of the driver's side of this rental, and then 2 days later is telling Investigator Viverito, that's my car, right?
Yes.
And then also later on March 16th, seeks not to get rid of this car, but to extend the rental.
It appears so, yes, sir.
Okay. All right, let's talk about gunshot residue. You testified earlier in this case, and we talked a little bit about gunshot residue, right?
Yeah, we did.
And you said you got to be careful about gunshot residue because of the false false positives.
Right, yeah, he could be
Okay.
anywhere in the room. If a gunshot goes off, we all in here would have gunshot residue on
And there was none in the car.
Right. We're talking about microscopic particles
That's correct.
that are expelled out of a vehicle, out of a firearm when a firearm is shot.
That's right.
Okay. And these particles are expelled in a way that you just said, if someone shot a gun in here, we could all have gunshot residue on us.
That's correct.
Okay, and that would be unfair if I shot a gun to say, well, you have gunshot residue on you, because that would be a false positive on you.
That's correct.
Okay, but gunshot residue does detect if a gunshot was fired in the area, correct?
Yes, it's evidence of that a gunshot was in the area.
Listen to him.
Right.
All right, especially in fabrics and cloth and things of that nature, correct?
I'm not that would make sense to me, but I'm not an expert on it, but yes.
Okay. Well, those type of materials would not be subject to something like hands where you could sweat the gunshot residue off, correct?
That's correct.
Okay. And in this case, that FedEx video that you viewed, we see traffic lights, right?
Yes.
We can see brake lights, correct?
Yes.
We can see headlights, correct?
Yes.
What we don't see is a muzzle flash, do we?
No.
Okay. Now, you testified about shell casings.
Yep.
And you said you looked all over for shell casings on the scene.
We did, yes.
And shell casings are the cartridges that are expelled when a gun is fired.
That's correct.
Okay, and there were at least 2 or 3 shots fired just from looking at Mr. Drinks' the red Versa, correct?
At least, yes.
Okay, so you were looking for 2 or 3 or possibly more shell casings on the road, correct?
Yes.
Okay, and you didn't find any?
None.
And your conclusion was, of course, maybe you missed them, that's always a possibility, but the other possibility, as you stated in direct, is the person who's shooting the gun didn't put the gun outside of the car where you would see the muzzle flash. The gun was actually inside the car when it was fired, correct?
Yes.
Okay, and certainly if the gun is inside the car, that would cause gunshot residue to be spread throughout the car.
You assume so, yes, sir.
Including the headliner, correct?
Yes.
Okay. You decided to collect the headliner.
Say again?
Well, let me ask you that because I don't know that for certain. You worked along with CS crime scene technician Antoinette Green to process this car, correct? The car being the Audi. Mr. Stilwell was arrested
Yes.
on March
I'm
17th.
trying to recall, because it's not in my report. I knew you were going to, but I don't. Do you have anything to refresh my memory? Do you have a crime scene report with my name on it? Because I don't.
I don't have anything written by you, sir.
Yeah, I don't.
Okay, but let's try to work through this. On March 17th, you know that Mr. Stilwell was arrested on the warrant state that you brought on March 16th.
Yes.
Okay, and he was arrested in Atlanta. He wasn't in another state or anything like that, correct?
Correct, yeah.
Okay. And when he was arrested, he was actually still in the white Audi that he had extended the rental for, correct?
Yes.
Okay. And the Audi was collected as evidence, correct? Brought to police impound.
That's procedure, yes.
Okay. Are you not aware that crime scene technician Green, do you know who Antoinette Green is? Is she a crime scene technician with APD?
Yes.
Are you aware that she processed that car?
I don't recall for sure. I know I've done several cars with her before, but in this particular case, I don't recall being with her to process the car. This particular car.
Do you recall a headliner was collected in this case, correct? You do know that?
I do not.
You don't know that the headliner of the Audi was collected as evidence in this case and analyzed?
It makes sense that it would be, but I don't,
Okay.
I don't recall that, no, sir.
In your experience, your expertise as an investigator, a homicide investigator, a headliner would be a very appropriate piece of the car to collect, to check for gunshot residue.
Again, yes, sir, it makes sense. I'm sorry, I don't recall it.
And it should have gunshot residue in it if a gun is fired from within that car, correct?
If it has not been cleaned, yes.
Okay.
Hold on, you hear that? He's being so resistant, and then finally he thinks he has his moment to push back against Schardt by saying, if it hadn't been cleaned, yes. So he finally concedes that it's something they would have searched and expected to find something on. He's pissed. He knows he never found anything on it.
All right. Do you know, as we sit here today, whether or not a GBI analyst tested that headliner for gunshot residue?
Do not.
You don't know what the results are either, do you?
No, sir.
Okay. Okay. You took out warrants on March 16th, 2022 at 6:39 p.m., correct? For my client as well as Mr. Nichols and Mr. Farley.
Yes, well, 6:40 p.m., but yeah.
Okay, 6:40 p.m.
On the
And that was
16th, yeah.
And that was right after, or shortly after you had that conversation with Investigator Viverito in police headquarters, where she identified the people that were in the BP
That's
video.
correct. Yeah, her,
Okay.
the Sergeant Belknap, yes.
So once you had an identification from the BP, that's when you move forward with the arrest warrants against Mr. Stillwell.
That's correct.
Okay. All right, well, I want to talk to you about your analysis of the FedEx video. You have your report in front of you, correct?
I do.
Okay. At the time that you swore out these warrants against Mr. Stillwell, you had never even viewed that FedEx video, had you?
I don't think I got that till afterwards. I did speak with a representative who described it to me and sent me some still shots.
Okay, and I'm gonna go to page 14, going into 15 of your investigative report.
Okay.
On page 14, going to 15, you write, as of the writing of this report, and this report was written on 3/20/22, correct?
Well, that's when I started it, but yeah.
Okay, so you started this report 4 days after you you obtained the arrest warrants for Mr. Stillwell.
That's correct.
You started this report 4 days after that. Okay.
Yes.
And-
This part, now I had notes and all that stuff, but
Understood. And you say, as of the writing of this report, the actual video from FedEx has been requested via a subpoena, but has not been received. The above pictures were sent to me by a FedEx corporate officer who told me that he had watched a video which shows that the two white cars pulled up alongside the red Nissan, forming a straight line across the road. And then suddenly the two white cars sped away against the red light and the red car stays in place. That's verbatim from your report, correct?
yes, sir.
And your report is accurate to that fact.
It is, yes.
You, at the time of writing this report, and certainly at the time of bringing out warrants against my client, you had not watched that FedEx video.
No.
But you had spoken to someone at FedEx corporate that sent you some still pictures, correct?
That's correct.
And had told you what they felt they saw on that video, correct?
That's correct.
Okay. Who was that FedEx corporate officer who analyzed this FedEx video?
I don't remember.
Do you know that person to have any law enforcement training?
Not familiar with it.
Say it's a friend.
Do you know how many times that person watched that video before giving you his or her conclusions about what the FedEx video contained?
No.
Okay. When did you finally receive the FedEx video?
I don't recall exactly when I got it.
Do you remember what month?
No, I don't remember.
When did you remember when you first watched that FedEx video?
I've seen it several times, but I don't remember when I first saw it, no.
Was it months after bringing up these arrest warrants on Mr. Stillwell?
No, it wasn't months. It was a few days probably.
Well, a few days would have been 4 days afterwards you started writing this report, and you didn't even have the FedEx video then. So could have been longer than a few days before you watched the video?
It could have, yes, it could have been.
Okay. And of course, you brought those warrants on March 16th, 2022, without any gunshot residue results from that white Audi.
That's correct.
You said you saw a car in that video, the FedEx video. Ms. Hylton, could you play the FedEx video for me? Thank you. And it can be 101:20, we can start. I think it's fair to say you saw a car making a U-turn on the video and you saw it was a little odd.
Yes.
It piqued your interest?
Well, it just, yeah, it did. I wouldn't say it piqued my interest. It just went with the situation, I guess.
I think you said you thought on direct, you testified, you thought that the person driving that car may have heard or seen something, correct?
Yes, I did.
And the reason you say that is because that person driving that car abruptly made a U-turn.
Yes.
Okay.
I'm ready when you are. It's not ready.
Oh, I'm sorry. If we could go to 101:20, yeah, just. That's that's the red Versa pulling up, correct?
Yes, sir.
Okay, and that would be the white Audi?
Yes.
And that would be the white Fusion pulling up on the right lane, correct?
That's correct.
That's not the car that makes the U-turn, is it?
No, sir, I don't believe so.
Okay. And Mr. Stillwell is now running the light. He's no longer there, correct?
That's correct.
Okay. We see. Now this car pulls up. and makes that interesting U-turn, correct?
Yes, sir.
And your determination is maybe they did that because they may have seen or heard something, correct?
Maybe.
Okay. I have no further questions. Thank you.
And Ms. Weinstein.
No, Your Honor.
Redirect.
Let's see this redirect.
I actually want to start right here at the FedEx video. Was there anything in the video, once you actually watched it, that was inconsistent with what you were told by the FedEx person?
No, ma'am.
In the video we just watched, prior to Mr. Stillwell fleeing into the red light, was the white Fusion and the Audi stopped for a moment before fleeing into oncoming traffic?
Yes.
Now, Mr. Schardt asked you a number of reasons as to why a person may rent a vehicle. Do you remember him asking you that?
I do, yes.
Or why they may put tint on a window? Do you remember him asking you a series of questions?
Yes.
Can a person place tinted windows on a rental car to conceal themselves in an attempt to seek revenge on the person that they think may have killed their two friends 3 days before?
Yes.
Mr. Schardt asked you a series of questions about whether or not someone may be rolling a blunt in a car or things of that nature. Do you know if while they were sitting in the car, both the individuals in the Audi and the individuals in the Ford Fusion, if they were maybe talking to each other in the car? Do you know if they were doing that?
I do not know.
Do you know if the people in both cars were on FaceTime with each other?
Do not know.
Do you know if the individuals were in the car planning at that time to kill someone? Do you know if that was happening?
I do not know.
Mr. Stillwell, the Audi was backed in. Is that fair to say?
Yes.
Okay. And if the Audi was backed in, did they have the vantage point of seeing Mr. Drinks when his car pulled into the gas station?
Yes.
Okay. Did the Audi, because it was backed in, have the vantage point to see Mr. Drinks as he walked into the gas station?
They did, yes.
Did the Audi, because of his vantage point, see when Mr. Drinks left the gas station and got back into his car?
Yes.
And was it the Audi that immediately pulled off once Mr. Drinks' car pulled off?
Yes.
And then the Fusion followed?
That's correct.
And that was the same vehicle in which Mr. Jackson, it appeared, was the driver?
That's correct.
Mr. Schardt asked you a number of questions about the facial features of, I think, both Mr. Nichols and Mr. Stillwell while they were inside of the gas station. Do you remember him asking you a series of questions about that?
Yes.
Do you know what their facial expressions looked like while they were in the tinted vehicle?
No.
Do you know if, as they saw Shymel Drinks walking into the car, that their facial expressions changed from what they looked like inside of the BP gas station?
I think we're getting to facts, not evidence. It's complete speculation at this point.
Sustained.
Now, I want to show you what's already been admitted as State's Exhibit 118 BV. And I'm going to go to 9:49 p.m. the read. And does that read, say, Windsor Street and Richardson Avenue?
It does, yes.
And is that location that's not too far from the BP gas station?
That's correct, yes.
And at what time is the Audi passing the LPR reader on Windsor and Richardson Street?
9:49 with 6 seconds.
And Mr. Schardt asked you whether or not the surveillance video camera times are accurate. We're looking at this time here at 9:49 and looking at the surveillance video timestamps, especially at the BP. Would that help you determine if whether or not the BP gas station video was accurate or not?
Yes.
Okay. And based on looking at both the LPR reader and the timestamps on the BP video, are those times, do they seem to be accurate?
They seem to be similar, yes. They're not exact, but they are similar.
Okay. And about how far would you say the Richardson and Windsor is from where that BP gas station is?
Not far. It kind of depends on traffic and the light, but anywhere from a few seconds to a minute or two.
Okay. Now, Mr. Schardt asked you about the headliner and gunshot residue. Do you remember those series of questions?
I do.
If a car is cleaned, could that remove any GSR that may have been in the car?
From what I understand, yes.
Now, looking at the BP video and FedEx, did any other car besides the white Audi and the white Fusion that immediately followed the red Versa, was there any other car that immediately followed the red Versa out of the BP gas station?
No, ma'am.
Were there any other cars that pulled up right next to the red Versa outside of the Audi and the BP and the Fusion?
No.
Was it after the Audi and the Fusion pulled up right next to the red Versa, and after they left, the red Versa just sat there for about 27 minutes?
That's correct.
The damage on the red Versa, is that all on the driver's side of, on the passenger side of the red Versa?
That's correct.
And is that the side of the vehicle closest to the driver's side of where the driver's side of the Audi would have been?
Yes.
Now, Mr. Schardt asked you a number of questions. You know, why would someone keep the rental car, or why would they say that the car was their car with a car with a name? Do you remember some questions similar to that?
Yes.
At the time in which Investigator Viverito was speaking to Mr. Jackson at the house that got shot up, had you and Investigator Viverito talked about your investigation?
No.
Had you shown Investigator Viverito your surveillance video by the time that she was, at the time that she was talking to Mr. Stillwell at that house?
No.
Prior to talking to Investigator Viverito, did you know that there was a white Audi at a house that was recently just shot up?
No.
Did you know that Mr. Stillwell was in a pink Floyd shirt prior to talking to Investigator Viverito while she spoke with him at the house that got shot up?
No.
Did you know that Miles Farley was with him at the house that just got shot up in the same clothes prior to talking to Investigator Viverito?
No.
were you ever made aware of an individual by the name of Demekion Garlington was also at the house along with Miles Farley and Shannon when investigator Viverito spoke with them?
No.
With the red Versa, did you ever learn if that was a rental car or not?
No. It was, I don't believe it was. I believe it belonged to one of his family members.
Okay.
I'm sorry, I didn't hear that.
I believe it belonged to one of Mr. Drinks' family members, the red car. I think, if I recall right.
Did the Versa have any tinted windows?
No.
I feel like that's a risky question to ask.
Court's indulgent for one moment. Mr. Schardt asked you about Mr. Stillwell's conversations with investigator Viverito at the home. Do you remember him asking you about the conversation that Mr. Stillwell had with investigator Viverito when she met with him at the house?
Yes.
To your knowledge, did Mr. Stillwell ever tell investigator Viverito why he had tinted windows on a rental vehicle?
No.
Did he ever tell investigator Viverito why he put tints on the car within a few hours of renting the vehicle?
Objection, Your Honor. That's not enough.
Sustained.
Mr. Schardt asked you about seeing a muzzle flash at the light. Did you see any muzzle flashes at all on that surveillance video?
I looked for him, couldn't see any, no.
But was there still a deceased individual sitting at that light once you arrived on the scene?
Yes.
All right. And do you have any knowledge if Mr. Stillwell told investigator Viverito when he put those tints on his vehicle?
I do not.
I have no further questions.
Recross?
No.
Okay.
Thank you.
Thank you.
Nah.
Thank you.
All right, you're excused. I believe y'all have got one more witness.
He's gonna be long, but we can start.
What?
We can start him, yes, he's gonna be long, is what she said. We can start.
How long?
About an hour and a half.
To an hour and a half? Wish y'all had kept a shorter witness. Okay, I guess we'll stop for the day. I mean, I don't know who the witness is.
Detective Vampire.
Who?
Detective Vampire.
All right. Yes. I mean, I'd really like to stop court in, for the day in the middle of a witness, so I'd rather not do that. I mean, unless nobody cares, we can knock out 40 minutes. We can also approach if y'all want to discuss.
Yeah, that was love, right? She was like a deep throat laugh,
You're fine anyway.
pause, phrasing. She was like,
Whatever you think. All right.
We did the number.
All right, ladies and gentlemen, I'm going
All
to
right.
excuse y'all and remember that y'all will not be back with us until Tuesday because Monday is Veterans Day. For any veterans, thank you. So I'll see y'all on Tuesday. In the meantime, do not look at any kind of accounts or read or listen to or in any way absorb any kind of accounts or information about this trial or anybody involved in it. Don't talk to anybody about the case. Don't let anybody talk to you about the case. And we'll see y'all on Tuesday. Hope you enjoy your little break for a few days.
That's a non-stuff.
Yeah, I think Max did a good job. I don't think Hylton did a bad job trying to I mean, she had a very cooperative witness to work with, right? She could ask certain questions and know what he was going to respond, you know, just like he'll say, well, you know, we could search things, but if it's cleaned, right? So Hylton had a slight assist there just because of the way Hogan will answer her questions. But Schardt really...
We're here on, no, I know, we're here till Friday.
Yeah. I mean, they know. Oh, yes, yes.
No court tomorrow at all, but.
No court tomorrow. Friday, we're doing non-jury matters, and I need a list of what we need to cover by that time. And then by Monday, I need at least preliminary jury instructions.
Me standing here was trying to get ahead of being told that I hadn't responded to Ms. Percefield's
Oh, no,
emails.
no. I mean, I know y'all have been in court all day.
The
but-
plan, I think myself and Mr. Weinstein are going to meet tomorrow morning.
Okay.
And we're going to do everything we can to compile a list and get it out to the court
Okay.
and the state as early as possible from our perspective, what needs to be on the agenda on Friday.
Great, thank you.
I wonder if it'd be possible, maybe we'll have nothing on the agenda.
I mean, that would be fantastic, but highly unlikely. Yeah, I mean, honestly, y'all, if you want to like work amongst yourselves to narrow down whatever we are going to have for Friday, that would be fantastic.
In all seriousness, I think one of the biggest things that needs to be litigated, I have, and I'm not trying to speak out of school, but I've had conversations with Ms. Hylton, and there's talk about what they're really going to seek to admit from my client's phone.
Right.
And also from the wiretap, and there's rumors that that might be pared down. But I think what they're seeking to admit and also the mechanics of how that would be admitted, I think are probably something that we need to discuss, especially as it applies to Investigator Viverito.
Okay, well, y'all can discuss that amongst yourselves first. And certainly, I know we've definitely had indications from Ms. Hylton that the wiretap and cell phone evidence was going to be pared down. It's probably time, if you have not shared yet what that paring down is, to share that with Mr. Schardt so that.
Do that tomorrow.
All right.
Judge, you said the jury charges will start on Monday or Tuesday?
No, I'd like for y'all to have to me at least your preliminary stab at what y'all are going to want for jury charges. And I'm not saying we're going to take them up then. We're going to be doing trial next week, but.
The reason I'm asking is you also asked about Mr.
Yeah.
What day?
I don't know. I don't know. I mean, how, do y'all want to just come up here and discuss scheduling?
Yes.
So we'll see if they come back on the record. But I was going to say, I really think you can see the little things that Schardt touched on are pieces that he's pulled from, you know, we heard stuff that he referenced when Kenneth Copeland was on the stand, things that he was sure to ask the first time Hogan was on the stand. You can tell that he's looked at this whole strategy, this whole trial as the long play for the things that actually pertain to his client. So I thought that was great to see. And some more of the meat and potatoes about this stuff is going to happen when we have Starks and Viverito and then whatever the other person's name was. Lamrocker? I don't know. I don't know, you guys. Oh my gosh, yeah, if Jeffrey Williams throws a concert, can the jury go to it? I mean, if you were the juror, like, you were told not to concern yourself with his prosecution, so is it, like, related to this case to go to a show? I mean, I'm sure that's not gonna coincidentally be on the table as an opportunity, but good question. Yeah, STS, I don't know, because you do see the hazards start to go at some point. And you know, hazards might not blink as soon as you press the button. It might be like the first beat is the off and then it blinks on. And it's split seconds that we're working with. I don't know. I'm all confused because we have these questions that the injury, the medical examiner thinks that he should have been incapable of doing certain things. But then if he turns the hazards on, I don't know. And a lot of this, yes, I can't believe he investigates murders. He doesn't seem to look at the other things that could be suspicious. Even when he himself, on direct, is noting that, oh, I thought that thing was pretty peculiar. So, I don't know. But again, guys, at the same time, with circumstantial evidence, just because it's circumstantial doesn't mean that a juror or jury, all members of the jury, can't decide that it's enough, that the state has shown enough to convince them that, you know, beyond a reasonable doubt that this must have been the way it went down. As far as what would the motive be, I think Viverito is going to be the one that gives us testimony on why this, according to the state, was a back and forth between YFN and YSL from the Ford and McMiller shooting 2 days before the Shymel Drinks shooting, and then the shooting 2 days after the Shymel Drinks shooting at Waters Road. So lots of stuff going on there. Right, so it could have came from the Fusion and not the Audi, whatever. And it's really not Shannon Stillwell's job to to try to protect any other client, any other indictee, not client, indictee. So the Honorable, yeah, that says 2 cars, 4 people, no gunshot residue, shells. I don't think it's enough. Yeah, so again, it was 9mm though, so I guess, you know, the casings, I have shell casings like implanted in my mind for this trial because of how many pictures Mr. Brown took us through. But this is 9mm here. But as far as the no gunshot residue, no glass on the street, I get that the impact is supposed to go inside, but nothing, even from opening a door, is visible in pictures of the pavement. I don't know. It's a little weird there. It's a little weird. Guys, there's just a lot of questions. Yeah, Casey Dog says just waiting on the Audi expert to fly in next. Big shout out here also to Squirrel Brain Gang. I am loving the new picture. If you're not looking at your screen, Squirrel Brain Gang, who used to be Squirrel Brain for Thorpe, but is upgraded because of the new memberships, the new enrollments in the Squirrel Brain Gang. We've got the Shrugging Squirrel. Hello, Cat and Chat, little behind today. I watched the Karen Reed hearing regarding not guilty verdicts, polling the jury, free Karen Reed, then had to change my picture to better reflect my feelings today. Hope everyone is well. And again, I think that's a double jeopardy issue, right? I have some concerns about search warrant representations in this case. You know, speaking to a client without telling him that he's really a suspect, that you're already marking him as a suspect, getting statements from him without telling him what you're really doing. in the YSL case. And then over in the Karen Reed trial, I think we have a double jeopardy issue that's a really big question. And each of these things, you know, you could put the facts of the case aside and it would still be an issue to consider. Should that be okay? Should that be a means to an end to sacrifice certain rights? Miranda rights. You know, the right against unlawful searches. The right to not be tried over and over and over when a jury was willing to acquit you. Or a jury's been sat and something happens, like prosecutorial misconduct, that causes the jury to be discharged, right? These are all big questions of rights that go far beyond this trial. So great to have you, Squirrel Brain Gang. That was awesome to look at this morning and hear those arguments. I concur, a little bit of grump there. KC Dog says the state tells stories like Benjamin Button. Chloe Albert's revenge, and the whole chat was hilarious when Schardt said riddled. Riddled. And right, that was a very impactful moment. The jury didn't get to hear the representation. That was an evidentiary hearing. The jury wasn't there when Hylton was trying to say riddled with bullets. Well, how many bullets won? But Schardt, nevertheless, paints this image of, do you know that my client has been at risk? He could have people looking for him. Different occasions where his car has been shot at, riddled with bullets. So he's using that imagery that the state wanted to hyperbolize for their own use. And he's using that imagery.
That was just some scheduling matters which we need to talk through. So if there's nothing else, court's adjourned, and I will see y'all Friday at 9.
Friday at 9, you guys. So Friday at 9. But yeah, he took that imagery, and I think that was really effective for him to do. And then brought up the Tiara Jones. And not only is that really what actually happened, we had a loss of life with Tiara Jones, but if that name is something that the jury can remember, you're also giving, like, strategically, you're making the jury think about protection of self, but protection of others. So not only would I have the windows tinted, Hogan saying, you got to tint the windows to hide yourself if you're doing something shady. That's the explanation for it. But Schardt, very artfully, snuck in, well, it could be for the protection of others, who we haven't heard anything about doing anything shady, like Tiara Jones. Right? So it's not just to protect yourself, it could be to keep others safe with no direct causal relationship to someone being out to get me in a retaliatory gang shooting. So, as far as me being on tomorrow, no, I'm actually recording a course all day. So I've got to do some other work. If I do pop on, it's going to be something completely accidental. But I will be here Friday at 9. We will do that. And maybe that sounds like maybe it won't be a whole day, but whoever knows. STS also says, do your shopping before doing a crime, right? According to Hogan, how would Hogan explain this? You know, would you expect people to go and roll up, sit in the car, waste time on camera sitting somewhere when they're out committing crimes? And again, by the state's theory, these guys should be scared of retaliatory shootings this whole time. This is supposed to be some whole back and forth. So if that's really the case, it doesn't make sense that Shymel Drinks would be sitting in the parking lot. It doesn't make sense that the others be sitting in the parking lot. Both sides would be lacking if the scenario was they're in the same area that each other might frequent, and they're just sitting there for 5, 10, 15 minutes at a time and then going back there later. It doesn't make sense. It doesn't make sense according to the theory, the logic, the rationale that the state tries to put forth. So yes, always do your shopping before doing a crime. Use your credit card and smile at the camera. Make sure your phone location is on. Great advice, great advice. Thank you so much, STS. And then Rex McKnight, we've got to take a minute here. Rex McKnight, you guys, this is Muck Duck Inc. I think we are getting, we're doing a bridge to the new channel. So when you see these two names, it's because Rex is starting a new channel. And it was super cool. Thanks to you guys in the chat. Before he gets his first content, we got over 100 subs. So if you're interested in supporting Muck Duck Inc. / Vegas Reaper Rex McKnight, and or if you're interested in Blackjack, Vegas, classic style playing, dropping a link in the chat right now. So hop over there. It is great to see you. Sorry I'm taking so long to get to this, but thank you so much. This was 10 gifted memberships plus another 50, you guys. That is 60 gifted memberships. So if you guys want to throw some ducks in the chat, that would be super amazing. Let me find the little duck with the green hat. You know, next time I see a mallard duck in real life, I'm just going to think of Slime, the green feathers. So super appreciative here. Both Rex and Muck Duck here. And then also this guy is putting me to sleep. You know, a little bit of it was slow today. But I do think for the most part, this stuff was pretty interesting. Right? I was really trying to follow along what was happening in these videos. I was pretty tuned in. I might yawn anyway. I yawn a lot. My bad if I'm making it contagious. But yeah, as far as someone putting me to sleep today, maybe earlier in the day, but I was locked in as soon as Schardt got up there. So hope you're awake now. Maybe you were on replay there. One happy white girl says, I would try and help. Okay, so if we are, if we pull up, if we see that someone next to us got shot or whatever, we see trouble in the car next to us. This is the scenario that I put forward. One happy white girl saying, I would try and help. In my mind, if the person is in a car bleeding out, all the danger's gone. The perpetrator isn't coming back to check pulses. Great point here. And remember, we really didn't have someone, it looked like a pretty busy intersection, and maybe when you're driving by, you don't really notice that a car's sitting there with something wrong with it at night, right? But maybe pulling up next, looking over, sitting through a light, noticing that the car is not moving, maybe you get a little curious there. So shout out to Cheeseboro, who like realized something was wrong here and finally made the call, right? That would have been the one happy white girl. So shout out to you, Good Samaritan. Chloe Alberts-Erven says, as the shop steward of the YSL Trial Jurors Union, juror number 56 would like all testimony run past him first for possible 403 violation. Thank you. And guys, the reason they went through those videos twice was just to get the timestamps established. I don't know why they didn't do that on the first run. Could kind of seem like a little bit of an excuse to show the storyline twice. Because remember, Hogan was narrating it both times. KC Dog says, again, the state don't believe in any order. Nope. One happy white girl says, how can the jury tell it's an Audi? And I have questions about that too. I don't really think they've told us. I mean, maybe that FedEx photo is where they got the plate read from. I mean, because Schardt didn't go in on that. Schardt is just conceding that that is the Audi, and that was Stillwell driving off at the red light. So it seems to me like Stillwell's conceding. I mean, Schardt is conceding that that's Stillwell. His alternative theory, what he's deciding to argue, his strategy is raise questions about that weird U-turn, right? So by the time we got to Schardt, he seems to say that that is the Audi sitting at the intersection. So, what are we looking? I see everyone saying something about Steph. What are we doing? Hold on, wait. Tagging me on X. Let me look. Okay, this is a little different. This is from Jamie. I mean, this might also be the same thing. I'm seeing other tags. So, suspects are initially March 15th, victim Shymel Drinks, homicide, suspects Christian Johnson. So, yeah, who is this person? So how is this person? The fingerprints that we were looking at. So that's one question there. Let me keep going. And then Nick posted it. Okay. Is this, are you, sorry, is this what factual lie was tagging me? Because I just went to Nick's wall. Okay, wait, hold on. This doesn't let me zoom. Okay, August 25th, and in Texas. How would this be the case? Can you do this license? So I don't know the process. Can you do this without, like, if Shannon Jackson's in custody? Like, so I don't know, guys. Like, I would be very cautious to just jump on this train. I would be very cautious. So Texas allows marriage when another person isn't present? Even across states? I don't know, that just seems weird. Yeah, guys, I don't know. I mean, if it's true, it's true. And that issue can take its time to play out, but I mean, that seems like a weird system that you can just do that without someone actually being in the state. So, yeah, so I don't know, you guys. And then the Drinks foot comes off the brake, go back to the... Hold on, wait, is this when Hylton's replaying it, or is this when Schardt was playing it?
Made a U-turn.
Yes.
Okay.
I'm ready when you are. It's not ready.
Oh, I'm sorry. If we could go to 10120, yeah, just. That's that's red Versa pulling up, correct?
Yes, sir.
Okay, and that would be the white Audi.
Yes.
And that would be the white Fusion pulling up on the right lane, correct?
That's correct.
Oh, sorry. My bad, let me rewind it. My bad, guys. My whole head is blocking the
Correct.
thing
That's correct.
exactly.
That would be the white Fusion pulling up on the right lane, correct?
That's correct.
That's not the car that makes the U-turn, is it?
No, sir, I don't believe so.
I mean, his car moves
And,
a little there.
Mr. Stillwell is now running the light. He's no longer there, correct?
That's correct.
Okay. We see. Now this car pulls up and makes that interesting U-turn, correct?
Yes, sir.
And your determination is maybe they did that because they may have seen or heard something, correct?
Maybe.
Okay.
Yeah, there's
I have
the
no further
light.
questions. Thank you.
There's the light again.
And
Catch that twice.
Mr. Stillwell is now running the light. He's no longer there, correct?
That's correct.
And I would even argue, so have you ever been at a light and you see the car next to you start to like release their brake and move, and you're like, you double check to make sure, like, that's, you think that the light is turning green also, even though it hasn't, but you're like ready to, if it is a green light, because you see the other car move. That could be what's happening when the car rolls forward when Shannon decides to book it across the thing. At that point, Drinks could be well alive. And this other car that pulls up, what's going on with that car? So, hold on, let's rewind like 20 more seconds to right when this third car would be pulling up. Now we're doing the buffering thing.
Red Versa pulling up, correct?
Yes, sir.
Okay, and that would be the white Audi.
Yes.
And that would be the white Fusion pulling up on the right lane, correct?
That's correct.
That's not the car that makes the U-turn, is it?
No, sir, I don't believe so.
Okay. And Mr. Stillwell is now running the light. He's no longer there, correct?
That's correct.
Okay. We see. Now this car pulls up and makes that interesting U-turn, correct?
Yes, sir.
And your determination is maybe they did that because they may have seen or heard something, correct?
Maybe.
Okay.
And then the lights are flashing right here. So we go back, like, it's going to take it 10 seconds back, I think, 5 seconds. But this is where you see the lights flicker. What if he gets shot at, gets to the light, is trying to get his sense together, is about to try to shoot at the car that pulls up next to him, having no clue who actually shot at him, is losing consciousness anyway, and Shannon realizes somebody's in the other side holding the gun out and says, "Oh, we booking it." On the other hand, it does look like the Fusion is pulling up, but that could just be to inch forward to make the right turn, depending on the angle of the street.
Something, correct?
Maybe.
Okay. I have no further questions. Thank you.
Oh, did it?
And Ms. Weinstein. Redirect.
Did I catch the flash? Do you guys get what I'm saying though? Like, if the shooting happened before the camera angle of the FedEx, and he has enough juice in him to get to the stoplight, but he's losing consciousness and he's trying to react, his hands in his pants, the gun's on the seat, a little bit of mess, understandably so. But he's trying to, maybe he's holding the gun and try to look the other way. That would explain how there's a gunshot coming from the window. It happened before he got up to the red light. And it would also explain why something might make Shannon Stillwell want to book it. Because the guy in the car next to him is about to shoot at him randomly when the guy in the car thinks he's shooting at whoever shot at him. So, yeah, and the problem with this, though, Stimpy, I know that's what was said, is that there's still movement and or lights come on after Stillwell has booked it away. So it wouldn't have been instantaneous. It might have been 2-3 seconds, but instantaneous, I'm questioning what the ME is representing there. So Yeah, U-turn, lookout car. And the thing, and this is the thing, the detective didn't even try to look, so. Yeah, and it could have been a whole mess. And it's, there might be a chance that Shannon Stillwell has certain context that we haven't heard and that maybe he won't introduce in front of the jury. But maybe Shannon remembers, like, I pulled off in that moment because that's what I always do, or I pulled off in that moment because something specific was happening and it was weird. So, yeah, all this talk is reasonable doubt. Yeah, where's the flashes? And I think this is a problem because for it to be instantaneous death, we still see it looks like the hazards, the lights are coming on at that moment. So I guess the body could have jerked or something. But if the immobility is supposed to be instant, I mean, yeah, I think this is a great reason too. Saw the cars coming up behind him. Yeah, the people walking on the side of the road, which is hard to tell because in some, especially the one at the intersection, that body just like because of the pixelation, the quality just kind of like appears a little bit. So, I mean, guys, I don't have an absolute conclusion here on what, obviously, like I'm sitting here trying to figure it out myself, but a great point in the chat that this is all reasonable doubt. So, yeah, call the 911 caller back in. We want Cheeseboro back. Your name sounds innocent, but uh, and then, okay, so let me get back. I miss Nick. I do have this set up to head up on over there after this is done. Big shout out again to STS for all the love today. FFS, Nick Starro, I feel like you're about to be streaming or already are, so I must have missed Nick. Gonna have to go say hi to him over on his show. But he said, Miss Love is back on the prosecutor's table, and immediately, all witnesses are taking twice the time that they should. And it's like a thing when she wears the half moon earrings. That's gonna be a day. Chloe Albert's Revenge says, it's a dumb question. If you recall, he's never recovered a murder weapon. And he's been doing that. He's the homicide detective, and he's been doing this since murder weapons were muskets. Yeah, that's the thing. Doesn't give me good confidence. And I felt really sad and mad at the same time because it's like they didn't try to investigate this at all. And this is your homicide detective guy. We heard similar issues with Rodalius Ryan and Blaylock with the Jamari Holmes shooting. And, maybe the theory he comes up with, maybe he gets it right once in a while. But if you're just operating on a theory, it sounds like fan fiction and you're finding suspects to fit the storyline. And that's not good. And I don't think that that's good for the victims. But thanks for the comedic relief, Chloe. Leah's dad says, this is terrible evidence, but especially so when you have jurors tapping to wrap it up. Like, come on, wrap it up. And then you've got this guy going on and on, Hylton replaying the videos just so we can get the timestamps the second time around on the stuff that has timestamps. Casey Dog, right there with you. This reasonable doubt. Reasonable doubt. Chloe Albert's Revenge. You guys were hilarious in the chat with him saying cool. You guys were all about that with Max Schardt. I also love any recross? Nah. But Chloe says Max is cool. Is so much cooler than Hylton's. Sure. KC Dog says, didn't the ME say it was in his pocket? I think you're talking about the phone. I think that was clarified because she just couldn't place the placard, the evidence marker, in the right position. So she was explaining that she couldn't. Well, or did she say she took it out of his pocket? I remember the one officer said, it was plugged in the USB, but I don't know if it was plugged into the car side, like the cigarette lighter. Yeah, I think this is a whole mess. Yes, exactly this. The detective didn't detect anything. So I don't know. I have some questions about the timing, and again, this isn't the end of this incident, right? I think we have so much more pieces that we're going to be able to hear from the state and then hear pulled apart maybe on cross-examination by the defense attorneys when we have the Viverito come up on the stand. So, and we have to wait till Tuesday to hear that. Chloe Albert's Revenge, I loved this. Chloe Albert's Revenge says, "Hey, Cowboy Santa, are you getting redder or jollier? You tell me." He was getting worked up a little bit, red in the face, stammering over his words, sounding like me a little bit when I start to trip up trying to pronounce things. But only after cross-examination, certain lines of questioning. So, how about that? Chloe also says, "Mr. Schardt, this is too much. He's used to opium or peyote with the Indians." So, I'm not a Western, I don't know Western movies, but you guys said he looked like somebody last time he was on the stand. And I can picture it, right? Like, I don't know Westerns, I don't know the actors, but I can picture him right up in one of those movies. I don't know if the chat's got an assist. Ike is saying, "I've seen lots of gunfire in infrared, don't ask. And there's usually sparks, kind of unavoidable. Watch this 10 times. Am I missing it? I don't see anything." And Schardt asked about it. Schardt asked about the muzzle flash. So where is it? Where's the gunshot residue? Where's the muzzle flash? There's an issue, we don't see it. There's also no gunshot residue. And the biggest problem for me, guys, is the state's own harping on the same outfit. Haha, he's in the same outfit that he wore on the day of the murder, so that's how we identified him. Or he's just wearing the same thing because it's a hoodie and a hat, and you can like wear that multiple days. You might not wash a hoodie every time you wear it. A hat, you might not wash a hat, put it in the laundry basket when you're done wearing it for one day, and then not wear it again for another week. You could wear it every single day. Hello? So it's not like he was wearing the exact same drawers. He didn't change them. That's weird. It's not really that weird, if you ask me. But if there was gunshot residue in this car where he fired it, and he didn't change his clothes, I mean, he gets back in the car after maybe he washed the car, and he doesn't get gunshot residue transferred back into the car. And I don't know how that all works, but they haven't explained to me that that's not possible. And we actually have testimony that it's very easy to get a false positive. So there you go. Jeff Bridges, okay. Yeah, I don't know. I'm so bad with my, like, movies and actor names. So shout out to the chat for the assist on that here. Thank you so much to Adventures of Nim. I rely on you guys a lot. KC Dog also says he needs to take his pills and get back to the mall. The Santa jokes. And it's crazy because there was like some Santa in a kind way when he first took the stand. And then when he started to shift, after he shifted on cross-examination, it became like bad Santa, right? At first it was like, oh, he's kind of Santa-y. And now he's like, uh-oh, naughty Santa. Chloe Albert's Revenge says, yeah, 100%. His Jen McCabeosis is flaring up again. Yeah. I think that's a good comparison. Muckduck Inc. says a vehicle's four-way hazards are designed to come on automatically if particular sensors are triggered within the vehicle. Something simple as the sound of glass breaking or even a gunshot can trigger it. Oh, is this the case for even older vehicles? I mean, that kind of looked like an older Taurus. When they showed like the inside, the cup holders, the door handle, the lever to get out. Is that something that's always been a thing? Because that's interesting. And it's interesting that, you know, they haven't kind of asked somebody about that. In your experience, do you know if hazards can come on for that? So this was a Taurus that Drinks was in. So the red car. And also, Amber, I don't know if they tested his clothes for residue, but it sure seems like Schardt is aware that either somebody at GBI, I think he said GBI, are you aware that somebody tested it? Did you look at the results? And we had Stumpy McStumperton here kind of like have a silent answer at first. He didn't really have a response. He said he didn't know. And it almost sounded like his true answer was, I don't know. but he tried to just say no to blur his answer. Like, I'm not really lying because I'm going to say no, because I'm really acting like I'm saying I don't know, but the jury will hear no, as if I know that that didn't happen. And Schardt very skillfully corrected. So you don't know. Clarifying that he didn't say no, that testing never happened, but that I'm the lead investigator and no, I don't know if we ever tested that thing. So he did a good job cleaning that up. And I think that was a very shifty move. I think that was an intelligent, an intentional, muttered, try to muddy up for the jury type of answer. Oh, where am I? Are you behind, Pluto? Am I still in the way of something important? I think you're in the past, Pluto, but when you join us, sorry. Sorry about my face. Oh, it was a Versa, not a Toro, whatever. Guys, I'm so bad with cars. And yeah, I really think, you know, that third the third car, and it would kind of line up. It would line up with when, after we see Stillwell speed away, and the car that's behind him, we still see some activity with Drinks' car, with the lights. So, and again, reasonable doubt, right? Ms. Nikki says, sidebar, who is Diamante Kendrick alleged to have conspired to have unalived? I can't tell from the indictment. So he is stuck with the Donovan Thomas. And then they also have him, the night with Martinez Arnold with Duke after the Magic City thing, they're treating it like they conspired to get their guns together, hop in the car, and go out hunting for Shell Kell and get their get back. Right? That's the state's theory of what was going on that night. I think they kind of like jumbled getting into that very much because of Dennis getting booted off the stand and then Underwood trying to talk about lyrics. I think they just never really got back into the meat and potatoes of that. So, but there's that. Really, most significantly, Donovan Thomas. That's like the centerpiece of the state's case. Dave911 says, YouTube kept hiding your channel from me. Oh, so I bought a stream deck and have my own cat button. You have a cat button? That is cool. I didn't know Stream Deck. I guess you can like make the buttons do anything, right? I know most people use it for like pauses, plays, rewind, sound effects. You have a cat button. I love that. That is so awesome. Good to see you. Hope you're doing well. And now let me go shopping for a Stream Deck later. We can get the Mike. Guess what day it is as a first Stream Deck sound effect for every Wednesday. And again, thank you Factual Lie for the ping. I don't have a way to make it make sense. This possible license. I mean, I don't know. I'm sure we'll find out if so. Dominic Motley, or maybe it's Dominique, says 3 cars that pulled up on Drinks. Drinks could have whipped out, so they run the light. And yeah, right. And we have that. Certain things I feel like would stick out in the jury's mind. I mean, when I heard that he had his hand down the band, like the waistband of his pants, you know, it's a little bit, it makes me laugh. It makes me think of like the sitting on the couch meme. But then it also got me thinking like reaching for a weapon or whatever. So what if this is the storyline? Drinks could have whipped it out, whipped out a firearm. So they run the red light and the car 3 could be the shooter when that U-turn was made. There's not enough information to tell. And they didn't look at his phone. Or they say they didn't look at his phone. I'm assuming they didn't look at his phone because I think the defense would have had something that they had a warrant in place to get that phone. It's, to me, I think they didn't look at that phone. Nobody that went on the scene thought, hey, maybe we should look at this. So. Chloe Albert's Revenge says, Versa, Fusion, who the heck is committing crimes in these cars? That's the first clue to me that there's more to the story. But I know he's used to the horse and buggy, so bless his heart. Yes, I personally think that people will do stupid things. People will do things in ways that are obvious, use their credit card to buy things that end up incriminating them later, putting them at a location at a certain time. I really do think people do stupid things. But here, the state is alleging that this was a planned event, and that it's going to take work and steps for me to get there beyond a reasonable doubt. If they planned this, like, I'm not even sure it's clear, and I'm happy that we have the facts not an evidence objection from Schardt. It's still not 100% clear. It's been the implication by the state that Stillwell put tint on the windows. And Schardt is getting ahead and trying to offer an explanation why somebody might do that. But at the same time, he said facts not an evidence when Hylton tried to ask if Stillwell put tint on the windows. So I think we'll see with Viverito. Viverito was asking him, did you put tint on this car? Maybe some type of questioning there. And that will clear it up. And it could have just been facts not an evidence quite yet. But at the same time, remember, the Alamo lady was like, well, we don't add tint to our vehicles when we get them. She didn't say that we don't receive vehicles or order vehicles or add vehicles to our fleet that have tint already. We reject those. So there's still some questions up in the air that aren't really sticking, that the state just wants to assume as matching their story. So lots of big questions here. And again, it wouldn't be the first time I'd hear of someone treating a rental car like something more permanent. So let's see. A Skywalker says, what if shooter got out of the car and then walked away, hence no residue in car, shadowy figure walking? So you mean shooter gets out of the car, like presumably, and then does the shooting while they're walking, so there wouldn't be residue in the car in any case. Well, the state hasn't pointed out anybody walking. The investigators haven't talked about anybody walking. The defense didn't point it out. So at the end of the day, as of right now, this would just be the jury sitting here like us, like, are these people just walking? Do they have anything to do with this? They didn't report that there were shots being fired. They just kept it moving. You know, nobody's really addressed the walking persons on the record. And that's the thing, too, who opened the door? So there could be an issue with a tainted scene. Right? What if someone that was walking, just randomly, sees the car stop there and let me go and, why are they stopped here? Let me go open the door and take the change out of their cup holder or something. You know? We don't know. We don't know. Positive Q says, what if the car that made the U-turn shot him? When he saw him at the light, he could have made a U-turn and left. Doctor's not sure if he expired immediately. And I'm going to go back and rewatch the medical examiner, that little bit where she does seem that he would be mobilized instantaneously, wouldn't be able to move his limbs, but then you see the lights. So if that's the case, if I trust the medical examiner that instantaneously can't use my limbs, there's some stuff that happens after Stillwell drives away. And it was Schardt that elicited that confirmation from the medical examiner. So I feel like Schardt did that because the answer is helpful to his client. He's already gone. That other car that pulled up is kind of like scooted up in that space. And then the car does its blinky blink thing. According to the medical examiner, is there room for that to happen if Shannon Stillwell was the shooter and he'd already pulled off? But to be honest, that part, I don't really think Schardt gave us that second-by-second play-by-play. And it could be something he discusses with Viverito. It might not be the last of it. But yeah. So I don't know. A lot of questions here. Like every day, right? KC Dog says they would have been better off not bringing in the video. Now the problem is if Schardt thinks that this helps him, he would have brought it in anyway. So it's, at that point, the state probably thinks it helps them. I'm sure they do. They have their storyline to it. So I do think that they think it helps them. But even if they thought maybe, they could still try to bring it in and explain it to get ahead of the defense. And what's really interesting, you guys, I mentioned it in the chat, but since this is a shorter trial, we've got 2 co-defendants. Previously, I said, wow, it's going to be so long until the defense gets to put on their own cases in chief and bring up their witnesses that would discuss and maybe dispel some of the things that we're hearing from those that the state is putting on the stand. Well, now this narrow point in time, especially this Shymel Drinks incident, which is the presentation of that has started like right now. That's very close in time to when Schardt will be presenting his case in chief and able to call his own witnesses. So that shifts things a little bit. By the time you're actually rebutting something, I think it'll have more of a slapback effect, right? Because it'll only be about a week and a half, 2 weeks after the state just had witnesses on the stand to tell us the opposite. So interesting shift here in the whole trial. Faith Over Fear says, red car brake lights flashed after third car. That's the thing, right? To me, like, I think Schardt is using the medical examiner's instantaneous immobilization in his favor because he's aware that those lights flash after his client pulls away, right? Because it's a pretty big, to me, it's pretty significant that he's not even trying to downplay that the Audi is Shannon Stillwell and that Shannon Stillwell is driving it. I mean, he gets right up there and says all that. It makes half of the stuff that Hylton's doing irrelevant. I don't know if Schardt maybe called an audible and changed strategy in the middle of all that, which is really impressive if he did. But at the same time, otherwise, if Schardt wasn't going to fight that concept that, hey, that's Stillwell driving in this car at this moment, all of that lead up was pretty wasteful. Right? Great. We can see who gets in the car. We understand that there's passengers, who's driving. You're establishing that. I don't think they needed to replay everything twice, the state. But yeah, I think that medical examiner, I think Schardt is leaning into that. Yeah, I wonder how many times Max watched that video. Probably as many times as the state watched that 17-second video of Jeffrey Williams talking about snitches. Oh, man. And then also, where is the statement from Barter? Right, who is Barter? Who is Barter? And is there somebody, like, have we heard of somebody Carter in this case mentioned? Because I'm assuming Barter is someone switching the B for the C. Although maybe that wouldn't be the case if they're supposed to be ops or whatever. Maybe their nickname really is Barter or their name is Barter with a B. But who is Barter? Who is Barter? Oh, and Chloe, I love this with the all caps, says, real riddled Hylton, not one bullet. Don't object. Learn something. Yep. And I think it really sucks at certain moments like that, the jury isn't hearing. A lot of the really crappy representations in this trial have been outside of the presence of the jury, right? And there's still some that have been made in front of the jury. All right, wait, what video are we watching? Which video? I am also, and this is a bit of an aside, but guys, I do recommend watching day 117 again. I had clipped the part out where Schardt is talking about, where was that? Where Schardt is talking about these evidentiary issues that are going to be coming up for Shymel Drinks back on day 117. Okay, the FedEx video. No, I know the context of like Barter, you know, they were there. We had the testimony from Miss Williams earlier today. But like, where is he in this story? What role did he play? Where is he in this investigation? Right? Especially since we have a different suspect initially. Christian whatever. Christian Johnson. So I don't know. What car did he drive? Going back to the FedEx one. I think I was close to it, right? Yeah, okay. Because we had just rewatched it.
That's that's red Versa pulling up, correct?
Yes, sir.
Okay, and that would be the white Audi.
Yes.
And that would be the white Fusion pulling up on the right lane, correct?
That's correct.
That's not the car that makes the U-turn, is it?
No, sir, I don't believe so.
Okay. And Mr. Stillwell is now running the light. He's no longer there, correct?
That's correct.
Okay. We see now this car pulls up.
And the lights are right
It
there.
makes an interesting U-turn, correct?
Yes, sir.
And your determination is maybe they did that because they may have seen or heard something, correct?
Maybe.
Okay. I have no further questions. Thank you.
Yeah, I think there's like so much going on in this little surveillance footage. And I think it's hilarious that we have this. This has to be one of those like, please lock your vehicles. We're not responsible for like things that go missing from your car while you're parked at work or something like that. Because there's a key here. So there's just so much going on here. Yeah, we see the people walking, but I don't think it's clear that they have anything to do with anything. And again, it's not clear that they don't have something to do with anything. But yeah, I think Schardt, I think it's really important, Schardt. That's where I'm going to leave this. The number one thing I can conclusively say, I've come to the conclusion for myself, that I think it's important that Max Schardt had the medical examiner say, immediately immobilized. Can't move. But something's moving in that car. Something happens in that car after Stillwell's gone. So that's all I've got there. That's what I've got. And to me, that's if that's what the medical examiner says, state didn't challenge that. It's a pretty big deal. It's a pretty big deal. Dennis says it seems like everything or everyone the state puts up is not helping their case. Right, and I don't know how to find out who a Barter / maybe Barter is this Christian Johnson person, if they're the same person. But like, it was enough for somebody to think they were a suspect on March 15th. So what changed that? What changed that? And this was the fingerprinting, because we had Davis on the stand yesterday. This is the fingerprinting we heard about. And everyone's like, Christian Johnson? Who's Christian Johnson? So they lifted the fingerprints and get this report. And they say he's not eliminated as a suspect. Checked him as a suspect here. So, I don't know. I think it's just because there's a fingerprint there over on the passenger side, the window frame, because that's all we've got as a description here. This is like an image that's cut off here. So it could have gotten there because we were hanging out and I leaned, I closed the door and got my fingerprint there, and I wasn't doing anything weird. It was earlier in the day. It had nothing to do with this. But at the same time, who knows? Who knows? All right, guys. We can rewind one more time on this video. I personally don't think I'm gonna extract more out of this, except more speculation. Oh, sorry, I didn't share it.
Made a U-turn.
Yes.
Hold on. Come on, video. Yeah, it really does feel
Correct?
like hunting Sasquatch.
Yes,
It's
I
because of
did.
the quality
and
of
the
the
reason you say that
video.
is because that person driving that car abruptly made a U-turn.
Yes.
Okay.
I'm ready when you are. It's not ready.
Oh, I'm sorry. If we could go to 101:20, yeah, just. That's that's red Versa pulling up, correct?
Yes, sir.
Okay, and that would be the white Audi.
Yes.
And that would be the white Fusion pulling up on the right lane, correct?
That's correct.
That's not the car that makes the U-turn, is it?
No, sir, I don't believe so.
Okay. And Mr. Stillwell is now running the light. He's no longer there, correct?
That's correct.
Okay. We see. Now this car pulls up and makes that interesting U-turn, correct?
Yes, sir.
And your determination is maybe they did that because they might have seen or heard something, correct?
Maybe.
Okay. I have no further questions. Thank you.
And Ms. Weinstein.
Yeah, and I do think that that car turning around would have seen whatever that car that pulled up after Stillwell pulled off. Like, if they saw anything and were turning around, it would have been because of the third car that pulls up, the third whitish car. So, yeah, this seems like someone on a prowl. Somebody that had marked somebody, maybe. Somebody that just drives stupid and speeds up behind somebody, right? It could be either. But also, yeah, shout out to, right, Joshua Johnson. Josh Johnson. Does it go by Joshua or Josh? Did a skit on the YSL trial, the longest trial. I'll link to that. Think you guys will enjoy it. Was just a video? Yeah, okay. Video not alive. There we go. So Josh Johnson, YSL skit there for you. And Nick, this is going to be spilling over into a redirect with Nick. So he does recaps. He speeds through a lot of the breaks, but you can get his thoughts, rewatch things, or if you were late, you can catch stuff that you missed over there. Bye, Franz. I always call you Biff, and everyone calls you Bye, Franz, but I always call you Biff. Yeah, it's hard to see them. They just like come into the frame randomly because I think the one on the one side, it's too dark to see them, and then they walk into the light, so then you can see them. And then further down the video, the quality is just, it's too far away. It's hard to tell where they actually pop into view. So get those eyes checked, eat some carrots. But yeah, with that, guys, this will spill over as a redirect into Nick Staro's stream. No court tomorrow, you guys. So have a productive day. Have a good day. I'll be on X sharing anything important that happens. And then Friday at 9 a.m. Eastern, court's back up for a non-jury day. No court on Monday. Jury will be back on Tuesday. So that's what we've got. Big thank you again to all the love today. Holy moly, we had 177 new members. My banner is way off. So congrats to all the new slimes. Welcome aboard. Welcome to the Cat Not Williams Rico gang. Get that up there. Everybody take care. Oh yes, and Club Classy. Thank you, staff. Club Classy tonight at 8 p.m. 2 hours away. So come hang out over there. I referenced the song earlier when they said squabble. I think Schardt said something about they weren't squabbling in the gas station, right? They looked like they were having fun. There's a song that's really catchy that they play over at Club Classy called I Squabble. It was a good time. So come over there, maybe you'll hear it. You guys all have a good night. Let me know if you come up with any more theories about what's going on in this video. Because to me, it looks like the third car could be the sketchy car. So with that being said, you guys take care, be well, see you on Friday.